Good morning, good morning, good morning. I missed you guys. How is everyone? Let's separate these tabs. Here we go. Let's separate. Pause that. How is everyone? I'm about to watch Big Crazy today. They are still, I'll let you guys see, we are still deliberating for Miss Judy Church. There has been, there has been, watch this, feel like it's like super high or something. Okay, there we go. No questions, no nothing. They just, I guess, back there hammering away at it. Okay, so we have, let's see. Nothing. Nothing going on there. Nothing going on there. So we have that up and live so we can continue to see what happens when. So what we're going to do in the halftime is in the meantime is go ahead and watch this hour and a half, 2 hours of Shanda Vander Ark on this dang on stand. Oh, thank you, friend. Listen, y'all know now. See, hey Nicole. Y'all know sometimes what all we got on this calendar. I did update the calendar. I was getting stuff done. I was watching stuff. And the sad part about it, hey Chaz, how is the planning going? I know he's deployed. I've been praying for your family. Your family came across my mind. You and another family. And I started to reach out, but it was late. But I know your baby is deployed. So just know that you have been on my heart and mind. And anybody else whose family I may not know is deployed, enlisted, what have you, we thinking about you, okay? Because I know that also my best friend who is a veteran, Bestie, there's a certain time after she left that if any stateside national emergency happens, like up in the like Ohio, New York, Indiana, like up in those states, she could be called back. So it's a scary time right now. Hey everybody. Hello. So few things. I got like 4 messages from folks I know. Like got a lot of messages, but like 4 from y'all, okay, from the family, about Alicia Andrews. Now, they have filed another motion on behalf of Alicia Andrews, and I think it's going to go smooth through April. I'll call her back in a second. Uh-oh. Yeah, I'll call her back in a second. It's probably Tiffany and Brittany. Yeah, YouTube isn't live. We on punishment over there. Somebody said we don't be doing what we're supposed to do. Yeah, so we are live currently right now on YouTube and on Twitch. Hello, where there are subscriptions over there. Now, so if you did not get a refund for your subscription, request one. Hey Hannah, so there is, where did I pull it up at? The new motion is a motion for a new trial and a judgment. Is a motion for basically to throw everything out. Okay, they saying like, okay, the judge was already biased, so throw out everything she didn't touch. And so I believe there is, you said Twitch is where it's at. I like it. But there is, I believe there's like somebody had, I think the state has till like April 3rd to, is it April 3rd? Something like that to respond. And then the state can go respond back, or the defense can respond back to the state by April 10th. It's going to go smooth, probably past the next Julio trial, because that's supposed to start April 13th. Yeah, that's supposed to start April 13th. depending, because I got to watch that last motions hearing. So I saw one expert, but not the second expert. And Laura, I'm not going to lie. I thought I was losing my marbles, but now I don't feel so bad because what the experts were saying were not landing. And I felt like stuff was traveling to my brain by boat. And when I get like that, I need to just sit still like a little kid and sit on my hands and not do nothing else and focus and pay attention. Now I don't feel bad because it seems like that defense came off the same way to everybody else. So I wanted to rewatch those experts. However, so what I was going to do is rewatch the defense for Judy Church from day 7 and then turn around and what? I wonder why. While I'm waiting on a verdict, but I also wanted to watch Shanda Vander Ark, and I also wanted to see what happened with trying to sever one of the Murphys. Do I feel like, okay, I'll say this. Do I feel like Alicia Andrews gets a new trial? So this is okay. I'll tell y'all what they're the grounds for this particular. So the grounds is like the defense is arguing that the manslaughter verdict that she got was contrary to the law and the weight of evidence. Hold that. Contrary to the law and the weight of evidence. And since the jury acquitted her of the more serious meant to do it as charges like first degree and conspiracy, they're saying that basically everything that was put out there says she meant to do it, she knew what she was doing and she was going to do it, and the manslaughter don't quite say that, so it don't fit. Hold. Okay. Do I think the defense is correct? Yes, I do. Because I don't feel like manslaughter fit. Because again, this is my personal opinion. I am not a lawyer. Shout out to the other male. In order for me to feel like manslaughter fit for me and only me, it would make me have to feel that what them boys did to that boy was manslaughter. And I at no point in time do I feel like that was manslaughter. I do feel like Alicia may have saved her own hide, and I know other people are going to say, no, I did this, no, we did this, no, this was happening. But ultimately, for me, Alicia is the one who got up on that stand and had to give a life-saving performance. Not saying it wasn't true or it was true, but I think that getting on that stand humanized Alicia to a point where the jury was not able to say, I don't think she wanted that to happen. I don't think she knew that was going to happen, but she also did not remove herself from the situation. She also did not act like I think it was more so her behavior after it happened that caused her to get a guilty, right? Not saying what that child's intent was when she went, because at the same time, I can see it two different ways. I can see it from both sides because I can say that I've been a fool. And most times when you hang with a fool, you end up more so with his friends more than he with you and yours, right? When you're young and dumb like that. And yes, we've all been young and dumb, okay? So you can end up in a situation thinking you cute and you just riding with him and you sitting passenger side and your hair blowing in the wind and the drop top down and the music loud. You can end up in a situation like, wait, he was what? He was who? Because you riding, right? But then that makes you just as culpable. And we all know that ignorance of the law is no excuse. So therefore, she could have ended up in the right place at the wrong time every single time. However, we've all been a fool at one point, right? We've all ended up in some situations, and some of us are just absolutely, we're in a point where Sprint had just dropped the first camera phone, and didn't nobody else have it, and couldn't nobody else get a picture unless they had the same phone. So couldn't nobody document your foolishness, okay? Now, because of that, I do feel like in a way it could have been. I'm going. We going out of town. I'm going. I'm riding. I'm chilling. And you go with them. Now, could you end up around a crew of folks that you don't really know? Absolutely. Do I believe she knew the Murphys? Absolutely not. They was like 30 years old. The kids was like 17, 18. Little Rainbow was what, like 17? No. I just feel like she was following to a point, but I do feel like she got good goddamn sense. And I do believe that she has probably developed more sense afterward from the sheer fact of having that baby and the situation that she's going through right now, right? So I do feel like life has lifed, and she got some things she can't ignore anymore. Now, I think the biggest issue is after the fact, even if she humanized the fuck out of herself, okay? She made some people literally either see themselves in her or attack other folks' selves about her. It got crazy during that trial, okay? So she humanized the fuck out of herself. But when it comes down to the letter of the law, which is not human at all, right? It's black and white. When it comes down to the letter of the law, people have a hard time fitting her in there because they've seen the human, right? We've seen some of ourselves at points. We've seen other things, but then you have to kind of grapple with the human part and then where's that phone? The human part and then the text messages afterwards. The human part and then you're in jail communicating with another inmate as if y'all co-parenting and neither one of y'all got the baby. So there are some very real choices that she has made and is making that I believe made the jury make her a choice. However, I do believe they saw the human in her and they did not think that she deserved to go for life for her participation in that. However, if Isaiah Chance can be looking at the go to sleep penalty and he was right next to Alicia, because somebody could argue he didn't pull a trigger, he didn't have anything, he didn't do anything, he did everything that Alicia did. And that, I think, is the hard part. Do I think it was second degree? I don't. I think either the first degree or not guilty would have made more sense because I don't believe what happened to that boy was manslaughter. I believe it was absolute first degree, premeditated after the first premeditation didn't work. So to call it manslaughter for anybody means you could call it manslaughter for Lil Rambo, Davion, Rashad Murphy, and even on Isaiah Chance. If it can be manslaughter for her, then it can be manslaughter for Isaiah Chance, right? And we know that Isaiah Chance and Lil Rambo has some other communications going on, right? Let me start calling him Lil Rambo. Sean Gathright. So that's kind of where I am on that. I do agree with the defense. It doesn't make sense, but I don't know if I agree to the point where she should have got nothing. It kind of, they looking for me. That's why I ain't go home yet. And blah, blah, blah. Oh. So it's Lil Rambo. That grandma is going to go about him, okay? That grandma going to come with every piece of doubt. She said them was cameras and power washing equipment. Big cameras. head photographer. She looked at the bags, and that's what she saw. Well, why is that different than what they found in your truck, ma'am? Exactly, loves to me. So if Isaiah Chance is just as guilty as the people that hopped out with them catchers and sent that Tesla screaming for its life, Alicia was with him. Do I think she knew about the plot from the beginning? Do I think she was attending the team meetings and shit? No, I don't. But you knew who that was when you drove past them. You knew who that was when you got past them. And even if you didn't pay attention, you had your head down on your phone like most young people do and don't pay attention to where they're going. That's why they ain't got no sense of direction and need GPS everywhere. I think that at that point, you were absolutely, once you got out there, you heard all that. You heard that hellfire, thundering, and damnation coming down and raining down on that car. You heard it, even if you didn't see it. And then when you asked him about it, and he said he didn't know what it was, he ain't never heard of it, he didn't hear it. And then the next morning you wake up or before you go to sleep, or right when you wake up, you see on Instagram everybody saying RIP to that man, and then he passed away right where you at. And all of a sudden your weekend cut short, ma'am. You're supposed to go home to your mama. You're supposed to go home to your mama. But at the same time, I'm not going to lie to you. That's why I said I can always see it two ways, because if I'm in a car and Lil Rambo is the driver, any of the Murphys with us, and Mr. Get Out the Front Seat is sitting up here next to me, that's all I got to protect me, and they done made a point to come down here and take this man out the way that they did, what's to stop them from leaving me on the side of the road? I wouldn't have said shit till I got home. And then at that point, she's still in a hell of a situation if she do say anything. And then if she do say something while she in jail, I mean, I understand people saying she ain't getting life, but if that man slizzy stick, 15 ain't no short time. So at this point, it could be a way of survival, a way of protection for her family, protection for herself, protection, a hedge of protection for her son, for her child. It could be a lot being attached to those people in that situation in the way that she's attached. So at some point, it may be safer for her not to say anything. It may be safer for her to talk to this fool. I just don't know. Come on, Love Me Smith. Listen, let me tell you something. If I'm anywhere near Lil Rambo and I know he in the vicinity, I'd have been running from that Impala like everybody else. The way them people knew that Impala they knew that Lil Rambo. You know what I mean? And I'm not, no, I don't have nothing to say. I didn't see nothing. I'm Helen Keller. I didn't hear nothing. I didn't see nothing. Get me to my mama. Take me home. Take me home. Like, so I don't really think she can. Baby, the way them two random people, and I know they didn't have nothing to do with nothing, but the way them two random people showed up in that courtroom the day she testified, never mind. Never mind. Oh, I'm gonna make a video about this, but I don't want to make a video about it yet. But I'm gonna make a video about that because remember, I had a video where I was dancing around the slime, right? The song, and then I said while there was a plea taken and there are no more trials, we'll never be done with YSL, right? We'll never be done with YSL. The decades and decades and decades that these men have on probation, like they literally could have a grandchild today and be jaywalking trying to get to that grandchild's high school graduation and end up with a probation officer that's currently in kindergarten with them. It's so long and so many twists and turns. Now, there's been a couple of things that have happened. We just have not spoke on them. But there may be somebody on some fugitive shit. Somebody may have been running from a warrant for quite a while. That's going to come out. And then, of course, we saw it was in Miami and at the Drewski thing this weekend. There was some words exchanged between somebody in Thug's camp and somebody and Charleston White, in which case Thug may have added his 2 cents. Allegedly, we don't know. And somebody, according to Charleston White, somebody with a protective tool on them may have clutched it or said something to him. Now Thug is still an entertainer. Young Thug, King Slime, Jeffrey Williams, he is still a entertainer. So to an extent, he's still going to have armed security around him. So I just pray that it was the armed, licensed security that was protecting him and not that he keeping the wrong company again. I pray. Uh-oh. Hi. Good morning. Good morning to you. Oh, you got some more shorts on? Yeah, we got to get that. I'm going to wash that stuff off of that other car seat. Okay. As soon as I get court started. Come on. Look at you. Oh! Want to say hi? Say hi. What you doing? Slobber box. Hi, honey. What you about to go work?
Yeah. Okay. I gotta go talk to the dude that I go selling guns to.
Yeah, I'm live. Oh. Jesus. Yeah, if he said that, I think that, to be honest, if I saw Charleston White anywhere near me and I was on any kind of probation, I would have gone the other way. Open the plane so I can sit down. Get me out of here. I would have gone to the bathroom. I'm not, because we know Charleston White knows exactly what to say. And when I watched that video that was sent to me where he was saying, it was my belief that he was in possession of a popper, that it was my belief that he was going to do some harm to me. That's all it has to be. He knows exactly what he's saying. We ain't gonna tell his business. He our fam too. He a fool. What he is. Especially after how him and Woody went at it, I would not be nowhere near him. So I just think it just turned a really nice weekend into a really ugly thing, and I think it's going to cause some issues for a second. And the fact that there are other issues going on with other people that are supposed to be in that trial, I just feel like they all about to end up like back to back in front of the page. And well, one thing we know, Brian Steele ain't gonna never be short on work. Golly.
You too grown for me. Just straight face.
He trying to get to that. That's my one. So that's my favorite one.
What sugar one?
I know. All right, y'all. Mr. Steele been working. You got a phone?
Yeah, you got a phone though. Or you want your milk?
Yeah, I'm good. I don't need nothing. See, I'm trying to make anything. Say, I'll holler when I want it. I already know you're trying to get that keyboard. That's the one he like.
You like colorful?
Big Uncle don't wear no turtleneck. He be acting like he about to choke. Yeah, Fonnie gonna definitely work with Charleston White for anything, but we do know that Thug had 40 years? 20 years or 40 years on the back end if he didn't finish his probation successfully. So I like little turtlenecks, mock necks. I don't know what it is. Hi, honey. What you looking for? You don't want that. All right, y'all. So what we're going to do, we're going to go ahead and get into Miss Shanda Vander Ark. Let me see.
You got any cups here?
Uh-huh. But it's over on the other, your uncle switched on the other side. Mm-hmm.
Bye.
See ya.
See you around 1:32.
Yeah.
You said 3, right?
Yeah, I'm gonna have to go pick up Dallas since Big on call. All right, be
Thank
careful. You're welcome. All right, come on, baby. We gotta watch this fool. She looked like that oldest son right there, don't she? She looked just like her oldest son right there. Ooh, she looked just like her oldest son. My baby baby. Hi, little one. Where you going? Where you going? Come on. You gonna make me have to put my bonnet on because by the time you leave, I ain't gonna have no edges. Huh. You're not getting my phone, buddy. You ain't chewing on none of my remotes. Hi. What happened? She looks just like Paul, man. No, technically this is the second day, but same hearing because she cut a fool by the headache at the last hearing, and so they did everything but her testimony.
All rise. Court resumed. Morning. Please be seated. Before the court is filed 2023-110 FC, State of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark? All right, Ms. Vander Ark appears before the court with her attorney, Mr. Ronald Ambrose. Ms. Lindquist is here on behalf of the State of Michigan. Setting time for continuation of the
Great.
hearing
Bonus.
of defendants defendant's motion for a new trial. I believe we are at the point where Ms. Vander Ark was going to testify. Is that correct, Mr. Andrews?
It is.
Okay, is that your understanding, Ms. Bloomquist?
That is, Your Honor. At the last hearing, we took some of my witnesses out of order so that we could just kind of get something done on the record. I believe it was November 25th.
Okay, all right, Mr. Andrews, you can go ahead and call your first witness.
Yes, Shanda Vander Ark.
All right, Ms. Vander Ark, if you want to come right around here. Please remain standing and raise your right hand.
Everything but your ass, because you wanted to play. Oh, she looked like Paul with some boneless bread.
Please state your name for the record, spelling your first name and last name.
Shanda Vander Ark, SHANDA space capital ARK.
Okay, go ahead, Mr. Andrews.
And Ms. Vander Ark, you are the defendant in this case, is that correct?
Yes, sir.
And your attorney at the trial court level was who?
Fred Johnson.
Fred Johnson. And when did you first meet with Fred Johnson?
About the case the day after, 2 days after I was arrested.
Okay. And can you tell the court what your conversations were with Mr. Johnson?
That first day, we just kind of talked in general. We said from day one that I was going to have to testify. So we talked about that. He talked about he was putting together a team to work on it. And I remember one thing of all the weird things to remember. He asked me what my favorite TV show was, and he was going to have an intern watch it and then come in and tell me about it every week just to have that time. But there wasn't a whole lot of specifics that day. We were just talking. He asked about my mental health. And
was there any a point in time that you ever conceded your guilt in this case?
never.
Did you always relay to Mr. Johnson that you were not guilty?
Yes.
Right. Have you ever been charged with anything?
No. I've never even gotten a parking ticket.
So
And what that mean?
You have testified in this case, correct?
Yes, sir.
Prior to testifying in this case, had you ever testified before?
Yes, sir. When I was a kid.
Or how old were you?
Oh gosh, from age 8 up through, I think about 16 was the last time my biological father tried to get visitation or custody of us.
Okay. Was being charged in this
Already
case,
convicted in certain ways.
can you describe your
Have a good.
mental health during, immediately after being charged?
Oh, horrible. I couldn't eat. I couldn't sleep. I actually didn't eat for 18 days after I got to Muskegon County Jail.
Honey, you would have been gone.
It was, I didn't know which way was up.
Just as a bit of a background, you, when did you move to Michigan?
Oh gosh. 2015, I think.
Okay, and
My little guy was like 6 months old.
okay, so you, it was, who moved to Michigan with you?
It was my late husband, Adam, and little man, and myself. That was it.
Okay, and at some point, Paul comes to Michigan?
Yes.
So
Do you
there
recall when that
is
was?
He had just turned 18 and graduated high school, so that was 2020. It was in the middle of COVID.
Okay, and sometime after that, Timothy arrives.
A year later.
Do you remember the month?
I want to say it was the end of May because school had let out.
May of 2021.
Yes, sir.
And I think during your testimony in this trial, he came with like a bag of medications.
A gallon-sized Ziploc bag, yeah.
All right. What were the medications for?
Well, he was diagnosed ADHD, sensory processing disorder, bipolar, and on the autism spectrum, but he was very high functioning. And so that was, he had, I don't remember the name of any of them really, but there was one that made him like a zombie that he took twice a day. And I mean, I think there was probably 8 or 9 medications per day that he was taking.
Why did he move to Michigan?
I got a text from his dad one day that he could no longer deal with him. that Timothy was pushing his buttons. If he did not come to live with me, my ex was going to put his hands on him
And so in May.
and asked me to take him. Yes, I took him.
From May and when he first arrived, what was his behavior like?
I mean, he was about to turn 15 when we got him, so he was a teenager, but nothing outlandish. I mean, he was trying. He did not care to tell the truth hardly at all. There's no point in asking him a question pretty much the whole time. But you know, he would do stuff. He took my youngest toys at times. He broke a couple of them, and then he took some stuff from Paul. But like, it was just typical teenage. It wasn't anything that we couldn't handle. So.
In January of 2022, a significant event happens.
My late husband Adam had a stroke January 3rd of 2022.
Okay.
A massive stroke.
And how did that impact the house?
Better question is probably how didn't it? I lost his income. I was already the primary breadwinner, but then I'm the sole breadwinner. We had a babysitting schedule worked out for the little guy, and with Paul and Timothy, at that point we didn't leave Timothy alone with the little one, really. And you know, I was working full time. I was gone because of the location I worked and driving over there and driving back. I was gone from the house 12 hours a day, 5 days a week. So everything just fell apart. You know, I wasn't paying bills on time. I was barely surviving.
Was Timothy being watched by your late husband prior to January?
Yes, yeah, him and the little guy. And Paul.
I think you mentioned there in your direct testimony, this was around Mother's Day of 2022. Timothy was about 104 pounds.
Mm-hmm.
Is that a yes?
Yes.
And you knew that because he picked up the dog.
He weighed the dog. I could no longer lift. It was a Great Dane puppy that was 6 months old at the time. And the dog weighed 102 pounds. There was no way I could lift that dog.
Okay.
And so he got on the scale, weighed himself, grabbed the dog, got on the scale.
What happens from that day until July 6, 2022?
I mean, from what little I remember, it was the same thing that had started when the stroke happened. Timothy, I remember a couple times, he flat out told me, he said, I'm going to keep doing stuff until you just let me do what I want. And I said, that's not happening. And it just snowballed. I don't remember a peaceful moment after the stroke for one reason or another. And that's not all on him. I mean, it was just in general, but he certainly created a lot.
What do you think? It would fall on him?
He dies on
Ma'am.
July 6, 2022, correct?
A month before 16.
When are you arrested?
July 7th.
And are you immediately taken to the Muskegon County Jail?
You mean on the 7th?
Yes.
Yes, from the North Shores Police Department.
Okay. What were your conditions like in the Macomb County Jail or Muskegon County Jail?
It was awful. I was on max security solely because of my charges, so I was isolated completely by myself in a room.
When you say max security, what was it like?
You're in a room by yourself. You only have the option of getting out
Did you have
of the room in
alarm?
1 hour a day, so you're locked down 23 hours a day. For me, I was in such bad shape. I couldn't eat. I barely slept. I mean, the whole 17 and a half months there, I might have averaged an hour or two of sleep a night. And there was no mental health treatment. I mean, they tried a couple of meds, but they did nothing. And I kept asking to speak with the doctor because it was always a social worker. And she said, oh, you're on the waiting list. And I guess the waiting list was longer than 17 and a half months. But I met with her a few times and she was no help at all. She'd say, oh, I'll meet with you once a week or I'll meet with you once a month. And that never happened.
So it wasn't because of anything that you did, it was just the nature of your charges that they put you in max?
That's the only reason, yes.
how often, well, did you have mental health issues prior to that?
I have severe ADHD and I have sensory processing disorder, and a little bit of OCD. I guess it was a month after I got to Huron Valley, I was diagnosed bipolar, which I've had my whole life, I guess, and didn't know it. But at the time, I just knew about the ADHD and the sensory processing.
How often during this time period would you see Mr. Johnson? From the time that you're incarcerated to?
I think the first month I saw him 2 or 3 times, but after that, it was every once in a blue moon. I think he said it was once every other month. It didn't even seem like that often.
During your conversations with him, were you talking trial strategy?
A little bit. We didn't a lot, but we did a little bit.
Was it ever, well, tell me what the strategy was.
Well, on the child abuse charge, it was intentionally and knowingly, and that was, without that, the felony murder charge was gone. And so that's where we focused. It was never on I didn't even realize second degree would be an option until the day of jury selection. So we focused on the intentionally and knowingly from that, because that cost the felony murder charge.
Did you know manslaughter was
He never,
an option?
we never talked about second degree or manslaughter until the day of jury selection. It was on the jury instructions for second degree. And then the last morning, when I had the breakdown, I vaguely remember him coming in and saying he got these instructions added. And I had no clue what to say. I was in bad shape, so.
Well, tell me about, I mean, you testified,
Yes.
and tell the court how you felt during your testimony.
Well, before the testimony started, and this was one of the things that really shocked me, while the medical examiner was testifying, Fred was writing down questions. He had not had any
Objection,
questions.
non-responsive.
Sustained.
How were you feeling during your testimony?
Stressed, panicked, scared, terrified.
Okay, and after, how did your testimony end on that third day of trial?
I believe they were talking about
Right.
jury questions, and I had a really bad panic attack.
Okay, and what happens after that?
Well, I had been in the room by myself in a pod.
Well, I mean, from the time that you leave the courtroom, this courtroom.
Instead of going back to the pod, I guess the sheriff had decided to put me back down in holding instead of where I had been, where there was at least people around, even though I couldn't come out to see them.
Are you okay, so you're talking about in this?
In Muskegon County Jail, yeah.
Oh, at the bill, okay.
Yeah. So he separated me completely down in holding, and
Did Mr. Johnson talk to you after that, on that third day?
No.
Okay, and what happens
Not to be put in isolation with
at the jail over the course of the night?
well, I remember right after I got back, I mean, I was upset at the whole being separated, holding, the lights don't dim, the noise level was horrible, and I was trying to think
you
through
need
the trial stuff
accommodation.
just to keep myself occupied. I had thought of some questions I wanted him to come back and try to ask me the next day, but then I don't know if I even slept for an hour that night, but I remember when I was, I don't want to say come to, when I was functioning, I was curled in a ball. I was freaking the heck out. I couldn't, when they first came to get me, I said, I can't even go. I can't leave the
all that
room.
baby was
They're
found.
like, well, you have to, come on. And it just,
How were you taken from the jail to the courthouse? Or courtroom?
well, we went to, I guess, where I changed clothes, and that's as far as I got. But we walked over there.
Okay. We heard, you were in the courtroom when we heard some testimony that you were curled up in a ball, is that accurate?
Yes.
Were you suicidal?
I don't remember saying it, but yes, apparently I made at least one comment that I was going to kill myself.
All right, I mean, sounds pretty drastic. What else do you remember from that morning?
I remember just being sheer panic. I was frozen, like I couldn't even move. I remember laying up against the wall on the floor on my side on one of the concrete benches in one of the holding rooms that they tried to come upstairs, and I couldn't do it. And so I went in there and curled up in a ball on my side. I was completely paralyzed. My brain was not working. Anytime I even thought about anything, I wanted to panic, and I had several panic attacks during that time.
Do you recall talking with Mr. Johnson during this time?
A little bit, yes, sir.
What was the nature of your conversation? Or was he talking to you, are you talking back, or what was it, how was it going?
I remember at one point he came in and said that he had fought for a while to get the involuntary manslaughter instructions put on, and I remember thinking, what's that got to do with anything? And then I specifically asked him after we tried to come upstairs, I said, look, can we please adjourn this? I can't do this today. And I asked him several times, and he made a comment. He said, oh, it'll just be the same way if we do that. You're gonna have the same issue. And then he said, well, we'll just go on without you. And then he left.
Do you recall signing this document?
No.
You've seen it since, though?
Yes, I have.
All right. Is that your signature or not?
I mean, it looks like a version of it.
Okay. But you don't recall signing?
Don't go on your time.
Is that a no?
No, sorry.
Why do you think they're gonna be more comfortable? We want people with that
Did
maybe
you
really comfortable in that
did
car.
any-
Come on now.
Medical personnel come to talk to you when you were in your condition?
No, sir.
When you were testifying on that third day, did you ever concede that you were guilty of anything?
No, not for a second.
And as far as you knew, Mr. Johnson knew what your position was.
Oh, yes,
And what was that?
that I was not guilty. We had a visit. It was one of the last couple of visits I had with him, and he was actually the one that stated, we've been talking about the intentionally knowingly, and he said, they don't have intentionally and knowingly, you're not guilty. And I
Okay.
clung to that.
And the intentionally and knowingly phrase that relates to the first degree child
Yes, sir.
abuse. And in your understanding, the ultimate charge was felony murder.
Yes, sir.
And the predicate
He
offense
didn't tell
was
you you
first
not
degree
guilty,
child.
Yes, sir.
and you knew you was guilty of sin.
I don't have any further questions.
Is it all right if I move the podium?
Oh, don't start squeezing your eyes like you got another one.
Okay. Good morning. So, Ms. Vander Ark, I just want to go back and ask you a little bit about your background, okay? So, were you a legal clerk, or what was your exact role at Newaygo County Circuit Court?
I was a law clerk.
Okay. And you were previously an intern in Muskegon County Circuit Court,
I
correct?
was, yes.
What were some of your job duties in
Legal
those two
research.
positions?
Oh, sorry. Well, both of them. I did legal research. I helped score sentencing to make sure it was accurate. That was about the extent of it here because I was still in law school. When I worked for my judge in Newaygo, I actually did the research, and I would draft opinions, and then he would, decide if that was okay. And then most of the time he just signed off on that I'd gotten it correct.
Is it fair to say that you worked on post-conviction motions for your judges,
Yes, I did several times.
including claims of ineffective assistance of counsel?
I honestly, I would assume so. I don't remember.
And so in other defendants' cases, you would be writing draft opinions or bench memos for circuit court judges.
That's what I wrote. I don't think we had an ineffective assistance. I don't think so. I may be wrong, but I don't think so.
And it's your testimony that your opinions or your recommendation to the judge was so good, he just wrote off on it, signed off?
On most of the time, there was a few that he adjusted, but
So therefore,
he
that
would read them and then send them over to his clerk to
play
publish.
that
So,
you're in right now.
And this all happened before you were criminally charged, correct?
yes,
So even before you were at a trial, you are intimately familiar with post-conviction motions,
There you go.
correct?
I wouldn't say intimately familiar. I mean,
Yeah.
some of them I was familiar with, but
Familiar enough for your judge to
yeah.
just rubber stamp what you
For the
said?
ones, a lot of what we did, actually, most of what we did was civil. There was some criminal, but most of the motions and the work I did as far as writing was civil. He did both civil and criminal.
Ding, ding, ding. Come on.
Now, Ms. Vander Ark, you mentioned that Mr. Johnson had a team of individuals at the Public Defender's Office, correct?
Yes.
And could you tell the judge how many individuals were on that team?
I have no idea. I think total I met with over time probably 6. And then he mentioned having somebody doing research and other people and other interns working on it, but that's the people I met with. I don't know how many there were.
Okay. It wasn't just you and Mr. Johnson working on the case, though.
No, it wasn't.
He had social workers that
Yes.
assisted you,
Yes.
and it sounds like interns as well,
Yes.
and other attorneys in his office.
Yes, I only met, as far as the criminal side, I only met with another attorney in his office. It was at one hearing, it was the gentleman that sat second chair, and then at trial. I didn't meet with any of the other attorneys otherwise.
And you said that Mr. Johnson began meeting with you approximately 2 days after your arrest,
Yes,
and he continued to meet with you throughout the pendency of the case,
yes.
and his team would meet with you throughout the pendency of the case.
The social worker is the one I saw the most. I'm trying to think, I saw the intern some, but that was mostly it.
And would, when you say the social worker, do you recall, was that Melinda Katecki?
For the last 2 visits, I only saw her twice in person. And I think she was online once for a meeting with a doctor. But there was another social worker that met with me once a week, usually for the first few months, I don't know, probably 6 months at least. And then she moved on from the office.
Now, Ms. Vander Ark, you've spoken quite a bit this morning about your medical, I guess, episode, for lack of a better term, medical episode that happened mid-trial. Okay, so I'm going to go into that. But that's not the first episode you had during these proceedings, correct?
No.
Okay. And one of those happened at your preliminary hearing or your preliminary
Yes.
examination, correct?
Yes.
And that occurred just before Paul was going to testify at the prelim, correct?
Thank you, Laura.
I believe so.
And your medical episode that happened in the trial happened right when you'd been confronted during cross-examination, correct?
I had one other one before trial, during trial.
Okay,
And
when was that?
There were some police officers testifying.
And it's
But I
your,
was sitting there and had a panic attack and they cleared the jury out.
and do you recall what the officer was testifying?
y'all, her shenanigans were so bad. They were so bad that she pretended they were so bad that when she turned over and heaved into a trash can, the judge said, "Let me see it." Like, her shenanigans were so bad, he checked to see if she threw up and then told her she didn't. Like, that's how bad her shenanigans were. So when she's saying, "Oh, you had this panic attack and had to clear the jury out while you were testifying," it was absolutely on cross-examination. Anytime she ended up in a situation she did not like, she would just absolutely act a fool.
About when you had that
I don't.
episode?
No, I don't.
Probably something pretty significant about your case, though, correct?
I mean, I would assume so.
Or something about your son's condition?
Or something.
I don't know.
It's fair to say that those episodes, though, don't happen all the time.
They do, well, they were beforehand and they still do happen consistently.
That's a poorly worded question, so I'll clarify here. Those episodes didn't happen on direct examination with your own attorney questioning you, correct?
They didn't happen yet.
They didn't happen during opening statements?
No.
Or jury selection? No?
No.
They didn't happen during certain parts of your preliminary examination?
No.
But these episodes happen when you're confronted with evidence that you don't want to acknowledge or admit. Is that fair?
No, they happened when I was confronted with traumatic events. It was anything traumatic that got that bad.
So seeing your son, who was in your care for all those months, in a picture, was traumatic to you?
Yes, extremely.
But you'd seen him every day that he was in your care, correct?
Yes, what I remembered, yes.
And then when you see a picture of him on that stand is when you have this episode.
Yes, I mean, I had panic attacks. Looking back, I know I had panic attacks previously, but I don't know what brought those on.
Nobody diagnosed you with a panic attack on the night of that trial, correct?
I don't know.
That's a yes or no.
I said I don't know.
You have no evidence that you had medical diagnosis of a panic attack that day.
That day? No. As far as I know, no.
And you have no medical diagnosis that you had a panic attack during your preliminary examination, correct?
There was no medical person called in.
Okay, so my question was, you don't have medical documentation of a panic attack that day?
No.
So let's talk about some medical documentation you do have.
Let's talk about what you do.
You recall Mr. Johnson submitted you to multiple individuals for forensic examination,
Yes.
and you met with those medical providers?
Yes.
And how many would you say, based on your memory, you met with?
A couple.
Okay. Would it surprise you that there's approximately 4 reports regarding your criminal responsibility or competency?
No. It
Would it
wouldn't
surprise
me.
you?
No, because I understand the process, so it doesn't surprise me.
Okay. What's your understanding of the process?
Right, did you
That
understand?
both sides can get the competency evaluation and the responsibility evaluation.
And you understand that under Michigan law, you're presumed competent unless proven otherwise, or unless shown otherwise, correct?
Yes.
You've never been shown to be incompetent, correct?
Not medically, no.
No, not legally. Is that correct?
Yeah.
You have never had a legal determination that you are incompetent, correct?
Yeah.
And that's after meeting with these 4 providers, correct?
Yes.
And in fact, some of the providers called into question your rendition of facts to present to them. Do you recall that?
I don't recall that, but I'll trust if they said that.
Do you recall specifically? Let me go back here before I get into that. Do you remember your interviews with these providers?
Bits and pieces.
Do you feel that you were truthful with them?
Yes.
Do you feel that you appropriately explained your situation and your memory with them?
I hope so.
But you don't know, correct?
No, I don't.
Sorry, bear with me one moment, please. Your Honor, I'm referencing People's Exhibit 2, which I believe was attached to my brief, which would be a June 20th, 2023 report authored by a Benjamin La Liberty, doctor.
Well, this case would have been Tiffany and an FOI
Now you-
trial, and that.
Did you tell this doctor,
What's going
or
on?
this individual at the Department of Health and Human Services Center for Forensic Psychiatry that you disassociated during times that Timothy was in your care?
Yes. Even times when he wasn't. I mean, it happened regularly. It still does.
Well, and that's my question. So is your claim in this post-conviction motion that you were disassociating during parts of the trial?
I mean, I'm not a medical person, so I don't know, but that's the only answer I have.
Well, so I'm not asking you to give me a medical opinion. I'm asking you to tell me what you mean when you're saying you disassociate.
Talking to somebody like this,
So what do you mean when you say you disassociate?
remind that she's right.
Usually it's a panic attack and I have no clue what's going on around me. I don't remember anything during that.
And when you, so you've said that on that day of trial, when you had your episode, that you had a panic attack, but would that be a disassociation like you have just described?
During the panic attack, yes. They usually only last like 10, maybe 15 minutes.
Oh, okay.
Ms. Wilkins?
Yes.
I just want to interject. Ms. Vander Ark, can you describe to the court what you believe what you are experiencing, not the people. So what you call panic attack, what are you experiencing during this events that you label as panic attack?
It's one of two things on the breathe. Either I hyperventilate or I feel like I've got an elephant sitting in my chest and crushing it and I can't breathe.
So that's double breathing.
Yes. I'm shaking. My head is totally spinning.
So dizziness.
Yes, sir. I don't have a clue what's going on around me. I know people have tried to touch me during a panic attack, and that just freaks me out worse.
You mean painful?
No, just trying to make sure I'm okay.
So
And
when somebody touches you, what do you experience when someone touches you?
I pull away, and the panic gets worse
Okay, so you're aware of somebody touching you.
when they actually put their hands on me. Yes.
When you say you don't know what's going on around you, is it you have auditory problems or you can't hear, or you just have an inability to understand what's being said?
I think it's both. I mean, I don't remember anything that's been said to me during a panic attack. I know I had a couple of people scare me at Huron Valley. They were just playing around, but it caused a panic attack because I didn't know they were there. And I guess they tried to talk to me and they said, yeah, we got no response. And I don't remember them trying to talk to me at all.
Okay.
It's like
Do
I'm
you
down
have
a,
any other symptoms?
it's like I go into a total darkness, like this black hole.
Okay, no. When you see dark, are you seeing black? What are you seeing? Is it
Like a
spots?
black or gray, usually. I'll try to fix on a spot as it sets in, but then that's it. I don't see anything else.
Can you move? Are you able to move your arms, legs, extremities?
Not most of the time, no. I'll curl up into a ball and
So
But you are moving.
You curl up in a ball, you consciously make the decision to curl into a ball to stop the symptoms? Or is it an involuntary movement into a ball?
it's an involuntary movement.
So involuntary movement into a ball.
Baby.
And then you don't know how much time passes?
No,
Is that what you're telling me? Okay.
no. I know that afterwards, I've had somebody there and look at the clock, and the only thing I could tell you has been I've had people say anywhere from 10 to 15 minutes that were around.
And you said these have happened while incarcerated currently?
Yes. They still happen
In your
regularly.
cell, in the common areas, where they happen?
Most of the time it's in my room
In your cell?
or in the restroom, yeah.
Room or restroom? Okay. Any times when other inmates were around?
Yes,
Okay. So common areas?
yes,
And you're aware that these areas are filmed, correct?
yes,
This would be on camera?
Yep.
Okay, so you're telling me that you experienced a panic attack where you curled in a ball on camera at the prison?
yes. In the foyer of one of my units, somebody came up behind me and scared me, and
Do you know approximately when that was?
I have I can give you a date range because there's a certain time I was in that unit.
Please
It
do
would
so.
be somewhere between end of August of 24, and beginning of January of 2025. That was the time I was in that.
All right, thank you. I just wanted to make sure we understand each other about panics.
Yeah.
Go ahead, Ms. Goldstein.
Let me clarify, you said August of 2024 through January of 2025?
Yes, I can give you the name of the unit if
Yes,
you
that
want.
would be helpful.
Gladwin A.
Yeah.
Sorry.
So, Ms. Vander Ark, now it seems like we're all on the same page about what you mean when you say panic or disassociate.
Yes.
Okay. And it's fair to say it's your testimony that you had that sort of episode mid-trial during your cross-examination. Is that your
Yes.
testimony?
Yes.
Now, are you aware, though, in People's Exhibit 2, that criminal responsibility report that I previously placed in the record, that it was noted by the clinician that your claims of disassociating, quote, only occurred when Timothy was bad? Are you aware of that in the report?
No, I'm not, because that's not true.
Okay. And overall, the opinion of the clinician was that when you described your current state, you did not describe any substantial functional impairments within the context of your current confinement.
If I said that, that's not true.
Well, that was his opinion.
That was his opinion? Okay.
Yeah.
I didn't know he said that, but that's,
And here, let's go further. On page 10, Your Honor, if I may approach. I'm showing the witness People's Exhibit 2, page 10. All right, Ms. Vander Ark, if you would look at that, and would you read right where that star starts? Please read that into the record.
Ms. Vander Ark was asked to recount her thoughts, feelings, and behaviors around the time of the alleged offense. However, Ms. Vander Ark claimed to have no memory of the events that led to Timothy's death, noting she frequently dissociated due to the stress of interacting with him.
And you can keep reading. Please read the whole paragraph.
Of note, this immediately appeared to be a self-protective response style as opposed to the result of a genuine memory deficit or bona fide dissociative condition. That is, her purported memory loss was noticeably selective and only involved the actions that allegedly caused the victim's passing. Thus, Ms. Vander Ark cannot be considered a credible historian. That's not true, but
I'm about to say that's pissing me off.
So, Ms. Vander Ark, we don't have an opinion from an expert that you were incompetent, correct?
yes,
But we do have an opinion from an expert that you're not a credible historian, correct?
looks like it.
Use a lie.
And that's specifically as it relates to your credibility about these disassociations you claim to have, correct?
No, I didn't. I'm sorry, guys. I done knocked the bottle over.
Of January 3rd of 2022.
At the jail over the course of the
And you're aware that these areas.
And only involved the actions that allegedly caused the victim's passing. If that's what's in there, then
Now, you, one of your claims in this post-conviction motion is that you take issue with Mr. Johnson not calling an expert, correct?
I mean, if that's what's in there, then we discussed it briefly. I didn't know what he was doing. So as far as if he was going to call him or not.
So I just want to make sure I'm clear. You weren't sure if Mr. Johnson was going to call the expert or if we weren't going to have the expert here at this hearing.
For a while, I wasn't sure if he was going to call him at the trial.
Okay.
Sorry.
But you do recall meeting with Dr. King,
Oh,
correct?
yeah.
Yes. How did you feel that meeting went with Dr. King?
Long.
Was it thorough?
I would assume so, yeah. I mean, I don't remember the whole thing, but I know it was exhausting.
Mm-hmm. Now, Dr. King also has some opinions as it relates to your credibility as a historian, correct?
I don't know.
You don't know? Okay. So I'm looking here at Defendant's Exhibit B, page 10. And Ms. Vander Ark, I'm going to just start here where it says conclusion. Ms. Vander Ark overreported general psychological dysfunction and generated a larger than average number of infrequent responses. Are you aware that that was determined based on your psychological testing?
I mean, I think I've read it before.
Okay, you have no reason to dispute.
No,
what
I'm
he
not
has in this
disputing, that's what
report.
I'm not disputing.
In fact, you actually attached this report to your motion for a new trial, correct?
Yep, my attorney did, yes.
On your behalf, though, correct?
Yes, yeah.
Yes. And so we have one clinician saying that you're not a credible historian and another saying that you over-report general psychological dysfunction, correct?
That's what they say.
They say, huh? They.
Ms. Vander Ark, there is no medical opinion now that determined you were not competent to proceed with trial, correct?
Correct.
You have no medical evidence today that you've presented at this hearing, correct?
Correct. But nobody bothered to get any.
Your Honor, I'd move to strike that non-responsive answer from the record.
I will.
Thank you.
Is non-responsive.
So I'm going to shift gears here a little bit. In your direct examination, you've provided multiple other individuals that you want to place blame on for what happened in your criminal case. Is that fair to say?
I mean, I'm not gonna dispute it, yes. I don't remember all that testimony.
Well, just today. Today, you said that it was your ex-husband's fault that Timothy came into your care, correct?
Well, he asked me, yes. That's what he told me, and that's why I took him.
And it's your testimony that it's the jail's fault for your housing situation that exacerbated your mental health, correct?
And none of this your fault.
I didn't have any choice in the matter, so yes.
So that's a yes or no. Are you blaming the jail for your mental health?
For making it worse, yes.
So we have, you're blaming the jail, you're blaming your ex-husband. Now, you've also blamed Timothy today, didn't you?
As far as what?
As far as his behavior is causing you to act the way you acted.
As far as causing chaos, yes. I mean, as far as causing stress, yes.
And now you blamed work as well, saying that caused stress. Your employment before your arrest.
I mean, work always causes stress.
This has been a consistent theme for you, where you want to blame others for things you've done, correct?
Explain the situation.
Well, so you're saying it's your ex-husband's fault, it's the jail's fault, it's Timothy's fault, it's now your trial attorney's fault.
Come
We're
on,
here.
come on.
So is it fair to say it's a theme of yours to point the finger at others
Woo,
for what's going on in your case?
I wouldn't say it's a theme, no. That's an opinion. You can see
All right.
the things that I had no say in, that you can't blame me for.
Now let's talk about those jail, the testimony you had about your being held in, you said it was max security during the
Yes.
pre-trial phase,
Yes.
correct? You said you were locked in there and isolated?
In a room by myself, yes.
Okay, yes. Was Timothy also locked in a room and isolated when you locked him in the closet?
Say
He
the
wasn't locked in, but he was in the room, yes.
Okay. When you had alarms on his door to keep him in that closet, was he isolated?
Yes.
And he'd be locked in there for hours at a time, correct?
I would assume so, yes. I don't,
Yes or no? Was he locked in there for hours at a time?
yes.
I would assume so. You know he was. At your instruction.
And you want the court to use your isolation as a basis for
Come on.
making a determination about your mental health, correct?
It has an effect on it, yes, it does.
What about Timothy's mental health?
Come on.
What impact did your locking him away, isolated, have on his mental health?
I have no idea how to answer that.
Truthfully,
You want us to take in.
That's- here to do.
That is truthfully. I have no idea how to answer that.
Well, how does it affect yours? Let's think that how it would have affected a child at the hands of his mother.
now you talked about some of his diagnoses, correct?
Yes.
Obviously, it wouldn't be beneficial to him to be isolated like that, correct?
Yes. I mean, he isolated himself too. He did not. I offered to, there were kids in the neighborhood, and I actually specifically asked them, He wasn't the most coordinated kid in the world, but they were playing basketball one day, and I said, "Hey, can he come over?" They said, "Anytime." He never wanted to do that. When we went to little man's baseball games, he stuck to himself or with us. He didn't want to go talk to the older kids.
So it's your
You don't know how to be
testimony that
around
Timothy
people.
isolated
How y'all
himself.
treated him?
Some of the time. Not all the time, but some of the time.
Timothy, who you went to such lengths to keep away from your in-laws that you were tracking their location so that your child G would be outside when his grandparents arrived, is the one that isolated himself.
I did not. That was not the point of finding out where mom was. It was because the house was a mess. It had nothing to do with Timothy. That thought it hadn't even entered my mind until I got asked about it at trial.
You expect the judge to believe that Timothy did this to himself, correct?
Can you define this?
Well, that's what your testimony is
I'm
that
saying-
he isolated himself.
I said some of the time, and you said this. That's
Okay, I'll clarify. He isolated himself in that closet
some of the time. Some of the times downstairs,
where he had nothing but a tarp in there. He isolated himself in there. Is that your testimony?
he tore apart a mattress. But
That was not an answer.
some of the
My
time, I said some of the time.
That is not an answer.
Did he isolate himself in those ice baths?
I wasn't there for that.
But you ordered it, correct?
I don't remember.
You
You
don't.
had a cell phone at the time this happened, right?
Yes,
And you were messaging with your other son, Paul, correct?
yes.
And those messages speak for themselves,
I'm
right?
not disputing the messages. I'm just telling you what I do and don't remember.
No, little guy is the youngest son. This was her middle son that was unalive.
Now, you testified earlier today that during the time after your husband's stroke, you were, quote, barely surviving. Do you remember testifying to that?
Yes,
You were surviving just fine. It was Timothy that was barely surviving, correct?
I wasn't aware of enough of what was going on around me. I wasn't, I admit that.
Yeah, throw something on that neck.
Now, another claim in your post-conviction motion is how your attorney, Mr. Johnson, handled the surveillance video from that closet, correct?
The motion about it, yes. Oh, yes, I know what you're talking about. Yes, from the
Okay.
brief.
And so you are claiming that it was ineffective or deficient of Mr. Johnson to let the police officer testify to the contents of that video, correct?
I mean, if that's what's in, I trust my attorney with that, so.
Did you observe that video?
No.
You were in that video, though, to your knowledge, correct?
As far as I know, yes.
And that video has been described by multiple individuals as extremely graphic and haunting. Are you aware of that?
I think I've heard that, yes.
And that video actually, in fact, shows your son take his final breath. Are you aware of that?
I did not know that, no.
And it shows what you were doing in the time leading up to him taking that final breath. Are you aware of that?
I would assume so.
Are you aware that it shows you being extremely cruel to him in those moments?
I don't know.
You're also aware that after he's passed away, it depicts you dragging him out of that closet. Are you aware of that?
I remember performing CPR, so I guess was what happened before that.
Okay, one second.
Performing CPR. I'm really trying to figure out what that was supposed to do.
Thank you. Are you aware that at the end of that video, after you pull him out, there's audio about telling him to stop faking it?
I have no idea what was in it.
Are you also aware that before he passes away, you call him a dummy?
There was something said about that at trial. We all say stupid things.
Oh, really?
So it's your testimony that that was just a stupid thing to say to your dying son?
It's
To
stupid.
insult him?
It's a stupid thing to say to your child, period. That's what
Yeah,
I'm
you
saying.
said it, correct?
Come on.
Yes, I mean, I'm not disputing it.
Do you believe that your attorney should have let the jury view that video in its entirety?
No,
So you think it's probably a good trial strategy to shield the jurors from seeing you on video insult your dying son, correct?
yes,
It's probably a good trial strategy to not have the jurors personally witness his last breaths, correct?
yes,
And it's probably a good trial strategy to not have the jurors observe you telling him he's faking it when he's already dead, correct?
yes.
Now, it's your testimony that during the trial, there was some discussion about the manslaughter instruction, correct?
What do you mean? I'm sorry, can you rephrase that?
So you testified on direct that when Mr. Johnson came to the jail, he was discussing jury instructions.
Oh, you mean this hearing? Yes, I'm sorry.
I'm
I
sorry,
was
not this
confused.
hearing, I apologize, the trial. During the trial, there was a discussion that Mr. Johnson had with you about the manslaughter instruction.
Yes,
Yeah. I'm gonna ask a couple of questions that sort of dovetail off of the court's questions here, though. And I'm sorry to go backwards, but you said when you're having these dissociative episodes, you have involuntary movements.
Mhm.
I'm sorry, it's being recorded, so is that
yes, I'm sorry.
And let me ask you this, was it an involuntary movement for you to grab the garbage can while you were testifying? Or was that not intentional?
I don't know what you mean. I mean, I was gonna throw up. It
Okay,
was
so
right
did
there.
you make the choice to extend your arms and grab it?
Yeah,
And did you make the choice to lean your body over?
I don't know. I
You
don't
don't
know.
know.
I mean, I was about to throw up, so,
It's real
Did
convenient.
it happen by accident that you were positioned that way?
I mean, no.
Are you aware there was no vomit in that garbage can once you left the courtroom?
I have no idea.
It's because you faked the vomit, correct?
I didn't fake anything. I dry heave all the time. I dry heave from motion sickness before I got the motion sickness meds I used this morning for the trip over.
Okay, let's talk about that. So didn't you claim at the last hearing that you had some motion sickness on the way into court?
Yes, I did.
And do you recall whether or not that was supported by any of your transport team?
I remember they said that they had glanced at me in the mirror. I mean, I know I was dry heaving. I didn't actually throw up anything, but that's because I didn't eat intentionally. Because I
Do you-
knew I get
Okay,
motion
So do you
sick.
remember, I believe there was some in-court inquiry to your Department of Corrections officers. Do you remember them saying something from these seats back here at the last hearing?
I remember them talking from there, yes.
Okay, and I believe the judge, and I don't have the transcript, but I believe the court may have even sworn them in briefly for a couple.
One of them, yes.
One of them, yes. And it was as to your claims of motion sickness, or how you were feeling on the transport.
How I
correct?
was feeling on the transport, yes.
And there was no mention of you vomiting in that transport van, correct?
No, I dry heaved. I didn't have anything on my stomach to throw up, thankfully.
Ms. Vander Ark, you were here for that November hearing, correct?
Yes,
And you sat in the courtroom while the other witnesses testified, correct?
yes.
Is it your testimony today that they all were lying about what happened in the jail before the Friday start of the trial?
What do you mean?
Well, so let's talk about it. We had multiple individuals who testified about your desire to not come to court. Correct?
I know at least one said that, and I do remember making comment, I don't want to, but most of it was I can't.
Okay, but you did say the words, I don't want to.
Yeah.
Is that a yes?
Yes,
And you ultimately memorialized that in an affidavit.
yes.
And you don't dispute that that is something you signed, correct?
No, I don't dispute it. I signed it.
Do you remember? Actually, I'm gonna strike that. Let me rephrase. Miss Kentucky testified about her observations of you
Yes,
that morning, correct?
yes, she did. Although hers were different than Fred's and mine, but some of them.
It's fair to say you have some selective memory about what you remember from that morning, correct?
It's not selective at all. I still have memory issues to this day.
So it's fair to say, though, you remember some of the things enough to
Some
say
of it.
Miss Kentucky's is different than yours.
Well, because I sat there and I was the one that wrote the affidavit. And I sat here when Mr. Johnson said that, and officer said that I was curled into a ball on the floor. And then she said I was up in a chair, that it wasn't as bad. But he described it. I mean, the most accurate total description was what he did, what he described and the officers described. Hers wasn't as accurate.
So you're saying that Mr. Johnson's description of you that morning is accurate?
From what he said, as far as curled up into a ball and not able to communicate, yes.
So I said yes or no. Mr. Johnson's testimony about that morning is accurate.
As far as I remember I'd have to go
Yes
back.
or no?
Yes,
Okay, thank you. I have nothing further.
All right, Mr. Andrews.
Are you saying all of Mr. Johnson's testimony was accurate?
absolutely not.
Okay,
Not even close.
all right. You were seen by a number of professionals, correct?
Yes, sir.
One of those professionals is Dr. Colin King, is that correct?
Yes, sir.
And the prosecution mentioned that on page 10, there is a conclusion part, and you testified as to that, is that correct?
Yes, sir.
The ultimate conclusion on page 11 of Dr. Collins' report, can you read that, the highlighted portion?
Yes, sir. After reviewing the text messages with Ms. Vander Ark and the police report, Ms. Vander Ark continues to insist that she did nothing wrong and was not convinced that her actions and instructions caused the death of her son. This clinician is of the opinion that Ms. Vander Ark truly believes that her actions were appropriate and not harmful.
Okay, and this is a report that Mr. Johnson gave you?
Yes.
And you talked about this with Mr. Johnson?
I don't remember how much we talked about that.
Okay, as far as you're aware that you've always expressed your innocence to Mr. Johnson.
Absolutely.
Did you ever concede or ask him to concede to anything?
Absolutely not. I never would have.
Now, after day 3 after your testimony, were you seen by any medical personnel?
No.
On day 4, were you seen by any medical personnel?
No, sir.
I have nothing further.
No, Your Honor. Thank you.
I have some questions. Ms. Vander Ark, I think you testified at the beginning of your testimony for Mr. Ambrose, is that you said on day 1, Mr. Johnson told you that you had to testify. Is that true?
No, I said I knew I had to
You
testify.
knew you had to testify?
Yes, sir.
Okay. And did that conclusion come from the conversation between the two of you? Or was that something that you were already had concluded in your mind even before you talked to him?
I think it was mostly I concluded. I mean, we discussed it, but I kind of knew that from the first time. Or
So
first
you knew it, so you're telling me this idea of you testifying came independently even before you had spoken to Mr. Johnson?
Yes, sir.
And then did Mr. Johnson discourage that idea? Did he encourage that idea?
He agreed with me the whole way. We talked about that multiple times and the whole process. And we always said I had to testify. There was never a question in that.
You said that Mr. Johnson, the discussions between the two of you had largely centered around that the prosecution had to prove intentional acts. Is that true?
For the child abuse charge, yes.
Okay.
Intentionally or knowingly.
Intentional and knowingly. Okay. And you said you two agreed that, based on what you were telling him, that intentional and knowingly had not occurred.
That's correct.
Okay. Was there ever discussion after that about, well, it's potentially, there could be a negligence argument here?
No, we never
Never talked
discussed
about
it.
negligence.
Never.
You had indicated that you saw Mr. Johnson, you said around 2 to 3 times during that first month after you were arrested and taken to the jail. Is that correct?
Yes.
Okay. After that, you used the phrase, I saw him once in a blue moon. Can you give me an approximation how often that you believe you saw him going forward? Once a month,
Oh,
twice a month?
It wasn't.
You saw him.
I think when he testified, he said once every other month. I don't feel like it was even that often.
Okay,
But I
so
don't
what's
know.
your independent memory of how often you came?
I would say once every few months,
Once every few months. Do
Yes.
you mean 3 months?
at least 3, yes, sir.
So once every 3 months. Okay. All right. Did that frequency increase as the trial approached?
I don't feel like it did. I mean, there was a couple at the end that were closer together,
Okay.
but
The month before the trial, can you tell me how many times you remember him visiting you?
I'm thinking 1, 2. There was 2 actual visits, and then we came in here for 20 minutes
Okay.
to do a little bit of prep, just a few minutes.
I want to make sure, I should have prefaced what I was saying. When we talk about Mr. Johnson, I mean himself,
Yes.
not any other member of his team.
No, I mean,
Okay. So those that you were testifying to was Mr. Johnson himself. Is that
Yes.
correct? Okay. Were there any other members of
I was about to say now.
his quote-unquote team that had come and talked to you outside of those times that Mr. Johnson had come individually? So separate from Mr. Johnson.
you mean just before trial, or what do you mean?
No, well, let's start, you said 2 or 3 times Mr. Johnson the first month. Was there anybody else from his quote-unquote, let me go back. What did you know of his team? What did you consider his team to be?
I knew he had some interns. He had the original social worker. I don't remember her name. I'm sorry. Sorry, I'm bad with
So
names.
social worker,
She came in once a week to the jail for a while.
okay, once a week. Okay.
And then that was it. We came in for a hearing. I think it was to something about competency, and Nick Goings was there.
Okay.
So I knew he was on the team. And then both the social worker and Fred had mentioned a research attorney.
Okay. Did you ever meet the researcher?
No, I did not.
So you believe 2 interns, research attorney, at least 1 other attorney, Mr. Goings, and you believe he was an attorney, correct?
Yes. Oh, I knew he was.
And Mr. Johnson, is there any, and the social worker, was there anybody else that you knew was on this team?
Not specifically. I know he would say he had people working on it, but that's
All right. And you're saying the social worker came in every week?
for a while. Then before that one left, she left the public defender's office.
Okay, do you know approximately when?
I have
she stopped
no
coming to see
idea.
her? Okay.
I'm sorry,
That's
but
okay. And then when a new one took over, did that social worker come?
I saw her twice, I think, in person
Twice.
before trial.
All right. In terms of the interns, how often did you see an intern?
They actually did not come like he had said they would.
They never came?
One came with him. It was the same one a couple of times.
Okay.
I don't know, 2 or 3 times. It was there at the end. She sat in on the trial too.
So did an intern ever come independently of Mr. Johnson?
No.
Okay. I read your affidavit. One of the arguments advanced by your attorney and you in the affidavit was that Mr. Johnson did not argue what you felt. Well, let me ask you a question. The dehydration argument, was that to you should have been the primary argument?
I did not know about that until the medical examiner testified.
Okay.
So when I realized that, I asked him to ask about it, but I think he only asked one question and that was it. I didn't even know about that until that day.
Okay, in your affidavit, It says, and this is one of the paragraphs, this is page 11. It says, a medical examiner stated that one of the main causes of death was dehydration. It says, I specifically asked Mr. Johnson to examine this much deeper. There was no accusation against me regarding depriving Timothy of water. This alone could have raised a reasonable doubt that Mr. Johnson never pursued the subject at all. When you make the statement, I specifically asked Mr. Johnson to examine this much deeper. Are you saying was this before the trial, or was this after you heard the medical examiner testify?
This was after I heard the medical examiner testify.
So it's your testimony, and when you said you asked Mr. Johnson to examine this much deeper, was that during a break after the ME had testified?
No, it was in the middle of it. I wrote him a note.
Well, you wrote him a note.
Yes.
Could you recall what the note said?
I put dehydration ? Exclamation point. And I said, please ask more about this, because
That's
he
what
had
you wrote
access
on
to
there.
water. Yes, sir.
And your testimony that he did not?
No.
Okay.
You would not say there, you would
I don't
defend
know
it.
too much into what could
A
have.
lying defendant who can't say even.
Did Timothy have access to the water?
Yes, he did.
Was he cognitively capable of getting water on his own?
Yes, he was on the spectrum, but the only symptom he really showed was awkwardness. He was grade level. He was passing all his classes. And, he could communicate. He did interact with some people at little man's baseball games. But he just was awkward. He didn't want to hang out around other kids. And he was 15. He was, you try to hug him, he's like, Mom, go away. But no, he could communicate just fine. Trust me, he could communicate just fine.
And I just want to be clear what you believe the argument that should have been made. You believe the argument that should have been advanced to the jury was that Timothy caused his own death by not drinking water.
I mean, I think that something should have come up. And I just told myself, I probably can't even.
Is that the argument? Is that the argument that you believe should have been advanced to the jury, that Timothy caused his own death because he stopped drinking water?
I think it should have been mentioned, yes. He had suicidal stuff before I got him, so he was
He had
hospitalized.
suicidal stuff.
Yeah, he was actually hospitalized for suicidal ideation. His stepmom told me that.
Okay, so you believe that an argument should have been made that Timothy essentially consciously caused his
You
own
bet
death?
not.
He was suicidal, he committed suicide.
I mean, I don't know what happened, so, but it's,
I know that, I
yeah.
understand that, but I'm trying.
I think it should have been brought up, yes.
Okay, all right. I understand. Okay. Did your concerns with Mr. Johnson's representation, did those arise prior to the trial?
I was worried about it along the way, yes.
Okay. Did you ever attempt to bring those concerns, to the court's attention?
No.
Okay.
I wasn't in good shape. Remember, the time I was isolated, I wasn't eating, I wasn't sleeping.
Okay.
I was not in good shape.
Did you have the ability to write letters, correct?
Yes, but I didn't have any, for the most part, at first I had a little bit of money on my account, but I didn't have any
Well, you
envelopes
can
or
write
anything.
cuts, correct?
Yes, yeah.
Those are free, correct?
Yeah, you can write them, they go to your attorney.
Were you aware that you could send them to the court?
No, I was not.
Now, you were in court a couple of times before trial, is that correct?
Yes.
All right. Is there a reason you did not bring that issue to the court at the time of those hearings?
I didn't want to speak out of turn. I wasn't thinking about it right then, but I just, those hearings were for certain purposes.
So you didn't feel that you could directly bring those to the court?
Yes, yes.
Just below that paragraph on page 11, it says, I testified for around 5 hours in the Thursday trial. I was supposed to finish my testimony on Friday, including some very important questions that I wanted Mr. Johnson to ask me before I finished testifying. Do you recall what those questions were?
For the most part, no. I remember one of them because I lose weight really fast. And so, I know there were some questions about Timothy's size along the way. And then we also talked, because he's 6'1" and was like 130 pounds, and I'm small. And I was going to have him ask me about how quickly I lose weight, because if I don't eat for a day, I'll lose a couple pounds that fast. So I wanted him to bring that up.
So you wanted to ask how quickly you lose weight?
Yeah.
Okay.
Well, family genetics. I mean, my mama did the same thing.
Okay. Now, any other questions that you can recall?
Not that I remember, no. I didn't have a pen or paper to write them down. I didn't have that available when they put me down in the holding cell. What paper I had where I was at, I didn't have access to it.
Okay. These questions that you had contemplated, those were, I'm trying to figure out when you formed those questions in your mind. Was that on Thursday or was that on Friday?
Thursday afternoon. Thursday evening, yeah, after trial.
Thursday, okay. At the time that these questions were formed, were you suffering from a panic attack?
No, it was after that.
Okay. Friday morning, did you formulate any additional questions?
Not that I remember, no.
Okay. I want to know there's a lot in your affidavits about what was going on in the holding cell, that you curl up into a ball, you're barely able to communicate. You asked Mr. Johnson to postpone the trial, and you recall what his response.
Yes.
I want to know, do you independently remember that, or is that what your affidavit, is that based on what someone else told you?
No, I remember that small portion of it. I remember bits and pieces. I remember other parts of the morning as well, but that's it.
So,
No, I remember laying there. I was curled up, and because he testified that he had explained options to me and he did not. I asked at least 2 or 3 times to adjourn because I couldn't do it. And he said that, it was just gonna be the same and that they just go on without me.
Okay. So those things you do remember, but other things you don't remember, correct?
Yes.
So when during these panic attacks, it sounds like if I say lucidity, you know what that means?
Yes.
Okay. So you're saying during these panic attacks, there are brief moments of lucidity during these panic attacks, where you remember, where you can cognitively understand what people are saying.
Not usually during a panic attack. It wasn't one solid panic attack. It was multiple panic attacks that morning, but there was times where I wasn't actually in the middle of a panic attack.
So you're saying that what you recall independently of these communications is when you were not suffering a panic attack.
Yes.
So the recollections that you have are from non-panic attack instances, correct?
Yes.
I think you're purposely taking in everything that's saying, so that when you try to come back with anything, it's thrown, it's already aware of, because
Any follow-up, Mr. Haber, to those questions?
you,
Mr. Haber?
As far as you're aware,
as an
when
intimate
was the last
how
time
to do that.
that either you or Paul provided food to?
I want to say it was the day before he passed. I think Paul said he'd given him something.
Okay. All right, I have no further questions.
Any follow-up?
So, Ms. Vander Ark, it's your testimony that Mr. Johnson should have probed dehydration, correct?
Yes, he knew about it the whole time and never mentioned it to me.
I know about it too, correct?
What do you mean?
Well, let's go back. Were you at your preliminary examination?
Yes.
You attended it?
Yes.
And do you remember the testimony of Dr. Joyce DeYoung,
At the preliminary? The medical
the
examiner?
medical examiner?
I don't remember her testifying at the
Do you have
preliminary.
any reason to contest the certified transcript of the preliminary examination?
No.
And in fact, on page 87 of your preliminary examination, the forensic pathologist testified his cause of death was dehydration and extreme emaciation due to malnutrition and starvation. Any reason to contest that?
No, I don't even remember her testifying.
Now, there was also, I'm sorry, I cut her testimony off short though, but a significant contributing factor of exogenous hypothermia, so exposure to cold, end quote. Any reason to contest that?
No, she's the medical expert.
The reason he had hypothermia is because he was in water for hours before his death, correct?
That's not what Paul told me. Paul had run.
I didn't ask you what Paul told you.
If that's what
The
she
evidence
said,
showed that Timothy was in an ice bath for hours before his death, correct?
not the whole time because we didn't have enough ice for that.
Okay, well, let's go to this. You had an ice maker on your counter at the house, correct?
Yes,
And that ice maker was used to put ice cubes
It's about 5.5
into a bath.
when Judy's jury
Correct.
had to clock up.
And you
Yes,
were
I know.
aware of that.
yes,
And ice is technically water, correct?
yes,
And bathtub water is water, correct?
yes.
Nothing from Judy's jury so far. They went to deliberate around 9:15 Eastern Standard Time. So about 3 hours ago is when they went to deliberate. The judge did count 2.5 hours on Friday, and now we're at right about 3 hours. So about 5.5 hours on Judy's jury. But we do still have that up live, and they have not come back at all, not even for a question.
So yes, it's fair to say you did not restrict his access to water when you ordered ice baths, correct?
I'll go with it. That's a really weird question, but I'll go
Well, okay. You weren't keeping him dry by ordering ice baths for him, correct?
with it. That's a really weird question.
Well, ma'am, you are saying that Timothy committed suicide by not drinking water.
I didn't say that. I said it was possible and it should have been explored because of his previous history.
Well, do you understand that if it had been explored, that there'd be further questions about the ice baths?
I don't know.
Because naturally a bath contains water, correct?
Yes,
Which was a punishment that you ordered for your son, correct?
once or twice, yes.
Now, you also said that your attorney asked you when was the last time Timothy was provided food. Do you recall that?
Yes,
Do you recall having conversations about putting food in front of his face and pulling it away?
no, I don't.
But you have no reason to contest those
I'm not
text messages,
contesting
correct?
them,
I'm
no.
sorry, let me finish my question before you answer, okay? You have no reason to contest those text messages, correct?
Correct.
And so if they say that you said to essentially tease your starving son with a pizza roll, that Paul should do it.
If that's what it said, I'm not contesting it.
You also ordered that he be provided hot sauce, correct?
Yes,
Okay. Is that the food you're talking about with your attorney, saying you provided food?
no, not as far as I know.
You also ordered that he have hot sauce placed on his genitals, correct?
It's what the text messages says.
Is that the food that you say you provided to him before his death?
No,
Now, the medical examiner didn't determine that your son died from suicide, correct?
it's correct.
But now you're here telling the court that he was suicidal.
I didn't say for sure he was. I said it never got raised.
Well, you sort of raised it in that video that you said that your attorney should have played, correct?
What do you mean I raised it in the video?
On the morning you discovered Timothy was non-responsive in that closet. Okay, you following along with me?
Yes.
So that morning, when you discover he's non-responsive in the closet, you have discussions with Paul about telling authorities that Timothy was on a hunger strike, correct?
I'm not disputing it. I don't.
Did you, in fact, tell Paul that we need to say he's on a hunger strike?
I don't remember. If that's what it was in there, then I'm not contesting it, but I don't know. I don't remember.
And now you're saying he was on a drinking strike too, correct?
I'm saying it should have been explored. There's a big difference.
This is just another scheme of yours to try to blame Timothy for his own death, isn't it?
Not at all. There is no scheme.
Okay, maybe not the right word. Your testimony is blaming Timothy for his own death.
I'm not
Correct?
blaming anybody. I'm saying there's possibilities that should have been raised.
Well,
He
you're
had a
saying he was
history of
suicidal.
suicidal.
So you're saying he was suicidal?
I don't know. I never even thought about the possibility until that morning in court. Because I honestly do not remember the medical examiner testifying at prelim. I don't.
You didn't think about the possibility until you were trying to find out a way to blame Mr. Johnson
Come
for
on.
the trial. Is that correct?
No, that's not true.
I have nothing further.
Nothing further.
Have you seen the death certificate?
Yes. I didn't see it till that morning of trial.
Until when?
Until the morning I testified.
Do you recall what the first thing that is listed on this death certificate is?
It's dehydration.
Right. And that's kind of strange, right?
It's really odd.
Because he's in an ice bath, right?
hmm
And he has access to water, right?
Yes.
And so
He didn't.
he didn't drink.
No.
You never prevented him from drinking.
No.
All right, no further questions.
Stand there, can you stand down?
Fix your ass up.
All right, Mr. Ambrose, any additional witnesses?
I do not.
Any witnesses?
No, Your Honor, just if the court would recall, we took my witnesses out of order last hearing. I have no further witnesses.
Okay.
Filthy ice bath water. Come on.
Anything else, Mr. Ambrose?
No.
All right, I think it's important for the court, based on the testimony of Ms. Vander Ark regarding failure to raise concerns to the court. Ms. Vander Ark, I want to make sure we address you directly at this point, so you are free to talk to the court.
Okay.
I need to know if you believe that your attorney, Mr. Ambrose, is a little awkward, but is there anything that you believe he should do going forward at this point in time in regarding to your motion for a new trial?
No.
Are you satisfied with his representation?
Very much so. Yes.
Any other witnesses you want him to call?
No.
Is there anything else you want him to do?
No.
Okay, all right, good enough. All right, I think that's the evidence is concluded. The court is going to take the matter under advisement. The court will issue a written opinion, and then we'll go from there.
All right, I'm assuming that Mr. Roberts is not testifying?
No, he's not.
Okay. That was mentioned at the last hearing that he may be testifying, and I was kind of prepping for that.
Do you want to call him as a witness?
No, that's all right.
Okay, you sure?
Yeah.
Ms. Vander, you wanted to testify? Mr. Roberts? All right, good enough. We're in recess. Weekend.
We asked her every question. He's asking her every single question because he don't want to hear no shit. All right, so we still have no motion from. We're still live, but there has been no additional information, no questions, no movement at all in our Massachusetts courtroom for Judy Church. So they are absolutely still deliberating. So we're actually going to move into this particular trial here. The trial that this is going to be, this is, it was, what was this, 2 weeks ago? This, was it 2 weeks ago or last week? But this is the motion that has the potential to hold up the trial that's supposed to start on April the 13th because they are trying to, people are trying to get severed from each other as far as Julio Fulio Part 2. Now, in my mind, if I'm Isaiah Chance, I would want to sever myself from the people who actually popped. I definitely wouldn't want to be on nothing with Lil Rambo. But this is their the hearing that took place as far as whether or not they were as far as their reasons for wanting to split.
Good morning. All right, good morning. All four of the defendants are present. Their counsel are all present, states present.
Do you think that somebody's going to try to pull the hey, she was biased towards this story, this narrative, this trial, that one of our co-defendants before, so maybe she'll be biased to us? I was wondering if that's going to come up, but I mean, technically it don't work, it don't go, it's just some speculation. Okay, but I'm wondering if somebody's going to try to circle into this. And if you were Alicia Andrews co-defendant, would you want this particular judge to be on your death penalty case? Like, I don't know.
Good morning. All right, let me get set up here.
Yeah, she's still a judge for the other four. I think Alicia did not give up her right to a speedy trial, which is why she.
Okay. So some
Right, lawyer by
housekeeping
heart.
matters first.
Before we even get into it, you're absolutely right, lawyer by heart, because I was wondering, it seemed like her attitude came out with the member of the defense counsel, the one that was the day one, she was sitting right next to Alicia. And I said, it looks like Alicia could be her little sister or her niece. She flipped on her so bad out of nowhere. I'm wondering if it's that member of the defense counsel or if it was really towards this particular crime or these types of crimes, because of how prevalent they say they are in Florida and how much of a thing this particular rat beef was.
Let's see.
She had a couple moments with Arian too, but the way that she popped off on that one lady, it was out of nowhere.
I know that when we were here on Tuesday, that Mr. Gathright had some motions that I think I ruled on, but I couldn't locate the physical copies. So I just wanted to make sure that we're all on the same page regarding the fact that all of the motions have been ruled upon. All right.
Yeah, sure. The only one, and I saw it was on the list, it was sent out last night. The only one that hasn't been is really the firearm motion.
Okay.
The state and I discussed, I mean, I think it might make the most sense to kind of proffer it and address it with the expert.
Okay. Well, I do have that one. So there were 3 motions that I located in my stack of pleadings, and I just wanted to make sure that I had addressed all of them really for the clerk as well as for Mr. Gathright. And I believe that they were, the first one was a motion to declare section 921.1416I unconstitutional as written and as applied. And I think that was the CCP aggravator, which I denied. So that has been denied. Do you need it?
I'll just check it just to make sure I got it.
Okay.
I think I got it.
Okay, I think you do too, but just to make sure. And then the other one, the second one was motion to declare section 921.1416B Florida statutes unconstitutional as written and as applied. And that's the prior capital or violent felony, which would be contemporaneous in this case. And I believe I ruled that it was denied. Just want to make sure. And then finally was a motion in limine as regards to general procedures. And there were paragraphs. I think A was granted, B was granted. And C was granted as to the names, but denied as to questionnaires. So granted in part, denied in part. Individualized and sequestered voir dire was denied, and contemporaneous objections, paragraph E, was granted. All right. So, Madam Clerk, that was granted in part, denied in part, as articulated. And, okay, so I think those are the three motions that I located my copies of. Also, I had taken under advisement Rashad Murphy's motion to allow testimony of the impact of defendant's execution on family members. And specifically, Mr. Rashad Murphy had cited to Lugo versus State at 845 2nd 74. I did take a look at that opinion. And in that case, the defendant had one of his proffered mitigating circumstances was that his execution will have a tremendous negative impact upon the lives of his elderly mother, siblings, and 6 children. In this case, Mr. Lugo contended that his sister passed away. He adopted her 4 children and assisted in raising them. So in that case, what the real issue was what the issue on appeal was, Mr. Lugo he argued that mitigating circumstance outweighed the aggravating circumstances, and the court said no, and that was affirmed. But it does appear that this mitigating circumstance was offered, which was his execution will have a tremendous negative impact upon the lives of his elderly mother and siblings. So for that reason, as the motion is drafted, I'll grant the motion. All right. So yeah, just let him know. And really, and this applies to Mr. Rashad Murphy and all of the defendants in this case. Obviously, if we get to a penalty phase, you and your counsel can and should tell the jury every great thing about you, every redeeming characteristic about the totality of your life. Okay. So, all right. Very good. All right. So let's move on to which would be Mr. Gathwright's defendant's motion in limine to preclude the state from presenting firearms identification evidence. And then the state filed a motion to strike Daubert hearing request in defendant's motion. So how are you all suggesting that we handle this?
My position in the motion, and I know the state's early species, is that
Can't believe you just crazy little
firearms
boy.
identification evidence is not product of reliable principles and methods and should not be.
I'm sorry.
Yes.
I can't hear either.
This is better than courtroom 1, but it's not, it's still a big courtroom.
Understood. So, Your Honor, my position is that this body of alleged science, the firearms identification, is not reliable. It's not the product of reliable principles and methods. It should not be admitted at all. I recognize that has been addressed by many courts across the country, and the courts in Florida have not been particularly receptive to the argument. So, unless Your Honor is inclined to agree with me, I think that what Ms. Doherty and I talked about is that the best way to address this might be to proffer the expert's testimony when that time comes and rule on it at that point. So.
Okay. All right. Very good. So in light of that, I'm going to grant the state's motion to strike the Daubert hearing request, but I will allow defense to proffer before the witness testifies.
Well, no, it's still on there.
For appellate purposes. Okay. So just remind me that we need to do that before the firearms expert testifies.
Yeah, the DP is still on there.
So I'm going to grant the motion to strike. All right.
One more housekeeping matter.
Sure.
I'm wondering if it's going to come up in here, but it did come up before at another motions hearing, I believe, where the state wanted to allow them to be able to say, mitigating things or great things about them, about how much of a wonderful son, father, cousin, brother, what have you, that they were somebody worth sparing. They were loved at the time of the penalty phase, but did not want them to be able to say how great of a person they were at the actual execution if it gets that far. So there's a lot. It's been a lot of talk about what can be said when it comes to them, if they get to that. This is actually their request to split. I don't think Chance got anything. Anybody has gotten anything yet, but we should see everybody's everything in here.
I hope the court has now seen that I erred yesterday when I filed my supplemental memo on severance, one addressing the court's question to me last week. When I filed a draft instead of the final memorandum, I realized that very early this morning, immediately contact Ms. Ismer, and this morning at about 8:30 or maybe before, I filed it amended. Now, I will tell the court that the amended is in fact very similar to the supplemental. There's not anything of grave change to it, but I wanted the court to be aware that I apologize to the state for not catching it this morning. We filed a draft instead of the final of what we wanted to file.
Okay, very good.
Okay, and then the other thing, judges, I know I asked the court about this earlier in the week, believing that this would conclude any motions. I did have, and I will reiterate again, a motion in limine as it relates to the state's witness, Robert Howard.
Okay.
It is not yet complete, but it will not require testimony and probably very brief argument.
Okay, that's fine. We're going to pick another date in the future to hopefully resolve any outstanding evidentiary disputes. And I know you all still need to get together to do your evidence view, correct? Has that been scheduled yet?
I was gonna talk about that today. I know because of the voluminous nature of it, I wasn't even sure the state was ready to do that.
We do have to, we've gotten some items out of evidence.
The Sunny, the little girl, yeah, I'm thinking so.
Out of evidence that were put in trial.
Right.
So we will get that done. I think the photos for the most part, we're just gonna reprint. But they are a lot of photos, so I do need some time, but we will schedule that.
Okay, so on the lunch break today, I need you guys to figure out a prospective date for that, and then I will set a motion hearing date after that. But we need to have at least an idea of when that's going to be, because I know your calendars are busy, and I don't want you all to get jammed up, and then we can't get together at least one last time to go over any and all outstanding motions or issues.
Yeah.
Okay. All right, and I know we discussed this on the state's motion in limine regarding victims, gang activity, and drill rap videos not disclosed in reciprocal discovery. Did I give you all an absolute deadline? Did I pick a date?
Judge, I think they were supposed to provide it to us by today.
Okay.
And Judge, that would be any videos that we intended to enter.
Correct.
Any of us.
Yes.
And yes, Judge, you did give us until today to do so. On behalf of Mr. Murphy, I will not be providing the state with any additional videos.
Okay. All right. And so state, you're going to take a look at those and then let me know if you have an objection.
Yes, Judge, I believe the attorney for Mr. Chance provided us with a list of videos.
I did see. Yeah, I did see that. Okay, so I'm going to actually reserve ruling on that motion pending the state taking a look at what's been proffered. And if I need to resolve a dispute, then I will do so, whatever our next hearing date will be. Okay? So that one I will reserve ruling on. Yes.
Yeah, they back.
While we're talking custody matters, there is at some point.
Same player, different defendant.
There's a question Your Honor asked during my traffic stop motion.
Arnie.
Sure.
I can do that now.
Sure.
So when we were having argument on that motion at the last hearing date, Your Honor had asked if I would agree that finding the firearm in the car that Mr. Gathright was in would give a basis for, I guess, arrest. I don't know if it was arrest or a search of the car because he's under 21. And I didn't agree with that for a lot of reasons. But having done a little more research, I don't see a basis. I don't see a reason why his possession of a firearm, being under 21 and over 18, was unlawful. I know that's what the officers apparently believed, but I don't see a reason why that was unlawful. And if the state, has a reason that I'm missing, I'm sure they would bring it up. But to go back and readdress that question after having done some other research, it would, if he was under 18, it would have been unlawful. But I don't believe possessing a handgun between 18 and 21 is unlawful.
Okay, state what's your argument.
Judge, even, Judge, it is securely encased. I think that he is correct, but there is a law for that. But what he was arrested for was the possession of drugs and drug paraphernalia.
No, I understand, but I think the argument was made. I think law enforcement took the position that that was also.
They did, Judge. They believe that, and correctly so, that there is a law that if you are under the age of 21, you're not allowed to possess a handgun. But there is also additional part of that statute that says as long as it is securely encased, it's our understanding that that was in the console of the car.
So do you agree that that would have been securely encased in the console of the car within the meaning of that statute?
Yes, Your Honor.
Okay. All right. Thank you. Okay. All right. So next, we will move on to argument regarding the various motions as it relates to the gang evidence and whether or not it's going to come in. So the state has filed a motion for pretrial ruling regarding admissibility of evidence. And who's going to argue that motion for the state?
Can I be heard, Judge?
Yeah.
Maybe, Your Honor.
Virginia?
It's strictly up to the court.
To be honest, I really feel like those two idiots would have never completed this without those
things. Might subsume the state's actual motion when they argue against the state.
In 18 months.
No, I agree. Really, the point of the hearing the
paying to
state
play.
first is for the state to articulate exactly what it is.
And
that they're
Rambo
intending to
had
do.
access.
So that's my
Topic.
motivation in asking the state at this point to proceed.
So I believe they
for them
get
to identify on the record exactly which
You'll be a part of
incidents
us.
they are intending
You'll
to
be with
introduce.
us. You'll be a
And then I
victim.
will have the defendants
Nobody
argue
a
their various
question. You can
motions.
be with us.
Okay,
Let's have one more.
sure.
But they did it. They still did it. Allegedly. Excuse me. What you look at me like that for? I didn't look at you like that when you sneeze.
So if I'm looking at the state's motion, it looks like you're going back as far as 2018.
Yes, Judge. I am just looking at so many documents, just trying to find that one.
Yes, I understand. So it looks like pursuant to the motion itself, August 18th of 2018, Joe Rod Adams, also known as Spaz, was murdered at a Rains High School football game. Adams, it's alleged, was a 1200 associate. Robert Howard and Adrian Bibby Gaynor were suspects in the homicide of Adams. Howard and Gaynor are six block members, and Robert Howard was convicted and served a 5-year prison sentence for manslaughter and aggravated battery on that case. I believe Robert Howard was also a victim in this case, and he did testify in the Andrews case. The state also alleges or discussed in February of 2019, Adrian Bibby Gaynor was shot and killed in Jacksonville, Florida. Adrian Bibby Gaynor is known to be close with the victim, Charles Jones, and is associated with 6 Block. Hakeem Kuso Robinson and Leroy Scotty Whitaker, gang members of ATK, are currently charged with murder for the death of Gaynor. Then the state identifies August 16th, 2023. Jaquan Pickens, bully gang member, was shot multiple times and killed. Bully gang is associated with and allied with 6 Block. And then August 17th of 2023, there's an attempted murder of Jacoby Beals, a 1200 gang member. This shooting was believed to have been committed in retaliation for the murder of Jake Pickens that occurred the day before on August 18th. On October 7th, 2023, Antonio Tilley, ATK gang member, was murdered. Members from 6 Block claimed credit for the murder on social media. on the same day that Tilly was murdered. There, immediately after, there was an attempted murder committed against the victim in our case, Charles Jones. So I'm assuming, are those all of the prior incidents of gang violence that you are seeking to introduce?
Yes, Your Honor. That's what was outlined in my motion that we responded to, the motion for severance for Rashad Murphy. It's also what we have listed previously in all the defendants' case as under notice of inextricably intertwined evidence, Judge. Along with, there are some drill rap videos that also mention some additional gang members that we also intend to introduce. And Judge, it is the state's position that those 6 incidents, as well as the drill rap videos that we have listed in discovery as inextricably intertwined and evidence of motive, is relevant to this case against all of the defendants. First of all, the 3 defendants, Isaiah Chance, Rashad Murphy, and Davian Murphy, are gang members, and as part of our evidence requirement for proof for that particular gang enhancement, we have to prove that they were gang members and that this crime was committed for the purpose of enhancing or benefiting the gang in some way. And Judge, we are prepared to do that. As far as Sean Gathright, we believe that it is also admissible in his case. He is closely tied to Isaiah Chance, who is a known gang member. There is evidence that he is the supplier of the gun, as well as there is evidence that directly links him to the attempted murder of Charles Jones that occurred in October of 2023. We have listed the case law for this argument for inextricably intertwined that is directly relevant to gangs. In particular, I will again point to that Richardson case. What was very clear that there were 6 prior shootings that was introduced in that trial. That was a gang case that occurred again up in Jacksonville, where a child was shot and killed, and his grandmother and another woman in the car along with him were shot at but unharmed. And what the court went through is this whole argument about inextricably intertwined, and the state in that case was able to show to the jury through the documentation by the gang itself, that's how it qualified these drill rap videos, was the fact that this gang war was documented by the gang members themselves on social media, by not only drill rap videos, by social media postings. All of that was evidence of motive, and the court acknowledged that that was highly prejudicial, especially the prior shootings. But it was not substantially outweighed by the probative value of motive. And that is what this is in this particular case. It is motive. It tells why in Richardson, why that baby was shot, because there were gang members that were standing on the street where that baby and his family were. And it provided the explanation why that shooting happened, the motive. And it is the motive in this case, that historical gang war actually will show the jury all of the reasons and give context to why this shooting happened. And so it is highly probative. Motive evidence in any case has a very significant probative value. And the court went through that analysis and said that background, even the collateral crime evidence of the prior shootings, was not outweighed. That prejudicial effect was not outweighed by the probative value. And it is necessary for us to be able to actually explain to the jury what led up to this shooting, what was the motive, why they all came down to Tampa in one day for the specific purpose of shooting Charles Jones. And it all has to do with this back and forth gang war that is going on. 3 of the people of the 4 that are left are part of the gang that are allied together that dislike Charles Jones. Those drill rap videos, the evidence on social media that shows the back and forth, all of those are connected to these 6 incidences that we have alleged. In particular, Adrian Bibby Gaynor has a relationship the first one is the Rains High School where we start.
You can't say that without him.
Joe Rod Adams. I apologize,
Like
starting with that one. In 2018, he had the nickname Spaz, was a gang 1200 associate, and is related to the Murphy. So obviously, going back to that specific case, especially since Robert Howard, who is also a person that was with the victim when he shot and is a witness in this case, is relevant and gives history to the significance of the motive in this particular case.
Okay, and I'm not meaning to cut you off, and just so everyone knows, the first thing I really want to discuss and what I'm going to rule on today initially is regarding the introduction of the evidence related to the 6 specified incidents in the state's motion. All right, because then once I rule on that, then we can have a discussion regarding what drill rap videos and what other evidence is going to come in once I've ruled on the admissibility of the 6 previous incidents.
And Judge,
Okay?
I may ask for the assistance of Ms. Ismer. She is kind of taken over this area for us and covering with the state, and to some particulars, I may require her assistance in responding to the particular specific reasons why they're relevant to the case.
Okay, and that's, you mean as far as the drill rap videos or the actual previous incidents?
Both, Judge.
Okay, so yeah, so what I'm trying to say is that the any objections to any specific videos, I will address that after I've ruled on just the general nature of the gang evidence coming in. Once you all know the parameters of what's going to be admissible, then we can visit if there's objections to certain drill rap videos, whether or not they come in. Okay? Okay, very good. All right. Anything further before I turn it over to the defense, just with regards to the 6 previous incidents?
And okay. And Judge, I know that we probably will go through one by one, but some of the defense motion and limines that have to do with gang, there are several paragraphs that list different items. And so at some point, when we go through those items, I would like the opportunity to address those items.
Sure.
Okay. Thank
Absolutely. You. And one question. There was testimony that Joe Rod Adams is actually the brother of Davion Murphy. Is that correct?
Judge, there was testimony, I believe, by one of the detectives. They knew that there was a relationship. They had him referred to as a brother, but they were not absolutely certain as to whether it was a brother or a cousin. But they are sure that there is a relationship between both of the Murphys and Joe Rod Adams.
Okay.
But he did at one point believe that he was a brother to, I want to make sure, Rashad Murphy, and cousin to Davion. I now believe that is the reverse. Is that correct, Mrs. Smart?
The only evidence that we have to support the relationship is that there's a familial relationship, that they are cousins. There was some discussion, but proof as far as setting that forward at trial of a brother relationship, other than referring to them as their brother, is.
So I was going to ask you, what is the state's proof? Unless the defense is conceding that they're related. Mr. Gonzalez? Excuse me. Well, it'd be Mr. Gonzalez and then also Mr. Sonardi.
I'm sorry.
Well, Judge, I think it's the state's burden
I agree.
to provide testimony and evidence that they are in fact related in some way, shape, or form. So I would ask the court to defer to their proof in answering that question.
Okay. Same, Mr. Sonardi.
Same for
Okay.
Davion Murphy.
I'm just asking the question. Okay. So what's your proof?
Statements are calling Mr. Joe Rod Adams.
Whose statements?
Mr. Murphy and Mr. Davion Murphy and Mr. Rashad Murphy refer to Joe Rod Adams as their brother.
And was that in text messages or
In their interviews.
in their interviews?
Correct. More recently, there are phone calls which Davion Murphy has made with his mother, which indicate that the relationship is cousins. The detectives' evidence as far as following the gangs that they provided to us in preparing for the case were that the relationship established that they believed it to be was a cousin relationship. But the reference that we have is that they are brothers. I cannot tell the court whether that means that they are blood related or they just refer to each other as a brother.
Okay. Okay, very good. Okay, so who wants to go first?
I'll go, Your Honor.
All right.
Brian Gonzalez on behalf of Rashad Murphy. Judge, how the state of Florida gets to the point where they can elicit this type of evidence is the issue here. The second motion in limine, in addition to the Daubert challenge, requests that the court prohibit the admission of law enforcement opinion testimony and related evidence concerning alleged prior gang war history, hearsay-based gang intelligence, and purported uncharged gang-related incidents. It's our belief that the state is going to attempt to present to the jury a large and sweeping narrative that goes back 6 years, at least as referenced in the state's motion for pretrial ruling on admissibility, of a gang war in Jacksonville that includes multiple groups, dozens,
going back,
if not more, of individuals, a series of shootings and homicides going back to, based on their motion, 2018. This murder being in June of 2024. The state argues that this evidence is inextricably intertwined and that it establishes an underlying motive for this particular offense, the murder of Charles Jones. And it's our belief that that is not supported by admissible evidence. Through what now appears to be three detectives Nieder, Griffith, and McCullough, the state's going to attempt to introduce opinion testimony, which I submit to the court lacks or labeling historical violence as retaliatory conduct, and also utilizing a plethora and what is the primary basis of their testimony being hearsay-based intelligence derived from reports from other officers, confidential informants that are undocumented, lyrical interpretation of by opinion testimony of rap videos, a evidence of uncharged and unsolved shootings, wholly, by the way, unconnected with Mr. Murphy. And collectively, I believe it invites the jury to decide somebody's guilt, in this case, Mr. Murphy's guilt, based on association and propensity rather than admissible evidence.
Is he sweating?
The relief I'm requesting in detail is on page 2 of my motion, and the court will read that in her ruling.
And I'm sorry, we on your second motion in limine or third?
It's number 2, Judge.
Okay.
To that extent, the state is going to have detectives outline a history of this conflict going back to 2018, most of which are unsolved, and none of which are alleged to have been committed by Mr. Murphy. There will be testimony from detectives about gang affiliation as it relates to Mr. Murphy, as it relates to Rashad Murphy, as it relates to Mr. Chance. And there won't be any, I believe, as it relates to Mr. Gathright. The testimony is also going to outline the gangs themselves, the nature of the gangs, inclusive of their background and their history, sometimes going back to their inception, long before any of these detectives were involved in their particular investigation of those individual gangs, collectively or individually, and also how these gangs are not traditional gangs, they're hybrid gangs. They have no hierarchy, they have no rules, they have no consequences, they have no punishments, and that is an important aspect when we talk about how they differ from a traditional gang where one member does things only at the behest of other gang members or at the behest of the gang as a whole. There are individual motivations in these hybrid gangs that may not have any involvement, any other than an individual grudge or a particular issue between one person and another, that doesn't trickle down to any type of group gang type decision or plan. And that is the nature of it being a hybrid gang that mostly is derived historically based on neighborhoods or where you grew up. As it relates to testimony last week, Judge, and I'm going to run through this very quickly. Detective Nieder has 7 years on the job at the Sheriff's Department. He was assigned as late as 2022 to the gang unit. And at that particular time, he started working exclusively with ATK. He has taken 3 yearly courses at the beginner and intermediate level through HIDA, HIDTA. And these are 3-day organizational crime conferences where general gang intelligence is discussed. And they also do not provide any comprehensive instruction. And this is based on testimony from Detective Nieder, whether it be at the hearing or sworn testimony from his deposition. And that's set forth in the motion with particularity as to where the court can find that. He essentially admits during his deposition that the majority of his training and experience comes from on-the-job training and based on what other detectives had told him prior to him coming on board. Although he alleges that he speaks with a number in a group and on a regular basis, community members, they don't openly discuss gang details to where they are documented, to where there are reports, to where there can be testimony as to who they are. And certainly those witnesses will not be testifying in court. As it relates to Detective Drabeck, I'm going to pass him, as I understand by the court's ruling, that he's going to be testifying to this particular investigation in and of itself and will not be testifying to any historical information. As it relates to Detective...
Correct, not as a gang expert.
Correct.
He's a fact witness.
Yes, Judge. As it relates to Detective Griffin, he has been with the department for 16 years, but he didn't join the gang squad until 2021. And for him, he's been through that same HIDA training for 21 through 24, 4 weeks total. And he has never been qualified as an expert or given testimony as an expert. And essentially, he pretty much says the same thing as Detective Nieder says, acknowledging that his knowledge of 1200's activities prior to 2023 is very limited. And he does not have any witness with firsthand knowledge of any group dynamics. All of his testimony, again, is contextual inferences by unknown individuals that he cannot document. He can't tell us when, he can't tell us who, and he can't tell us with particularity what they say. As it relates to Detective McCullough, he began in 2022, and essentially he is in charge, and that's after a long standing history with the department itself, but again, in 2022, January, and he became assigned to 6 Block. He also went through the HIDA training. He also went through and did a couple of other trainings of general types, and talks about how social media downloads, rap videos, interaction again with community members would be his source of information, again with no particularized documentation of any kind in any way, and would not be able to testify to that if given an opportunity to testify to these historical issues. He also
he definitely got to be on something.
He was unsure exactly if he'd ever testified before as an expert. He does recall testifying a couple of times. He thinks just in front of a judge and the state attorney, which might lead me to believe it was either a motion or a sentencing. Doesn't appear that he's testified as an expert as it relates to any type of trial testimony.
Well, let me just ask the state something. Who are you intending to call as your gang expert?
Judge, 3 witnesses, Detective Nieder, Griffin, and McCullough. They each are.
So all 3 he talking about.
In a particular gang that is involved in this case, and all of them have years of experience in that gang unit monitoring these gangs.
So, but we can't have cumulative testimony.
correct, Judge, and we will not, it will not be cumulative. There may be one or two that we cover it all with one or two and not call the third, but we have just listed them under the abundance of caution if there's something that one of them cannot speak to.
Okay. We'll cross that bridge when we get there. So,
And Judge, it's my expectation that we will rely on one of them mostly for the expert testimony, but as far as the documentation, there is documentation. Each one of those gang members have been documented with field incident reports that are maintained by the specific person assigned to that gang. So there is fact-related evidence as well. So we are not intending on offering cumulative evidence.
okay.
And Judge, what I anticipate Ms. Doherty is talking about is a particular report where a person is documented as a gang member pursuant to statutory criteria. That we're not talking about testimony from people as to their gang history and what they do and what they did and what they might be accused of doing and how they relate potentially to a particular murder or a particular shooting. None of that. What Ms. Doherty, I believe, is talking about is the singular report where a particular person is documented as a gang member and under these criteria. And certainly you look at those criteria, and in and of that criteria are unknown interviews with unknown people.
Sure. So, but there's two separate issues here, right? Okay. So what we're discussing right now is the historical
Agreed.
evidence. That's all we're discussing.
I just wanted to respond to.
Yeah, no, that's fine. And that's what I'm focused on right now.
Understood.
What's the parameters of the historical evidence that's going to be permitted to come in? And three of the defendants, the state has identified for aggravators as being gang members or associates.
Correct.
And so that's a separate issue as far as the state's proof and who they're going to call to establish that. Okay. So I just want to make sure that we're clear what I'm focused in on at this particular moment is the history and how much of that's going to come in.
So I'm mistaken, because I thought Mr. Gonzalez said he was on to his second motion in limine, in which he's challenging expertise.
We are.
We are, and we'll get there.
Okay.
We'll
All
get
right,
there,
I
but
apologize.
I'm going to first
Hey,
deal
you heard
with
exactly what they were
the
saying
issue
and what
of
he's
the
talking
admissibility of the history of the gangs in Jacksonville.
Yes,
Okay.
Judge.
Did not
So
make-
in my motion, and I'm not going to go into it because I want to get to other things. I give the court what I believe, based on testimony of detectives at deposition, the backgrounds as to each one of the gangs themselves, 1200, ATK, 6 Block.
Because there are a lot of incidents, it looks like in your motion, Mr. Gonzalez, that the state's not seeking to introduce evidence.
They are, Judge, but they were testified to at deposition, and we did not know until we got this
Yes.
motion
Okay,
for
that's fine.
admissibility.
So, because at this point, the state has identified 6 instances, 6 historical events, and that's the universe at this point of what the state is seeking to introduce. So,
And I'm going to just touch on each one of those.
Okay.
Only those 6, not all the ones that are in the motion, because when the time I wrote the motion,
Right.
we weren't there.
Okay,
So I
very
will
good.
touch on those very briefly because they are in much more specificity and particularity in the motion. But I'm not going to just track the motion. I'm just going to try to give
Sure.
some bullet points on each one of those
okay,
circumstances.
thank you.
The gang war narrative, Judge, they are all listed, inclusive of the 6, in the table that I have in the motion. And I just would ask the court to look at that table. Now you can cut it down to those 6. Just gives an overview of each one of those circumstances. As it's reflected in each one of these detectives' testimony, many of those incidents remain unsolved. Certainly, in trying to determine who might be associated with what, there's not enough evidence to charge anybody with anything. None of these defendants, no one else that might be associated with any kind of gang. And therein lies, even at its root, a problem with what they would like to testify to as it relates to opinion that can't be buttressed by what I believe is admissible evidence, especially as it relates to Mr. Murphy. The states can introduce law enforcement testimony that establishes a victim, that talks about a perpetrator's gang affiliation, but no testimony about any one of these individuals specifically involved in any one of those circumstances, except for maybe some testimony as it relates to Mr. Jones's attempted murder on October 7th, because they're going to take a leap and they're going to talk about Mr. Chance and potentially Mr. Gathright, but mostly Mr. Chance. Without establishing this gang association, and I don't mean criteria under 874, I'm talking about evidence from witnesses. I think the state's intent here is to try to fill this evidentiary gap with testimony from one or more of those detectives, and they're going to cloak it as expert testimony or opinion. But regardless of whether it is, it's based on hearsay, it's based on speculation, it's based on contextualized inference, none of which is admissible under 702. So I asked the court to make that correlation as you determine these issues. Of the 6 incidents that we're talking about, take a quick glance.
Sure. So just again to recap, August of 2018, the murder of Joe Rod Adams.
Mr. Howard was convicted of manslaughter in that case.
Yes, he was, and will be a witness in this case, correct?
Oh, he will be a witness, and certainly we'll have an emotion limit on that. And I would, based on his deposition and based on his proffer, waiting to hear what he might say on the stand under oath about gangs.
Okay, well,
and about gang association.
And again, the only reason I raise that is because that's actually someone who will be testifying with direct knowledge of these incidents, right?
Direct knowledge of what, Judge?
Of the, he was convicted and served a 5-year prison sentence for the manslaughter and aggravated battery.
Yes, I believe he will testify under oath that, in fact, that's the case.
Which means he can be cross-examined.
Correct.
Which is my point.
Yes, Judge. And now what other contextual knowledge he may have about anybody here or gangs in general?
No, I
that's
know.
another story.
I'm just trying to draw the distinction between at least that incident. The state will have some direct evidence with a witness who then can be cross-examined, right?
Yes, Judge.
Okay, all right.
Now, I don't believe it will be as it relates to evidence that I'm suggesting in this motion is inadmissible or not inextricably intertwined. But nonetheless, we get there when we get there.
Right.
Judge Adrian Bibby Gaynor, Hakeem Kesu Robinson was charged in that case.
Right, that was from February of 2019.
Yes, Judge.
Okay, then we move on to August 16th of 2023.
Yes, that's Jake Pickens. That case is unsolved. Jacoby Beals is unsolved.
And that's from August 17th of 2023, correct?
That's correct, Judge.
Okay.
Then October 7th, Antonio Tilley, Jawan Mills was convicted on that case, but I don't believe there's any gang association based on testimony from detectives, and I'll get to that when I get to that individual case. And then we have October 7th, which is Charles Jones' attempted murder. Right. That is unsolved as well.
Okay.
So, Judge, while it might be reasonable to attribute some level of reliability to law enforcement intelligence that's derived from social media, in this instance, the basis for opining that groups, either in rap videos or in social media that no one's going to be able to testify to, right? Other than there was some. When, who was on it, what date, who said what, none of that the detectives are capable of testifying to. They can't testify to a rap video and their own speculation and their own opinion as to what that rap video might say. But when we talk about taking credit for something, because that appears to be a big issue, taking credit. The court might remember that Detective Nieder testified that taking credit is actually trolling. You're trolling the other side. You're disrespecting the fact that that murder occurred. You might even be lauding that that murder occurred or that shooting occurred. And certainly the state would like you to take the leap or allow a jury to hear or allow somebody to testify to. That's an admission of committing a crime. Yeah. And I would ask the court to look very closely as to whether or not that inference is admissible. Essentially, just briefly, Detective McCullough, when asked, are you saying they're claiming credit for some of these shootings? What do you mean by that? Well, they'll get on social media, Instagram or Spaces or Clubhouse, which is like a social media platform, and they'll just start talking about it. He got what he deserved, stuff like that, just claiming, basically taking responsibility for it. None of that insinuates anyone is taking responsibility for anything. They are rapping about it. And he says that in one part of his response, but then would like to suggest that basically they're taking responsibility, which again is an inadmissible opinion on his part that's not buttressed by any evidence. No one is specifically saying I did this. Well, of course, as we talked about, nobody gets on a video and says, I killed this guy. And I guess that's not what I was asking, but his answer is correct. People are not saying they're just taking credit for it. So what's happening in these social media posts and sometimes in these rap videos are the same thing that's happening at the same time out in the community. Somebody gets killed, there are thousands of people talking about it. People hate it, people like it, people laud it, people think it was deserved, people know what happened, so-and-so got shot, so-and-so was walking down the street. This is a community whereby social media, the ability to have knowledge and information is quick. And detectives testified to that. This is not relegated to one single group or one single person that knows about what happened to somebody. It's what they say about it. And therefore, we have to be careful. I believe the court has to be careful not to suggest to the jury and not to allow evidence that would lead a jury to believe that somebody had something to do with something when that's not what they're saying.
Right, I agree.
But those,
Judge,
the death penalty.
Talking specifically about the 6 incidences, I'm trying to talk as fast as I can. Joe Wright Adams.
Right.
The state is going to suggest that there's evidence to believe that Joe Wright Adams is a cousin of Rashad Murphy and Davion Murphy. This occurred in August of 2018, 6 years prior to this particular case. Detective Dishman was the lead detective in that case. In her deposition, she actually said that in investigating this case, that the argument developed over a girl. And it escalated. And at one point in time, Mr. Howard, a state witness, told a person, somebody's going to die on my 8. And then Dishman testified that she believed that Howard was talking about his friend, Lawrence Davis, who's called 8. That's the evidence of this gang affiliation in my mind. What ends up happening subsequently is that Biddy Gaynor is alleged to be a second shooter. He's not charged. Mr. Howard ends up either taking the rap or pleading guilty to a manslaughter on what was an alleged first-degree murder. And essentially along the way, the whole case falls apart because people recant what they were saying. They say they weren't telling the truth.
Right.
And they say they got threats. None law enforcement can't corroborate any of these claims.
Well, let me see this, Mr. Gonzalez. Let's just assume the state has evidence, enough evidence to go before a jury to make the argument that Joe Rod Adams was in fact had some close relationship. They even, whether or not they were actual family members, maybe refer to themselves as family members, whatever that may be. Wouldn't that be direct evidence potentially of a motive involving Davion and Rashad Murphy?
No, Judge. I think we have a significant remoteness involved. I don't believe that the jury should be led down a path that simply because one person was related to another, right, that would provide the modus to kill somebody 6 years later.
And remind me, and I may be getting, because I may be remembering, but was there not a video that Mr. Jones is performing in, or someone affiliated with Mr. Jones, where the grave site of someone's being desecrated? Am I remembering that correctly?
You are, Judge, it's another incident though, that's the town center shooting, but
Okay.
there are references.
Yes, Your Honor, that is correct. And it is of Mr. Joe Rod Adams.
Right. Right. So
That is
Joe
separate
Rod,
part.
right, Joe Rod Adams, and again, I'm just assuming for the sake of argument that there is evidence that there is some close relationship between the Murphys and Joe Rod Adams. He's murdered, and then Charles Jones actually makes a video where I think that they're pouring alcohol or something on the gravesite.
That's correct, Your Honor. So there was an initial video where it's believed that someone was urinating on the gravesite.
Right.
And Mr. Jones is alleged to have taken that a bit further and made an actual video with beverages or something.
Yeah. Yeah. I mean, okay. I just want to make sure I'm getting my facts correct.
And Judge, that's addressed in the motion when you get to it. As it relates to Bibby Gaynor, February 15th, 2019, 5.5 years prior to this murder, essentially, Mr. Gaynor is allegedly, well, not allegedly, he's killed by Hakeem Robinson, and essentially Detective Oliver was the lead detective in that case. He was deposed. That was unsolved for about 18 months. Only at such time as a jail snitch came forward and gave information that connected that murder to some type of retaliation, that law enforcement was able to make that connection and attempt to run with that particular theory of prosecution or theory of the murder. At this particular time, I don't believe that person is going to be testifying. It's hearsay. I don't believe that anybody is going to hear from a person who had direct knowledge of what happened or why it happened or under what circumstances it happened. I think that Detective Drabeck in his deposition stated that as it relates to Gaynor's murder, that although he was a suspect in Adams' murder that he wasn't charged with because everybody recanted, that he opined that Adams' murder was not the nexus for Bibby Gaynor's murder. That's what he says on page 29 and 30. Instead, he believes that the murder happened out of pure opportunity, not revenge, not retribution. And that's his sworn testimony.
State, just real quick, what's your response to that in regards to?
Your Honor, since the depositions have been taken of those detectives, Caso or Hakeem Robinson, very prominent ATK member, has since been convicted of that crime. And so understanding the defense's argument that the weight of that evidence could be that there's some other reason why that killing occurred, it is yet another act of violence which occurs months after Mr. Howard is arrested for the murder of Joe Rod Adams and killing the other person suspected to have been involved. So the 2 6 block members that are allegedly involved in the homicide of Joe Rod Adams in 2018, one of whom is arrested for that murder, the other of whom is killed in February of 2019, and then obviously now subsequently convicted of that murder.
Okay, thank you.
Judge, next briefly is Antonio Tilley, October 7th of 2023. Tilley, there'll be testimony from detectives again. And I'm not going to go over each time when I talk about testimony from detectives. The court already knows my feeling on how this testimony is going to be elicited from detectives and where they get the information. And I think at the root of the problem, it all is the same. So I'm not going to say that every single time, but every time I mention a detective and every time I mention what that detective is going to testify to, it's really under the same circumstances and same ability that he's going to be testifying to. Somebody else told him that we don't know who it is. Some social media post said it. Some Instagram Live said it. It's not documented. There's no report. There's no witness that's going to testify to
But
it.
can't gang experts testify to that?
No, Judge, I don't believe they can. Tilley was supposed to be an ATK member. Detective Anderson was the lead detective. Essentially, this was a contract killing. That's what the detective said who investigated the murder. And essentially, it was done by Jaquan Mills. Jaquan Mills is not a gang member. To my knowledge, and based on testimony from detectives, Jaquan Mills is not affiliated with any gang. Essentially, as I understand it, Detective Anderson testified that the suspected contractor is a guy named Paul Anderson, who is now doing a 25-year sentence for drug-related activity.
I'm going to say if
I
detective
don't believe
then we
there's
all
any indication
expert.
that Copeland or Anderson are related to 1200 or 6 Block, at least on any basis I know, unless somebody's going to testify to it now, and probably under the same premises that they're going to testify to everything else that they testify to. Anderson then did defer to Detective Nieder in his deposition, and essentially he said, my understanding is that Detective Nieder suggests that Tilly had something to do with Sedarian Copeland's son being shot. So that's potentially the reason all this occurred. We now get to October 7th, 2023, which is Charles Fulio Jones. Obviously, that case is unsolved as well. Now we start dovetailing into evidence I believe is, in fact, potentially admissible against one defendant and shouldn't be admissible against others.
Which is what?
Which is NIBIN matches between the shell casings recovered on October 7th at the scene and casings found in Sean Gathwright's vehicle. And essentially, Detective Nieder, based on the same analysis, is going to say that Jones was shot in retaliation for Tilly. And he believes that Isaiah Chance was involved. And his opinion is that Chance and Gathwright were close friends, spent a lot of time together.
Well,
and
the state's not going to be able to get into that.
well,
It's unsolved, and Detective Nieder is not going to be able to opine that he thinks Isaiah Chance was involved in the attempted murder of Charles Jones.
well, that's been what's been
I was about to say, they said it the last one, and you ain't say nothing now.
Am I mistaken? I'm mistaken.
Judge, we wouldn't go into that sort of opinion testimony. We do plan on presenting the physical evidence that ties him to.
They did imply that in the
statements he made through other, but not through the opinion of
Right.
the officer. They have not charged it.
Not relevant.
They did imply that with the what you call. Okay, I'm not tripping. Okay, Nicole. Yeah, they I'm like, this is the same judge and the same attorneys. They did imply that before, that the same exact casings that was found in that catcher would match the same shell casings from the attempted unaliving of Julio Fulio from the months before. So what, they can't put that. They implied, okay, come on, ShamWow. Come on, Cupcakes. I know I'm not crazy now. They did imply that. Because it was Chance's friend, right? Chance's friend and the Uber driver. Some girl set him up, said to come down there to where she was at. They pulled up. It was a abandoned house, and they jumped out and shot up the car, killing the person in there and the Uber driver. That was Chance's best friend, right? So what was it? The next day or the next weekend, they implied that it was Chance them because all of the stuff, all the ballistics matched that was Chance them that went down there to avenge his best friend. So, man, don't try to play
Murphy,
different.
And not admissible to Mr. Murphy.
Well, it's a conspiracy charge.
Judge, again, we'll get to that because that's what the supplemental. That's what the supplemental.
Well, that's a separate issue. So
right,
let's just
supplemental
stay,
issue.
let's just stay focused. So listen, no gang. If the state calls a gang expert, whoever it may be, they're not going to be able to
They're calling
opine
three
about culpability of anybody who hasn't actually been charged or arrested or proven guilty. So that's not going to happen.
Because certainly Detective Nieder was very clear when he said that Chance was upset with ATK.
Well, I understand. Law enforcement says lots of things in depositions that never come before a jury.
Understood. That's why we want to make sure that that's covered in a motion like this. Judge, in an incident by incident review, in addition to the other incidents that are set forth in the motion, but they don't matter anymore. Let's take these 6. We believe that it establishes that the state doesn't possess witnesses with firsthand knowledge capable of establishing gang membership, internal group dynamics of the gang, retaliatory decision-making, or coordinated action amongst these groups. Part of the reason being that they're hybrid groups and nobody is accountable for anybody else. And that is clear by the nature of the detective's definition of this type of association.
Sure. And I indicated in my email yesterday that you all would be given 20 minutes each. So I haven't been timing you, Mr. Gonzalez, but
I hope
I'm
you're
sure-
not, Judge. Don't start now.
I am not, but I'm sure the other counsel would like a chance to weigh in. So I'm going to give you 5 more minutes.
Yes, Judge. Your Honor, when we talk about Hayes and Richardson as it relates to
The admissibility.
yes, Judge, which is part of a large part of this, the severance issue as well as the intertwined evidence. I think that, Hayes and Richardson are co-defendants.
Correct.
They were tried together, but with separate juries, notably. And
And that's right, suss it out before you get in court and trying to argue this
Judge,
with a
there's
time frame,
no
and then everybody
problem
only
here. There's
like
no
the jury need help.
anti-
No, I know, not in
You're not
our case.
respecting the jury's
In
time.
Richardson Hayes, there was a brutal problem, which is why they had 2 separate juries, but the case was tried together.
And Judge, although the evidence is similar as to both of them, I think Hayes is a little more illustrative in its opinion. And essentially, in that case, what I want to make sure the court understands, my position, that this is a feud between PCE and 187. You've already heard, things about that, so you can understand the interrelationship. And essentially, these 2 gangs got sideways at a Kodak Black concert in November of 2015. And essentially, that spawned a street war between them that lasted approximately 76 days. And those are the intertwined evidence that the state admitted over objection in that particular case, which is a far cry from the level of alleged inextricably intertwined evidence in this case.
Well, in the Hayes case in particular, and for the record, we're referring to 338 7th 3rd 1123. In that case, the specific time frame as far as the historical gang evidence that was admitted was November 25 through January of 2016. That was the specific time frame. And I would just note for the record that in the Andrews case, I did allow Detective Nieder to discuss, I believe, the incidents of violence from which kicked off in 2023. Like you had the 2 incidents in the 2018, 2019 timeframe, and then there really appeared to be relatively quiet. And then in 2023, the violence cropped up again. So with regards to Ms. Andrews, I did permit Detective Nieder to testify to the history from the 2023. And I do believe, because Mr. Howard testified, that there's some evidence regarding the killing of Joe Rod Adams came in because he was actually a witness. So,
Fact evidence as to his involvement in that murder.
Right.
Judge, the big difference here is that in Hayes and Richardson,
About the same now.
firsthand knowledge, there were multiple witnesses that
It was real
testified that the
flexible, man.
defendants were members of gangs. They were members of the same gangs. They interacted with the defendants in this case, Hayes and Richardson. In fact, Mr. Bradford testified to what their street names were. He testified to they were both known as shooters in the gang and had participated in shootings in the past. That he, on many of the photographs that were entered, was able to say, I know that photograph.
Well, I agree. In that case, I don't see, and I'm not sure if the state called a gang expert or not, but in the reported opinion, the history of the gangs came in through gang members, correct?
Yes,
State?
Judge.
Yeah.
Which is the way it should be.
Well, that's why I asked you if gang experts could testify to that, and you said you didn't believe so.
No, Judge, I don't.
Okay.
I-
So I'll hear from the state on why gang experts can testify to that.
And so, Judge, if you court's read the opinion, you're not going to give me much more time. You're glaring at me. I get it.
I'm not, for the record, that's not a glare, Mr. Gonzalez.
I didn't want the record to
is
reflect that.
It's just a mindful look.
Yeah, Judge, and I didn't want the record to reflect that actually as it was said. If you go through those 2 cases, with Hayes being a little more illustrative, you can see the 180-degree difference between those cases and these. And one of the major arguments of Mr. Murphy is that in circumstances like this, That's what the state needs. They need a firsthand witness to corroborate. They corroborated the videos that were admitted, the witnesses, the firsthand witnesses. They corroborated the photographs that were entered. They went so far as to be able to corroborate the car that was stolen and used in the murder because Mr. Bradford, the witness, supplied it. They were to the defendants. They were able to corroborate the gun that was used.
And I don't disagree. It's a separate issue. So
Judge, at the end of the day, again, I would rely on the motion and the particularity it sets forth, and essentially tell the court that the state can only establish the connection between the charged act and the prior act by relying on the detectives, in my estimation, I believe buttressed by the case law, improper testimony of lyrical interpretations. We skipped through that part, but it's in the motion. And what somebody thinks something says without it being coded language, without it being a circumstance where this language is used over and over and over and over again, which would allow an expert to testify to it. I do not believe that any of these detectives should be allowed to testify as experts based on.
Real quick, was he the one who represented the fool that had that outburst? He can talk the ears off a donkey. You dang on right about that. He ain't letting up. He ain't letting go. I think he's trying to rope her into something that makes her go into, that ties her to you know who, so they can get another trial. He was. Yeah, he ain't gonna let up until he know he got his point across twice.
The arguments.
Don't blame him, though.
Also, those that are in the motion.
After what just happened.
I've included their depositions, Judge, which I think are really instructive when they're talking at length about their jobs and what they do and how they do it and how they get their information. I don't think the court has to rely on me. I think it's very clear in the depositions under oath. And finally, Judge, that they are drawing these clues from songs that are released by artists that are commercially viable. They can't establish gang affiliation other than maybe by 874 criteria, which I think is different than testimony that would allow this evidence to be relevant and admissible. And especially to show that there's a motive for these killings, it should be done with competent, non-hearsay evidence. And those prior acts are rendered irrelevant when they're not done that way.
okay, very good. Okay, let's see. Mr. Sonardi, do you have a motion as it relates to Davion Murphy on this topic? Or have you adopted Mr. Gonzalez's?
As to the 6 prior acts that the state intends to introduce, both as to Mr. Rashad Murphy and Davion Murphy, we will adopt the arguments of Mr. Gonzalez on behalf of Rashad Murphy, and also add that we can establish that Mr. Davion Murphy was basically incarcerated either in the Jacksonville County Jail and Florida State Prison from 1916 until almost to January 2023.
Do you mean 2016? You
Yes.
said 1916.
I apologize. Judge.
2016.
Oh, you need another attorney. He don't know where he at. He went from
January
1920 to 1968.
The same argument as provided by Mr. Gonzalez on behalf of Rashad Murphy. Mr. Davion Murphy is not alleged to be a suspect or anything in either of the 6 prior acts that the state intends to introduce. I concur also in the evidence that's available to even establish that Mr. Davion Murphy is in fact even a gang member of 1200. Again, he was incarcerated the 5-year window under the statute that expired. He is at most an associate. So again, we submit that contrary to the state's position, that introduction of those 6 prior acts as it applies to Davion Murphy.
Dang sure right.
So
Was born with up there and tell that 80s lie.
overcomes probative value. We would ask the court as to Davion Murphy to exclude that testimony.
Okay. And Sean Gathright, defendant's motion in limine to exclude collateral evidence. Mr. Wise.
Your Honor, I guess before I begin, maybe for point of clarification, there are, as you've heard, casings found in Mr. Gathwright's home that not even matches to two prior incidents. I think the only one that's of the six we've discussed is the prior Charles Jones shooting. So
Correct.
I don't know if the state it sounds like the state may not be seeking to admit evidence regarding these other two alleged incidents, one of which I don't think they know what or who the target of was. But could I just ask if do I need to address the Byron Walker incident and this unknown shooting from 2022?
We can speak to that. All the NIBIN correlations to the other shootings from the traffic stop as well as from the safe.
It's how they plan to try to get the other one
We're
in.
not going into. The only ones that we are going into were the ones that were actually confirmed, not just NIBIN, but FDLE
Right.
matches
For
to-
Mr. Jones.
Correct,
Okay.
the attempted murder, and then to our case here.
Okay, so that streamlines it a little bit.
Okay.
So, Your Honor, Mr. Gathwright's a little bit differently situated because he's clearly not a gang member. No one's even alleged that he was a gang member. As you heard from all of the alleged experts who testified, I guess it was last week, none of them had even heard of his name prior to being contacted by Detective Ramos. The only connection that the state has as to Mr. Gathright is this allegation that he was friends with Isaiah Chance. And even that, I think, is pretty speculative. There clearly were communications between Mr. Gathright and Chance, but I believe there's some thought that they must have been best friends. And I don't even think there's evidence to support that. The only thing connecting Mr. Gathright to these gangs is his communication with Chance. And quite frankly, I think that the connection between Mr. Chance and the gangs is pretty speculative as it is, but that's the only connection. So he's clearly not a gang member. And I don't believe he can even really qualify as a gang associate just based on the fact that he's communicating with Chance. But that.
Well, the state has not identified.
No.
And then, as far as I can tell, they're not seeking to prove that Mr. Gathright is a criminal gang member or associate, just a member of a conspiracy involving other gang members.
Judge, we're not approving an enhancement against him, but he certainly qualifies as an associate by the statute with his association with Isaiah Chance. And Judge, we believe it's the jury's decision to ultimately find who is an associate and who is a member.
Okay. All right.
And again, Judge, if that's the case, then basically everyone Mr. Chance has ever talked to is a gang associate. I know that's probably a separate motion, but when we talk about relevance of all these other prior gang activities,
That's exactly what they're getting ready to do.
connection, again, to Mr. Gathright is the fact that he's communicated with Isaiah Chance. Talking about each one specifically, the Gerard Adams incident, Mr. Gathright would have been 13 years old, I believe, when that took place. The Bibby Gaynor incident, he would have been, I believe, 14 years old. There's nothing connecting him in any way whatsoever to the Jaquan Pickens incident. Same with the Jacoby Beals. And the Antonio Tilley. The only connection, again, with the Charles Jones incident that takes place on the same date is the casings that are found in the NIBIN matches. But as you heard from the detectives last week, Mr. Gathright was not even on their radar in that case until the casings came back. So it's really just the mere fact that these casings are in the house. There's no explanation as to how they got there or whatnot. And there are, by the way, as you heard, there's a substantial amount of firearms and firearms evidence within the house that's searched. So that, Your Honor, I believe the relevance, whatever relevance would have all these incidences, and really the only one as to Mr. Gathright that could have any relevance whatsoever is the Charles Jones shooting. But the undue prejudice would far outweigh whatever relevance that evidence might have. I cite two cases in my memorandum that I think are remarkably similar to what we're dealing with here. And looking back now, I probably should have referenced them with regards to the severance issue too, but it's Thomas and Gilly. And it doesn't appear that these were cases that involved gang issues, but it was very similar in that there are prior shooting incidents involving allegedly rival drug dealers and then their associates. maybe they were connected with gangs, but it's taking the gang word out of it. I think it's really the same exact situation we're dealing with here. There were prior shootings, and then someone is killed in one of these prior shootings, and then there's a shooting that takes place of this prior victim's associates, and then a bystander is killed. So when the defendants are being charged with the shooting of the bystander, and Gilly, and it's not clear why he was severed, but he's severed and tried separately, the state brings in evidence of all these prior shootings, and that goes up on appeal after everyone's convicted. And in both cases, the second DCA says these instances were not necessary to describe the shooting. It was a pretty straightforward, the allegations of the crime they were actually being tried for were pretty straightforward. The courts found they did not need to get into these prior shootings to describe what took place. And it became, as I fear will happen here, a feature of the trial. And for those reasons, both of those defendants' convictions were reversed. And again, I'm not sure why they were severed, but it would appear that Gilly may not have had involvement in these prior shootings. I don't know if that's the case or not, but for whatever reason, he was severed. And it appears, based on my reading of those two cases, it may have been for that reason. But all this prior evidence comes in both cases, it becomes a feature, and in both cases, the convictions are reversed. And I think it's really the same exact situation we're dealing with here, especially as Mr. Gathright, because he really has no legitimate connection to any of these gangs.
Okay, very good. Thank you.
Judge, we would adopt that argument on behalf of Mr. Rashad Brophy as we would all other defendants' arguments.
Sure.
Same here on behalf of David Murphy.
All right, very good. Mr. Petratus.
We filed our own motion, but we would adopt the motions of Mr. Gonzalez and Mr. Wise in their arguments, and I'll try not to be too repetitive.
Okay. And this is Isaiah Chance's. It's titled Defendant's Motion to Exclude Inextricably Intertwined Evidence at Trial.
Yes, Your Honor.
Okay,
And just to go over the murders again very briefly.
You better get yourself away from it.
The Spaz shooting, which is a alleged 1200, not ATK, of which Mr. Chance is purportedly a member of. And I think it's important to know that Robert Howard, who's, as the court is aware, is going to testify, at his deposition denied being a gang member of 6 Block. So I understand that they're going to try to get it a different way, but they're going to get someone here, like Mr. Gonzalez stated in the Richardson Hayes case, but this time this person's going to say, no, I wasn't a member of 6 Block. Then we have a 6-month gap. We have the Gaynor shooting. That is alleged, well, it's not alleged, it was a charge of ATK. The next 4 that all occurred in 2023 are all unsolved. And no one is going to testify as that was involved in any of those shootings. You're going to have no gang members to come here and testify to that. In the Pickens, in the state's motion, it says ATK is believed to be involved. Again, it needs to go back to Detective Nieder. And the court asked, the court said you can't opine on someone who committed a crime that we don't have conviction. And I would argue that you can't opine the gang affiliation of a person who we don't know committed the crime. You can't, it's another step that requires Detective Nieder to opine. Detective Nieder, in his deposition, stated he gets his info mainly from social media. He does talk to gang members, but he gets general information, not specific information for them. They're not confessing to crimes for him. That's not what's happening. He's just getting general background information from them. And I would argue that's not enough to come in and tell us who committed these crimes and say it's ATK, it's 1200. The Beale shooting is alleged to involve 1200, not ATK. And as Mr. Gonzalez stated,
And I'm not about to do this with you. In there. Is that old one?
A gang at all. They're going to say that Mr. Gathright is an associate, but again, that involves being friends with one gang member at the most. In Richardson, again, it was 76 days, and the court said it's a continuation and consequence of preceding events.
Big old city look like dirt.
5 years ago, there's not preceding
That's
events.
probably the only trial Big Oak watched me every
we have an 8-month
day
gap
of it.
between the last
He thought
event
the man was going
in
to fall
this
over
historical,
on the thing.
gang war and this shooting. the court mentioned Griffin in the Richardson case. It said, to prove its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding these crimes charged, surrounding these crimes. In the Richardson case, again, 76 days. That happened one after another in a 2.5 month period. That is not what we have here. Richardson, one of the reasons they allowed it in, from my reading, was that they wanted to get the state why these victims were in fact the victims. We had a toddler and we had two elderly, or maybe not two, but an elderly grandmother and a middle-aged lady, and they wanted to explain how they could be the victims in that. That's not the case here. We have someone, Charles Jones, who is not a random civilian. There's going to be gang evidence presented about Mr. Jones. There's going to be gang evidence presented about all the co-defendants. There's going to be evidence of their involvement in the gang, testimony of a rivalry between ATK 1200 and 6 Block, all without the need to mention any of these prior shootings. The motive can be clear through the state's evidence without having to mention any of these shootings. And I think that's what the court should require. One other thing that hasn't been mentioned is these cases mentioned it cannot be a feature of the trial.
Correct.
And I find it hard to believe that if the state puts on 3 gang experts and then all the witnesses, and I'm going to use witnesses in quotes, to come in here and testify to show the other murders 6 times, that's days. It's
Well,
days
yes,
of testimony.
no, and I do just have a little experience because the Andrews case, that's not what happened. Detective Nieder testified in his capacity as a gang expert, just historically, as far as the history of the gang violence. The state did not bring in, my recollection, any witnesses other than Mr. Howard, who was a victim in this case. So.
We're talking.
Got 4. Come get all the kids.
Not that I saw. This was going on in Judy courtroom. We still live in Judy courtroom. Judy. They're still deliberating. We live. Oh, excuse me.
And I understand that, but I think that's going to be different in this case because I think they're going to try to bring in more.
Well, we'll see. You're right. It cannot become a feature of the trial.
And I find it, well, I understand, but I just find it hard to believe it will not end up being a feature of the trial. If we're talking about 6 other murders. I don't know if that's exactly what happened in the other case, but
I got them
everything
both.
else that I would get to is either in my motion or has been stated by the co-counsel. So that's all I have.
Okay, very good. All right, state any quick rebuttal just as to the 6 previous incidents that the state wishes to introduce
Judge,
into evidence.
Judge, we are certainly not going to make it a feature of the trial. We do plan on calling one detective to really go over the historical gang war, so it will not be a feature. However, we are going to add
And who's that going to be? Do you know?
Judge, we believe it's going to be Detective Nieders. The other 2 are listed because we still have to show gang enhancements and stuff of that nature, and I do believe their expertise adds
Sure,
to.
that's a separate issue.
That's a separate issue.
In the indictment, the state did specifically allege that Isaiah Chance, Rashad Murphy, and Davion Murphy were either criminal gang members or associates.
That is correct, Judge.
Okay, but not Mr. Gathright.
We did not, Judge. But Judge, there are going to be, I know that Mr. Gonzalez has kept saying like this is all based on hearsay. That is not true. There were some additional witnesses that were listed that were involved in those 6 other cases. And again, it's not going to be a feature. What I plan to do, Judge, is to have either a first responder just testify briefly within 2 to 5 minutes that they responded to that homicide, who the victim was. And then the gang expert is later going to connect up that victim was actually a member of one of these gangs. And then the next day, these are real things, real facts, real deaths that did happen.
and the victim of one gang is killed, and then the next day a victim of the opposite opposing gang is killed. And so, Judge, this jury should have a real, true, accurate picture of the very gang war that is going on. And these incidents also, even though they exceed the time frame, I understand what they're saying about Richardson and Hayes, the particular of that gang war, the escalation of violence, but it was 6 shootings that occurred back and forth, happened in a very short period of time. It's different in this case, but the incidences that we have selected are relevant to this case. And some of the relevance doesn't even have to do with any of them. It has to do with the victim and as a consequence with all of them, because the victim in this case, the motive for, and obviously one of the rap videos that we're going to introduce, and the motive for why they did not like him and were very upset and angry enough to kill him is his drill rap videos. And certainly that also
I know you crazy. My grandma's birthday
our
was
gang
14.
experts' testimony. They do have specialized knowledge. This is something that they all have years of experience in this gang unit where they are monitoring this activity on social media. And it's not hearsay. They are visually monitoring it, and they see a death happen. And then within 2 or 3 days, sometimes within the very next day, there is a video that is posted detailing and ditching the person who was just killed.
Well,
all of that.
desecrating someone's gravesite is pretty provocative behavior.
Yes, Judge. All of that is part of this gang war back and forth. And the jury needs to have an accurate view. And some of this is highly prejudicial towards the victim because the victim is out there doing the same thing, which makes him a target. And he is dishing and disrespecting the close members, people that we can connect to them, either through their wearing necklaces. They have posted their own videos, Judge. All of that is relevant to this case and is inextricably intertwined and shows why he was targeted and why he was killed. And Judge, when you talk about the hearsay, that is why we have listed either a first responder or the detective. Detective Nieder actually responded to some of those incidents. So we are not going to call 6 witnesses, but certainly the ones that he did not respond to, we have just listed a first responder, or we have listed the detective who actually went on scene and can say, on this day I responded, this person was killed and his name. And then we will go to our detective to say that that is a confirmed member of 1200, or that is a confirmed member of 6 Block or Bully Gang, which is a subset of 6 Block. So this by no means is going to be a feature of the case. And all of these detectives, even within the depositions, were honest and said they didn't know that that was an unsolved case. But certainly after a case where a victim is identified as a gang member and the opposing group then posts a video claiming credit, making fun of that victim's death the very next week or within a short time period, certainly that is a specialized knowledge, and it goes to the very heart of this case and the very motive why our victim was killed. And the probative value of motive, wanting to kill the victim, has a high value, and it is not going to ever be outweighed by the prejudicial nature. And that is what Harris and Richardson really explain when it let in 6 other shootings into a case, because it gave the jury an accurate depiction of the war, the escalation of this gang war, which led to those 3 people being shot and a child being killed. And so, Judge, that is what we have here. The prejudicial nature is not so significant. Some of these deaths are from our victim side killing the other side. The ones that are targeted, they are not charged with, and none of the detectives said, with the exception of the attempted murder. And we know we're not going to elicit what their personal opinion may be, but certainly there is going to be physical evidence that ties this as part of the conspiracy, that they tried to kill him before and they weren't able to do it. So certainly all of those incidents, even though we go outside of that time period in Richardson and Hayes, are still relevant. They're inextricably intertwined, and those specific cases are tied to our victim and the defendants in this case as being relevant and again, highlight the animosity between these two groups. They're making fun of people that are killed back and forth. Some of these shootings within the very next day, including the attempted murder of Charles Jones, was done the very next day after members of the opposing side, one of their members was shot. And so that is the state's argument that this is all relevant. It is not going to be a feature of the case, but it goes to the very heart of all of this group's motive to kill Charles Jones, the victim in this case.
Okay, so in the Hayes case, the court stated as follows, and get the page number. At page 1130 of that opinion, in establishing its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding the crime charged, but cannot make the evidence of other crimes the feature of the trial or introduce evidence solely for the purpose of showing bad character or propensity. Collateral crime evidence, regardless of its status, similar or dissimilar fact evidence, is admissible if it is inextricably intertwined with the charged crime.
I was about to say, ain't that what little Rambo's mama said? If that's the case, I'm
inextricably intertwined if it is necessary to 1, adequately describe the deed, 2, provide an intelligent account of the crimes charged, 3, establish the entire context out of which the charged crimes arose, or 4, adequately describe the events leading up to the charged crimes. Additionally, evidence is admissible if the prior incidents are relevant to several material issues, including motive, intent, and identity. So based upon the facts and the motions and the arguments of counsel, I am going to find that the 6 identified incidents in the state's motion in limine are inextricably intertwined, and they are relevant to motive, intent, and identity. Okay, so those, just as a threshold, those 6 incidents are admissible in this case. All right, I'm going to take a recess. And so actually, before I do that, so as it relates to the state's motion in limine regarding those 6 incidents, I'm going to grant it. Let me take a look here. I'm going to grant the motion, but I'm going to reserve ruling regarding the introduction of any videos, any rap videos that the state seeks to introduce. And once the state does their evidence list as far as what they're actually going to attempt to introduce, then if there are further objections as to any individual videos, defense can renew their objection and I'll rule. Okay. All right. So as to Isaiah Chance's motion to exclude inextricably intertwined evidence at trial, that motion is denied.
I knew that was coming.
Defense, as I indicated, can raise contemporaneous objections to any individual items of evidence. And with regards to Sean Gathwright's motion in limine to exclude collateral evidence, that is denied.
No, the inextricably intertwined portion is what she denied. And if y'all think about it, as much as we love to call him Little Rambo,
that's Little Rambo.
Little Rambo was this one down here. That's the one whose mama was in the army, and she had all them safes and stuff, and he had the access, had all the catchers and everything. He got caught with all the casings. He also, Little Rambo, got Big Rambo. His grandmama said, "My baby ain't got no guns. That's his photography equipment. Them was big cameras and lights and poles for the cameras."
It definitely poles.
So, but if you think about it, everything that's inextricably intertwined around Chance around Isaiah Chance is what connects Lil Rambo to the gang. Because Lil Rambo off solo. He don't have no craziness up besides him and Poppers. Him and his tools. Everything else, they don't have him as far as his only connection to the gang is Chance. So if she would have granted that motion, that would have removed Gathright from anybody but Chance, but removed Chance from Gathright and removed Chance from the dang on Murphys. That would have been the end of the damn trial for real.
However, again, defense has the ability.
Well, and can I add, because I actually specifically addressed those other two instances, the state is not seeking to evict, so could that be?
Yes, it's denied as to the 6 incidents that are in the state's motion that I've articulated here today. It would be granted
need
to
to keep
any
them
other
together, otherwise this whole thing
that
doesn't make
are not part of the 6.
30-year-olds,
And that goes as to all
17-year-old don't make no sense.
Okay, so we're just talking, so it's denied in part and granted in part. Thank you for that clarification, Mr. Wise. And then as to Rashad Murphy's second motion in limine, there were a number of items, Mr. Gonzalez, that you raised. At this point, it's denied in part only as to the 6 previous incidents that I articulated here today. Okay. All right, we'll take a break and I'll be back at 10:50.
Court's in recess.
A.M.
Is that March 30th, the court said?
March 31st.
Yes, Judge.
Okay. Mr. Sonardi, Mr. Wise, Mr. Petratus at work?
Yes.
Okay. All right, March 31st at 10 a.m. We'll call it a status and final motion hearings. And I think my JA is working on the seating chart for jury selection for the seating chart for final motion hearings. Me, what works best as far as the last round of motion hearings?
Probably the 31st, I would think.
All right, how does that work for everybody? Okay, so can I say 10 a.m.?
Is that March 30th, the court said?
March 31st.
Yes, Judge.
Okay. Mr. Sonardi, Mr. Wise, Mr. Petratus at work?
Yes.
Okay. All right, March 31st at 10 a.m. We'll call it a status and final motion hearings. And I think my JA is working on the seating chart for jury selection for the 150 where they will be. So I will give that to you all when I see you on the 31st. Okay. All right. Okay. Moving on to Defendant Rashad Murphy's fourth motion in limine, opinion identification testimony. And I think Mr. Sonardi filed a similar motion for Davion Murphy, defendant's motion in limine to exclude law enforcement from interpreting or narrating video surveillance.
We did that, Judge.
Pardon me?
We did that, didn't we?
Did,
No.
no,
I don't think so.
no.
Your Honor, Mr. Murphy's fourth motion in limine relates to opinion identification testimony. Again, we've been having a lot of discussion, a lot of argument with these types of areas of evidence. The state intends to introduce a large volume of digital media during the trial, surveillance videos of the shooting at various locations, music videos, as the court's aware, some Airbnb footage, surveillance footage from different businesses, surveillance footage from different jurisdictions, Jacksonville, Polk County, Hillsborough County. And again, the state is going to rely on law enforcement, on the detectives to identify Mr. Murphy in any of those recordings.
Yeah, I see in, but it looks like they're saying
is
4.
He's located.
4 o'clock.
In
I
general,
got that.
Judge,
We live in there. I got it.
pursuant to Bentley versus State, a witness can only testify to the identification of someone depicted on social media when the witness is in a better position than the jury to do so. And obviously, age-old proposition. And I cite Bentley at 286 Southern 3rd 912, second district case. And it would suggest that when evidence is such that the witness is in no better position than the jurors to make an identification, then that witness's opinion is inadmissible because it invades the province of the jury. Moreover, in particular in this case, is that law enforcement officers are not permitted to offer an opinion identifying a defendant in digital media unless that witness, that officer was an eyewitness, had a special familiarity with the defendant, or is otherwise qualified as an expert in identification. And that's citing Proctor and Charles, which are cited in the motion. It's my belief, Judge, that no member of law enforcement in this particular case, based on depositions that have been taken and evidence that's been elicited in motions, is in any better position than a juror to make an identification in this particular case. In Mr. Murphy's circumstance, I anticipate that, number one, there will be rap videos that the state has still shots of where they will attempt to identify Mr. Murphy in them. And my position would be the jury can look at Mr. Murphy and look at the still shot and determine whether or not that is Mr. Murphy or not. Certainly, law enforcement, all of them, have had a relatively minimal amount of time over even the time that they've been in the gang units, based on testimony, to have interaction with Mr. Murphy and to see Mr. Murphy on multiple occasions. And so with that in mind, as it relates to that particular identification, I believe the only other thing that, other than people testifying, I've seen Mr. Murphy, but I can't tell you where, and I can't tell you when, and I can't tell you with who, would be that there is Jacksonville footage where it is alleged that Mr. Murphy is getting out of a vehicle, an Uber vehicle, and there is surveillance video from that house that would be admitted for the purposes of identifying Mr. Murphy. In that same circumstance, and that based on that same premise and the law surrounding it, my suggestion to the court is that a police officer can't say, look, there's Mr. Gathright, he's getting out of that car. There's Mr. Murphy, he's getting out of that side. There's Miss Andrews. Court, I believe it was probably introduced in the Andrews case. There's Miss Andrews, she's getting out of that car. I believe that the jury can make that determination. It's their province, and no law enforcement detective is in any better situation to provide and authenticate that evidence. So With that in mind, Judge, I'm asking that you prohibit identifications from detectives as it relates to Mr. Murphy and any digital media that is alleged that he is in.
Okay, very good. So who's arguing this motion for the state?
Judge, I am.
Well, don't, and do you concede that Bentley versus State at 286 7th 3rd 912, which is a second DCA opinion from 2019, that's basically what the law says, right? That in
Judge,
general, a witness may testify as to the identification of persons depicted in photographs or on video when the witness is in a better position than the jurors to make that identification.
Judge, I do agree with that. Judge, generally, I also am going to provide the court with some case law as well, and that's Johnson v. Florida, as well as Cop v. Florida. And in Johnson v. Florida, there was an officer who was allowed to identify a video and still photographs extracted from a video because they were in a better position than the jury. In particular, it was not from prior, but for instance, if the officer is aware of the defendant's appearance, that how they look at the time of the offense, and if it has changed. So for instance, Mr. Chance, the defendant over there, his hairstyle is much different and shorter than it was at the time when this offense was committed, where he is being viewed on a Ring camera. And so if you look at Johnson v. Florida, it's a 4th District court case where in this particular case, an officer is in a better position to be able to identify the defendant based on that scenario, how they looked at the time of, and it is not prejudicial because it was limited to that officer's familiarity with the defendant at the time of the crime. So it doesn't go to any sort of prejudicial nature of any sort of prior contact that they had with the defendant. And again, I also provided the court with Cop v. Florida, and this is where a security guard who never identified himself as a security guard, who had a bunch of numerous contacts with the defendant in that case, and he had watched the video several times and was very familiar. But in that case, it was a grainy video, and he was able to testify and identify, but not say that he was a law enforcement officer. So, Judge, the two cases I've presented to you, and in this case, when we're talking about the video of the scene, there are 3 individuals.
Your Honor, we are back on the record in the Judy Church matter, and the jury has a verdict.
So we've been informed the jury has a verdict. They're lining up. They're coming into the courtroom in just a moment. I just want to make sure that everyone in attendance understands that there's to be no reaction to the verdict, whatever it may be. I expect everybody to remain composed and stoic, and I expect everyone's best effort in that regard. With that, we can bring the jury.
Anybody here always hear Judge Everett in these situations? Mrs. Adelson, control yourself. Uh-oh, now. They said prison. You going to prison? Where y'all at with it? Guilty or not guilty? Speak now or forever hold your peace.
Remain standing. All orders be seated.
Mr. Foreperson, has your jury agreed upon a verdict?
Yes.
May the court have the papers, please?
Thank you. The verdict is in order, and you may inquire.
Come on now.
Mr. Foreperson, what say you to indictment 2377 CR 14001, charging the defendant Judy Church with murder in the first degree? Is the defendant guilty or not guilty? And if guilty, guilty of what and on what theory?
Guilty, offense as charged, deliberate and premeditation, and extreme atrocity and cruelty.
Bye, Judy.
Mr. Foreperson and ladies and gentlemen of the jury, hearken to your
Bye,
oath.
Judy.
The court has recorded it. You, upon your oath, do say that the defendant, Judy Church, is guilty of murder in the first degree on the theories of deliberate premeditation and extreme atrocity and cruelty.
Now, I was low-key wondering if the experts that they put on
So say you,
in
Mr.
lieu of
Foreperson?
regular witnesses
So say you, all members of the jury?
Yes.
Yes.
Actually
Would you like
help
the jury to
Judy.
uphold, counsel?
Yes.
So say you, juror
Again,
in
since
seat
they were
number
going
one.
this long, we
Yes.
just under 9
So
hours.
say you, oh, I'm sorry, juror
Of
in seat number,
deliberation.
it's okay, sorry, juror in seat number one. So say you?
Yes.
Juror in seat number two? Yes. So say you, juror in seat number three?
Well, there's the
So say
justice,
you, juror in seat
Leroy.
number five? Yes.
They're
So say you,
polling the
juror in
jury,
seat
and they
number
all
seven.
say she is guilty of
So say
first
you,
degree
juror in seat number eight.
premeditated, intended,
So say you,
unimagined
juror in seat
Leroy.
number nine.
They said she put
So
that
say you,
rain
juror
X
in
in
seat
his
number 10.
Powerade
Yes. So
and
say
let him
you,
try.
juror in seat number 11. Yes. So say you, juror in seat number 12.
Yes.
So say you, juror in seat number 14. Yes. And so say you, juror in seat number 16. Yes. Your Honor, may the verdict be recorded.
It may.
Thank you.
Please be seated, jurors. Please be seated, everyone else. Jurors, I make no comment upon your verdict. As I've told you over and over again through the course of this trial, that's exclusively your prerogative. I would like to thank each and every one of you and our 4 alternates for their service in this case. I'd like the opportunity to thank each of you in person. If you're able to stay around for just a few minutes, I'll come down to the jury room imminently. But if anyone needs to leave right away or simply wants to leave right away, I certainly understand that. My thanks to you right now will have to suffice. You have fully discharged your responsibilities as jurors in this case, each and every one of you. So I am now excusing you and discharging you once again with our thanks and gratitude.
All right.
Prison. Let's see when she gonna be sentenced. Or he gonna do it right now? Because she just get an LWOP, right? Or maybe, I don't know. Let's see.
Let's set a sentencing date. I suggest later this week. Wednesday would work well for me.
That's later?
Is it possible to do Thursday or Friday? I have to be here both of those days anyway.
I could do Thursday in the morning. I can't do the afternoon. Mr. Narkunis and Mr. Scully.
Judge, may we have a moment to confer? We both have matters we've been trying to have to catch up on as well.
Certainly.
Thursday, Judge.
All right.
Oh,
Let's do
so it's a
Thursday.
miracle that dentist that shot through the door.
Thank you all. We'll be in recess.
Court, all rise.
They said we coming back Thursday. Did they say Wednesday or Thursday, y'all? Thursday, okay.
Are they gonna let me?
She recorded 13 videos over 30 minutes, friend, of him groaning and falling over. He couldn't hold himself up. He couldn't sit up. He couldn't hold himself against anything. And she said, look what you did to yourself. Look what you did. She claimed it was for educational purposes, that she was going to show him later what he had done to himself. All right. Bye, Judy.
Not be
presenting any sort of evidence from any of the officers in this case as to who those individuals are. However, the main case detective in this case, Detective Ramos, when he is
And we watched
questioned as
videos.
to or cross-examined by defense if any door is open as to how many people are involved in this crime and if certain builds and stuff of that nature go to how he put this case together. Certainly that isn't a statement of identification, but that goes towards his investigation and him looking at builds and stuff of that nature to circumstantially be able to put forth that case. But as it goes to the ring videos, and again, defense attorney, Mr. Rashad Murphy, he is not captured on that ring video. Some of the other defendants are, and some of their appearances have changed. I believe that Johnson v. Florida, as well as Cop v. Florida, give us the right to be able to have law enforcement. For instance, Mr. Isaiah Chance, the case detective, met with him on 3 occasions. One of those meetings that he met with him was for several hours. And because his appearance has changed, and if his appearance is changed from when the crime occurred, that would be appropriate for us to do.
Okay.
And Judge, as far as the videos and the wrap, again, we do plan on, based on expert testimony, I think, which is separate and different based on their part of their job to identify known gang members and studying of videos. And in those videos, there is significant change in appearance as to weight, as to hairstyle. The one that particularly that Mr. Gonzalez is talking about, it was a much older video, so we would want to lay the foundation of exactly when that video was first presented. The defendant had much longer hair and was much thinner at the time of. So we do, again, plan to present expert testimony in that area based on what they were supposed to do and monitor videos, and were tasked with identifying all the individuals within that video based on their expertise. Obviously, it would go to the jury, the ultimate question, whether or not they truly believe that person is in the video.
Okay.
Sure, although I haven't.
Hold on, wait, but.
Yes, I apologize. Well, I said Johnson v. Florida, 93 Southern 3rd, 1066, and common spelling Johnsson, and then Cop v. Florida, KOPP 314 Southern 3rd, 451.
Okay, hold on.
Judge, although I haven't had a chance to read Johnson very, very closely at this particular time, I would note that I don't believe expert testimony changes the foundation of this case law when they're talking about detectives versus gang detectives, and it's not distinguishing as to whether or not a jury is in as equally as a good position to make an identification. As it relates to cop, just looking at it very quickly, I would suggest to the court that it is distinguishable because, as Ms. Doherty said, the videotape is very grainy. It did not provide clear images, and zooming it only worsened it. And therefore, because of that, the witness in that case was allowed to make that identification. And based on what I certainly have seen, I can only tell the court that that is not the circumstance, either in the still photographs that I'm aware of or the video when it's run in real time. So to the extent that I believe cop is distinguishable, I believe the court still should rule in the same manner.
Okay, Mr. Sonardi, any further argument?
On behalf of Davion Murphy, Judge, yeah, we have filed a similar motion to preclude, obviously, any of the state's witnesses, be it experts or anyone else, from in any way narrating the videos. That includes surveillance videos and any of the rap videos. We would indicate that is the province of the jury to determine what, if anything, those videos depict or identify. And again, we are dovetailing on the motions of Mr. Rashad Murphy.
Okay. Okay, so the state.
I'm sorry, I didn't know that we were talking about the motion to narrate. Can I just briefly respond to that?
That's fine. That's fine. I'm going to reserve ruling on that part anyway. But yeah, go ahead.
Judge, with regards to, we're not, obviously not gonna put up any of the witnesses to narrate. However, the surveillance videos, I do
Fran, I
like to
think
question
they
on direct examination and the
have
sort
some
of
challenges.
areas that are
I think the
important
crazy
to
one
the
right there
state
that seemed like he
detective
might be
assist in
medicated
explaining that, like where
was
the
trying
cameras
to
are
act
set
as
up,
his own lawyer,
and
acting
any
out.
sort of
They were
questions
trying to
that go
sever.
towards his investigation.
It was a mess in the
As far
beginning.
as the rap videos, we're not gonna
Then
narrate the
Alicia
rap
ended up getting
videos
severed
either, but
because she
again,
wanted her
questions
speedy
are gonna go
trial. Then somebody
towards
got
the
sick, so it
gang
got put back
expert
anyway.
as to some of the
Okay.
significance of what is happening in that video and how it is pertinent and relevant to this case.
Okay.
Judge, and one of the things, since I read Johnson, and I apologize, one of the main reasons the court allowed the identification in that video is that the defendant, after the commission of the crime, had bleached his skin. And certainly that turned out to be a very significant change in his appearance that would have given rise to the fact that the detective had spent hours and hours and hours with him prior to the commission, post-commission of crime, that he could make that distinguishing identification.
Okay. Okay, so as to defendant Rashad Murphy's fourth motion in limine regarding opinion, identification, testimony, it is granted, as that is the controlling law pursuant to Bentley v. State, unless there is an exception, and specifically as noted, exceptions would be if the quality of the video is poor, or if in some respect the defendant had changed their appearance after the offense was committed. Those would be the types of exceptions. So the state just needs to be prepared to articulate what would be the exception to Bentley that would allow the law enforcement officer to identify anyone in the video.
Yes, Your Honor.
Okay. And then with regards to defendant Davion Murphy's motion in limine to exclude law enforcement from interpreting or narrating video surveillance. As far as identity, it's granted, which would be subparagraph A. That's granted. Again, unless there's an exception, and if the state's going to seek to have the witness, the law enforcement witness, issue an opinion as to identity, you just need to be prepared in advance to tell me what the exception is. As to the narration, subparagraphs B and C, I'm going to reserve ruling on those. I just need to hear the evidence as it comes in, and you just need to make a contemporaneous objection.
And Judge, that would relate to all defendants?
Correct. That applies to all defendants. Okay. All right. Thank you. Oh, do me a favor. Attach these two to the back. Okay, thank you. Okay, all right, let's see here. I have defendant Rashad Murphy's fifth motion in limine regarding irrelevant evidence. And okay, go ahead.
Oh, you got to do
Judge,
something better than that.
understanding the court has made some rulings already this morning, whether they be reservations of rulings or rulings. Again, there's some dovetail in this motion. It's several different categories of motions, and without being overbearing, I just want to make sure that the ones that have been reserved on or ruled on, the court will identify it for me one more time, and of course those that need to be ruled on, you do so. The first category, Judge, is NIBIN evidence. There are TPD analyst Sarah Price conducted NIBIN analysis of 9mm casings found at the homicide scene. She reported that those.
I can this up a little bit.
Okay.
I'm agreeing to the NIBINs, as previously stated. I think A through E are ones that I've already stated that we are not going to go through,
Okay,
because that's not the attempted murder of Charles Jones.
got it.
All right, let me just take a look. When you say A through E, are you referring to what?
So on page 1 of his motion, he lists, I think this is what he's talking about.
Okay, yeah,
There's A through E.
okay, and you're agreeing those are not covered.
Yes.
Okay, so it's granted as to paragraph 1, items A through E on defendant's fifth motion in limine. Okay,
Judge, next items, and before I go off the rails, casings seized from Gathrights vehicle. I believe we've discussed those already earlier this morning, did we not?
We did, except one of the casings goes to the attempted murder of Charles Jones. I'm not agreeing to that one.
and which one is that one? Is that A or B?
Judge, I'm trying to look at,
I think B is the one you're referring to.
yes.
It is.
It is, it's B.
So you agree to A and C, correct?
Yes.
Okay, so it's granted under paragraph 5, A and C of defendant's Rashad Murphy's fifth motion in limine. Those are granted pursuant to stipulation of the state. And then is there any further argument as to item B?
Only, Judge, that it has been the fodder of argument in other motions as it relates to A, inextricably intertwined evidence, which the court has ruled upon, but also as it would relate to the court's inquiry, which we'll probably get to at the end, as to evidence that is admissible potentially to a defendant or one defendant and not admissible to another. And my argument later will be that the casings found and the identification to the Charles Jones attempt on October 7 would not be admissible as it relates to Mr. Murphy.
Okay.
And I assume we're going to talk about that later.
Okay. All right. Well, as to that specific item of evidence, the motion in limine will be denied. Okay.
Third, Judge, would be firearm related evidence. The first would be Mr. Gathwright's vehicle search. I believe the state indicated that, and please correct me, I'm wrong, that those items found in Mr. Gathwright's vehicle you're not going to seek to admit those? Okay. Judge, as the court can see in paragraph 10, on June 26th, as a result of Mr. Gathwright's vehicle, this is another circumstance where we would ultimately later be arguing, pursuant to the court's request, that these items that are found in Mr. Gathwright's vehicle, all of which do not have any direct correlation to the instant murder, first and foremost, and secondly, certainly don't have any relationship or relevance as it relates to Mr. Murphy, should not be admitted. And again, would dovetail into one of the reasons for severance, that this evidence is not relevant to Mr. Murphy. It occurs on June 26th. Obviously, one of the tenets is what happens outside of the conspiratorial temporal time frame, and dovetails into the question that the court asked about co-conspirator statements versus evidence that that is found, let's say, in the possession of a co-conspirator. And
Maybe
that's dealt with in my supplemental filing.
With you on this,
I'm sure
but I
read already, but
try
it'll
it.
take a short amount of time when it's appropriate to argue that. So that is the next category of evidence that I believe should not be admitted and is irrelevant.
Okay. State what's your response. Are you seeking to admit all of these items, 10A through R?
Judge, yes, we are.
And they're not connected to the charged offense in any respect.
Yes, they are, Judge.
Okay. Well, okay. Mr. Gonzalez, are you done?
I am.
Okay. So, Ms. Doherty, why is this relevant?
Judge, first of all, he is a principal, and if you look at the box of the new Straight Talk prepaid phone that is in Gathwright's vehicle, as well as the prepaid car, and there is a receipt saying that he purchased it on June 6th. We also have evidence showing that he also changed his iCloud account and opened a new iCloud account on that day. Also, within the same vehicle is a piece of paper with several phone numbers. So immediately 2 days after this crime, Mr. Gathwright gets a new phone. His phone that was utilized in the crime, where he's communicating with the second vehicle, is never located. We can show that he purchased it 2 days afterwards. The note that is found with all the phone numbers so that he could program his new phone include the defendant, Rashad Murphy's phone number, the shared phone number that he has with Charmaine Steiger, is specifically written out, and it doesn't say Rashad Murphy as the person belonging to that number. It says GH. Again, his nickname is Ghost, so there's a direct link to the co-defendant. Another number on there is G. The nickname for Isaiah Chance is Gutta-Zay or Gutta-Man. That number matches his number specifically. So these are physical items of evidence, and he is a principal. All of the defendants are principals, and so these relevant items of evidence that pertain to the guilt of one defendant certainly is admissible if we prove the other defendants, all of the co-defendants, are principals to the crime, and we certainly will prove that they are all principals to the first-degree murder, as well as some of them are principals to the attempted murder of the 3 other individuals. Judge, if we go back to all of these other items, they are relevant to what we know about the shooting. We have video evidence of how this crime occurred, which 2 AR style rifles were used, and 1 9mm Glock that had a switch on it. And so all of these items that they have listed on there are relevant because they are either fireable in the AR rifles or attachments that could go to the AR rifles that were shown to be used in this crime that was captured on video. And in particular, the Max Tech 9mm ammunition. They say 2 boxes of unused 9mm Lugo. That actually there was a brand, and that was a Max Tech brand of ammunition, which was the exact brand of ammunition of the shell casings left at our scene. So certainly those are very relevant to the crime. And again, principals, they are responsible and are put in the same shoes of each person that we have proven committed and participated in this crime if they did something to assist. So all of these evidence that are listed, that we did not put in everything that was found in the car, but just the items that we believe are relevant to the actual firearms that were used in this particular case. And Your Honor, may I have 1 moment?
Yes.
It's not the trial yet, Miss Stephanie, but it is the next to last motions hearing before the next
Judge,
4 go
again, the other connection
trial,
to
April
this
13th,
particular,
2 weeks.
all of these items being relevant to this case. Again, it's 2 days after our crime was committed. We know, and we have evidence that Mr. Gathright was in the suspect vehicle, the Chevy Impala, which he drove and left purposely at his grandmother's house in Polk County. And he was seen by his grandmother moving several items from the Impala into this vehicle.
Well, Rambo Mama says she ain't confirming nothing without a serial number. You hear me?
Again, another connection to this crime. We have items of evidence that are significant and relevant to how this homicide and attempted homicide occurred here in Tampa.
All right.
Judge, I would only respond that, again, I don't believe the fact that because the state is setting forth a theory of principles, and because they're setting forth that it's their theory of a prosecution, that this particular phone is a phone that was purchased by Mr. Gathright, not by Mr. Murphy, in order to replace potentially, as a theory of prosecution, a phone that he no longer wanted anybody to have, doesn't get it any closer to being admissible against Mr. Murphy, nor do I believe, and again, reserving argument for the court's question as to evidence as opposed to statements as it relates to co-conspirators, the fact that none of these items have a direct relationship to the crime at hand certainly is extremely prejudicial, and not the kind of prejudicial evidence I would suggest to the court that happens just in cases in general. It far is outweighed by its prejudicial value, and that is especially not as much to Mr. Gathright, but as it relates to Mr. Murphy and, quite frankly, any other defendant.
Okay.
Next, Judge. Oh, I'm sorry.
Okay, so I'm going to deny the motion as to paragraph 10, items A through R. All right, next up would be the paragraph 12, the items from the residential search of Mr. Gathwright's residence?
Yes, Judge. On the 27th, a day later, Mr. Gathwright's home was searched. There are 2 AR rifles equipped with black mesh brass catchers and 2 spent 9mm. The 9mm were recovered. Oh, they matched casings recovered from the homicide scene, but in a kind of a unique situation, the court might remember, they could not have been fired at the homicide scene because there were the requisite amount of casings found on the 9mm that would have filled the firearm. I'm not a firearm expert or even eloquent as it relates to firearms, but the point being is that Detective Ramos subsequently testified, look, we now know that what was found in Mr. Gathwright's home could not have been fired that night, but certainly that doesn't preclude the fact that there is a match between those casings and this casing. So maybe it was fired from the same firearm at another time. So my argument essentially is the same as it relates to the admissibility of this evidence and its relevance and relationship to Mr. Murphy, and albeit something that may be considered relevant or admissible as to Mr. Gathwright, not so as it relates to Mr. Murphy. Number one, again, far outside the conspiratorial time frame, and secondly,
Lord, I ain't gonna lie, y'all.
doesn't have any direct relationship to Mr. Murphy.
Girl, if I was Alicia, I'd be scared to ask for another one.
All right,
Manslaughter was
are
definitely
you seeking to
emotional.
admit these from Mr. Gathwright's
Verdict.
home? Items A and B.
If I can, I'll speak, if I could, Your Honor. May I have authority to counsel?
Sure.
I'll speak
So
to.
she get another trial, and Isaiah's chances, like they might try to DP her.
Specifically. So the 2 shell casings are 9mm shell casings. Just like the ammunition found in Mr. Gathwright's vehicle, they are Max Tech brand 9mm shell casings. 31 shell casings were found at the scene, 9mm shell casings. All Max Tech brand ammunition. So this is the same brand ammunition. If you recall, in the Andrews case, Bernard De Jesus, who was on scene post-fact, did some interviews, testified, and a predicate was laid to his knowledge and expertise in firearms. And he testified, based on his knowledge of Glock firearms, that the, quote, stick magazine, which is an extended magazine that is utilized in Glock firearms, holds 33 rounds. 31 rounds were found at the
verdict
scene.
she got let me know that
seen her student different big one on that stand.
In his opinion,
it didn't
during the
match
trial must have fell into the brass
because I don't think what you guys are accused of or how that boy was taken out of here was man
one of the
at all.
other shooters
That was
rifles that
thought
nearby,
out, pure
because the brass was
personal
ejected in the
rage.
videos towards the direction of the rifle shooters. So that is the relevance, physical relevance of the evidence. And I can let Ms. Doherty speak to the relevance to Mr. Murphy, Rashad Murphy.
And Judge, again, he is a principal to the crime, and all of the physical evidence that are related to the crime would be admissible in his trial as well. Even though it's found in another co-defendant's house, it is a part that has ballistically been connected to the homicide. The 2 AR rifles both match the appearance that are the 2 AR rifles that are used in this case. There isn't a ballistic or forensic link because none of those shell casings were left at the scene. So we could not do a comparison based on that. But we know that they had brass mesh brass catchers, which we can definitely see that in the video. So it is definitely very relevant, very probative, and the defendant is charged as a principal, and that evidence certainly would be admissible in his case as well.
Okay. All right. Anything
Judge,
further?
before I go on, just 2 particular statements with regard to that. Number one, the brand is there's nothing unique about this brand of ammunition. It is a common brand of ammunition that it's sold regularly in virtually every gun shop in America, and has no direct relationship to this homicide other than the fact that the brands are similar. Secondly, the appearance alone of those AKs should not be the basis for admission simply without any type of forensic connection whatsoever. It certainly its prejudicial value outweighs its probative effect. And that's what I would say with regard to those items in Mr. Gathwright's residential search of 627.
Okay. I'm going to deny the motion as to items 12A and B. Their probative value outweighs any prejudicial effect. Okay. Moving on to the items recovered from the search of Isaiah Chance's home.
Judge, on the 27th, the same day, soon thereafter or simultaneous with Mr. Gathwright's residential search, Mr. Chance's residence was searched. There was a Glock 9mm with an extended magazine, some ammunition, Generation 5 Glock ammunition, notes that detail how to utilize, I guess, a Glock switch. None of the evidence seized from Mr. Chance's residence, to my knowledge, had any evidentiary connection to the charged offense or to Mr. Murphy. And for those reasons, Judge, and essentially with regard to the same argument, except for the fact in this particular case, I think it's one step removed from items found in Mr. Gathwright's possession, home, or car, and that is that these items have no direct evidentiary connection.
Okay. State, why are these admissible as being relevant?
Judge, I'm agreeing to the Glock 9mm pistol with extended magazine and the box that it belongs to, because we did compare it to our shell casings and it was determined not to be the Glock that we're looking for or that was used or licensed in this case. I am going to object to the notes detailing the Glock switches in the notebook, because in this particular case, one of the assailants was using a Glock that had a switch on it. So I do think that that is relevant to this case. In another video, a ring video where
now how is that relevant?
Right before,
if there was a 9 with a Glock, okay, so if there was a switch on that one, but you found notes for what a switch is or how to use the switch with the wrong 9, why can you then say that notes with the wrong 9 that don't match none of your casings, well, they're relevant notes because there was a switch used with a different one? The notes is with the gun to go with. I don't think Little Rambo needed notes, allegedly. If it was his, that's all I'm saying.
Where they come to Tampa on June 22nd of 2024, Isaiah Chance can be seen to have in his possession what appears to be a firearm with a switch on it. So it is relevant to that case, especially when we have video footage at the scene, and based on the scene as well as the projectiles that were left behind, we know that we are dealing with a Glock switch firearm.
And when it says notes detailing,
are all switches with only one universal switch go on everything?
Judge, there's so much evidence of this case. I would like the opportunity. I don't want to
Are they
mislead
handwritten?
you.
Okay, you just don't know.
Judge, I don't know. I can't remember specifically, but I can't. It's been a while since the last trial.
Okay.
It seems like
Now, in the eyes of Chance, that just took him away from. No, he didn't pop, but we know for sure he didn't pop in. His gun is inadmissible because it don't match nothing. Now he just looks like.
Okay, I'm going to reserve ruling on that one, which is C.
In the car with Alicia. So does he get man-slizzy too?
To a Generation 5.
Granted, Judge, the state stipulated that.
You stipulate.
Yeah, Judge, we know that the Glock and the particular one that was located is not the gun. Yes.
So paragraph 14, items A and B, the motion's granted.
Now I will say, lawyer by heart, my mind was going the same place, but they've always been able to rattle off every part of this rap beef, every part of this gang war, turf war, every gang, every subset of the gang, every mixture of the gang. They So at what point have we ever heard Barney say, there's so much evidence, I'll have to look, I don't know. Ooh.
Item 14C, I'm going to reserve ruling just to give the state a chance to clarify what exactly it is, and then we'll go from there. What the notes are. Okay. Moving on to the bully down poster.
Yes, Judge. During the course of the search of Mr. Chance's room or a house, in his room, there was a homemade poster that signified the phrase bully down. Bully down, according to testimony by the detectives, is again, gaining that knowledge through the same manner in which they gain the majority, if not all, of their information in their day-to-day activities, is allegedly a subset. Bully down is a subset group of the gang. And whether they're suggesting that Mr. Chance So bully gang is a subset of 6 Block, potentially, allegedly adversary to Mr. Chance. And these are bully down. And the suggestion, and I assume the testimony is going to be, that signifies a diss, or that signifies that bully goes down, something of that nature. Again, they're saying it's in direct disrespect aimed at Fulio or at Charles Jones. Again, under most of the same theories I've been arguing, that Mr. Murphy has no connection. There's been nothing to suggest that Mr. Murphy had anything to do with making that poster, with aligning with that particular mentality or statement, if it's just a creative statement based on the word bully down. And that although the state alleges a conspiracy, again, we're back to the same conspiratorial window, and whether or not items and acts are different than conspiratorial statements. And so all of those circumstances combined would suggest, and of course, I don't need to tell the court as I go along through all these things, the admission of those things are part and parcel of the reason that I believe that severances should be granted. But I don't believe that they are relevant and admissible as to Mr. Murphy.
Okay, state, what's your response? Why is this admissible?
Judge, it is a poster that they find, which the expertise from the gang will show that this particular, it's kind of a thumbs down poster in reference to the bully gang, the subset of 6 Block. Not only do we have the expert testimony as to what that means, we also have the interview with Isaiah Chance where Detective Ramos specifically asked him about that sign. And there is some acknowledgement on his part, because he starts kind of laughing, acknowledging that they had that. As well as particularly with Rashad Murphy and those videos, we had taken still shots from the videos that certify him as a gang member. He is making that same bully down symbol, the thumbs down kind of symbol in reference to that particular gang. So there is all kinds of connection, Judge, as to the relevance of that located again in a co-defendant and principal to this case.
And is it your position that the evidence of this poster would be admissible against all of the defendants?
Yes, Your Honor.
Okay. All right, I'm gonna deny the motion. Next step would be the Walmart cell phone purchase.
Yes, Judge. In the 24 hours before Mr. Jones's murder, The defendant purchases several items on video from a Jacksonville Walmart, including a prepaid cell phone. Initially, Detective Ramos testified that he believed that this defendant purchased that phone in order to use it during the course of the homicide. Later, however, he confirmed and testified that the purchase of that phone was entirely unrelated to what he originally thought. The phone itself and the purchase of the phone has no relevance to the charged offense, especially as it relates to Detective Ramos's testimony. And the admission of the phone would create a risk that would invite the jury to draw some type of, unproven and unsupported evidentiary link between Mr. Murphy and Mr. Gathright, simply because of the nature of two straight talk phones being purchased by two individuals who are alleged to be principals to this particular crime. And it would infer a propensity unrelated to any materiality that this phone has, especially after further explained by Detective Ramos under oath.
Okay, state.
I'm in agreement with that. Although we are still going to present evidence of Walmart and what the defendant was wearing. And
Right.
There is a photograph that shows the phone that we do not intend to introduce based on or mention the reason of the phone, but the reason that it is necessary is because there is a black boot that is definitely identifiable in that photograph, as well as the rest of his clothing is pertinent to this case and what he's wearing. But we're not going to go into the specifics of purchasing the cell phone or what it was used for. I think that based on their investigation, they did discern and learn that it was going to be smuggled into a jail. We're not going to go there.
Okay, so it's granted.
Judge, lastly, there are still images on Mr. Murphy's phone. The court is going to do a written order with regard to the motion to suppress the cell phone. If that were to happen, this would be moot. To the extent that the court denies that motion, a full extraction of Mr. Murphy's phone was not possible because law enforcement damaged the phone without intent, but nonetheless damaged the phone while it was in their custody. And they were only able to get a manual review and extraction from that phone. There were screenshots that were extracted from that phone, 4 of them. Number one, on June 19th, at 1:29 p.m. Eastern, there was a screenshot of a homicide scene that a Young and Ace song was tagged. Again, without getting into the many number of different ways in which that image in of itself, and then the song in and of itself could have gotten on that phone, that's a story for potentially another day. But it's that image, number one. Number two, a day later on the 20th at 11:02 p.m., there's a photo of 2 rifles that were documented. They are similar to those used in the homicide, but they are not tied to the homicide in any way, shape, or form other than their appearance. June 22nd at 3:09 a.m., there's a photo of a bag, and I assume, again, this is a bag showing a Straight Talk Wireless phone, the phone charger, the packs of cigarettes. These are things that were purchased at Walmart. If the state is on the same vein, I suspect they may say, okay, we're not going to use that. But the photo itself, because of the boots that are being worn in the black pants, certainly is relevant. I'll let them argue as to that. On the 22nd, also at 7:26 p.m., there's a screenshot of a text message conveying instructions on how to enter the prison and retrieve a Walmart bag. I would suggest for the same legal basis that I have argued previously that these photos, screenshots, pictures are inadmissible. There's no evidence to establish the identity of the people who originally posted those images to social media. And even if authenticity could be determined, the images that are unrelated to this particular homicide have no relevance. I go into a little bit further argument as it relates to the tagging aspect, and essentially the tagging of that song, although we can't suggest that Mr. Murphy had anything to do with that. In addition to Young and Ace being a gang member pursuant to testimony from gang detectives, he also is a labeled artist that gets millions and millions and millions of views with regard to all of his different songs. And they are not all drill videos, and they are not all videos that troll or disrespect other people. It is an entire litany of a music catalog. Again, Judge, the state cannot link those firearms to Mr. Murphy in any respect, other than the fact that that picture was sent to him and was on his phone. And in that light, Judge, I would ask the court to prohibit their admission.
Okay, state, are you seeking to admit paragraph 26, items A through D? And if so, why?
Yes, Judge. 26A, the screenshot, it was posted, this is a shared phone to Rashad Murphy and Charmaine Steiger. This is a phone that Ms. Steiger originally said shared, and they equally used, and was found in the defendant's possession. Later, she has
Right, put away that job.
solely.
So obviously, get take it out and praise you, Christ. Listen, I can only imagine my mama. She's been put out that courtroom.
We would be willing, there is a Jacksonville homicide scene that is part of it. We would be willing to redact that out. What we are interested in here and what is relevant to this particular case is that on that day, he is tagging Young and Ace's song. And that was captured in a screenshot. And obviously, Young and Ace is the member of ATK. He's one of the founding members, and predominantly in some of these videos that are directly relevant to this case, including videos that were posted after the victim was dead, detailing his death, that were posted a few days after the homicide.
They live in a gated community.
As to the photos of the two rifles, they are sent June 20th of 2024 is the timestamp that is in the defendant's shared phone. Again, these two phones match the appearance of the rifles that are used in this case. And there is another connection to Sean Gathright. That same photo is found in Sean Gathright's phone. So that is very relevant, highly probative, and outweighs any prejudice significantly. On June 22nd, that photo, again, we're not interested in the phones and anything else in it, but that is the one photo that we have. It's not really discernible in the video footage from the Walmart of the type of boots that he's wearing, and he's wearing black combat boots. That and everything else that he's wearing matches one of the armed mass shooters in our case, and this is a day before the homicide occurs. June 22nd, the screenshot of text messages with instructions to prison security gates, we are agreeing not to go into that.
Okay.
Judge, I only have one short 2-second rebuttal, and that would be as it relates to item A, Judge.
What was the Young and Ace's song that was tagged?
I do not recall. I don't believe it's one of the ones that the state's going to be entering. That would be number one. It is not one of those songs. And second of all, Judge, they said the defendant tagged this song. They don't know that, and I could be wrong. My understanding is anyone could have done that. That's the way it came. And to suggest that there's a link because Mr. Murphy tagged that song, I don't think that's exactly the circumstance. Anyone could have tagged that song. It's on the phone, but I don't believe there's any evidence that would suggest it's Mr. Murphy that did so.
Okay, so just so I'm trying to understand exactly what this is, it's a screenshot on Mr. Rashad Murphy's phone that depicts a homicide scene with the Young and Aces song tagged as part of the depiction of the homicide scene. Is that
And it's kind of a
correct?
faraway shot, Judge.
We can show you on our computer if you want to see it.
Yeah, let me just. And remind me, what is this relevant to, state in your opinion?
Judge, it's relevant because Young and Ace, who is a member of ATK, this again is going to be corroboration of the gang expert's testimony that 1200 and ATK are allied, and they're allied against 6 Block. And again, this is on Rashad Murphy, a documented member of 1200, and it is relevant because he has on his phone a screenshot, and just like Mr. Gonzalez says, it's going to be at issue attribution, who this phone is being utilized for. We have it with Mr. Rashad Murphy when he's at the Walmart. We have it in the vehicle, the suspect vehicle, when he is arrested. And of course, it never comes to Tampa. So this is a shared phone between him and his girlfriend, Charmaine Steiger. But obviously, with the additional other information that is located on that phone that is relevant to this crime, any sort of connection to the gang is important and probative. But again, this is I know we are not suggesting this Jacksonville murder. We have been explained that it is a Jacksonville youth that is depicted in that picture. We would redact that out. We're not going to go there. I am more interested in the fact and that Young and Ace's song is specifically tagged and is screenshotted on his phone.
By someone and could have gone to tens, if not hundreds.
On Keisha, they saw two
Right, I understand.
kids. Not even that they was young and dumb, but that they wanted it
So
so bad.
I will, on 26A, state
They
stipulates.
wanted to
it's
be a
not gonna
part of
introduce
so
the
bad.
photo
He was
of
willing
the
to not think.
Jacksonville homicide, so it's granted as to that and denied as to the remainder of 26A. 26B is denied, 26C is denied, 26D is granted.
They had their own
Okay, I
little
think that's
arsenal.
it
They
from
had
that
their own
motion,
vehicles.
correct, Mr.
Judge, 26C granted in part.
Well, it's a photo. The photograph itself does have relevance because it does show the person in the photo with the, according to the state's theory, the similar black combat boots and black pants. So that, for that purpose, it is more probative than prejudicial. So I denied it. Denied the motion and limited to keep it out. So I think that's it for that motion, correct?
Yes, Judge. Yes.
Okay. Okay, Davion Murphy, defendant's motion in limine.
Judge, we've obviously, Nixon argued again for Davion Murphy. We've argued the certification of Mr. Davion Murphy as an associate of gang 1200, so we're not going to reiterate that. That's already before the court. We're arguing paragraph number 2, and that is that the state may intend to introduce the fact that there was a gap of about 6 months from the time that the warrants were issued for Mr. Davion Murphy's arrest until the time that he was in fact taken.
I think it was the boots, the pants, and the was the belt, kind of studded belt or something.
All that they have, basically, as I understand it, is the time frame itself, and not that I'm aware of. In fact, as we speak, I'm still not absolutely certain how it was that Mr. Davion Murphy was even identified to be arrested. That I don't have that information. But we would allege that there is no consciousness of guilt simply because of the time frame from the issuance of the warrant for his arrest and the time that he was actually arrested.
Okay,
Just, I'm sorry, what motion are we on? Because
it's Davion Murphy. It's titled Defendant's Motion in Limine. And in that motion, Mr. Sonardi is asking, one, that the defendant's prior certification of being a gang member of the 1200 gang be excluded. Two, the approximate 6-month lapse in time of the defendant's arrest following the issuance of defendant's arrest warrant. And three, photos of the deceased victims. What are you referring to when you say the photos of the deceased victims?
I'm sorry.
When you say photos of the deceased victims.
Right, the autopsy photo, oh, I'm sorry, it should be victim.
Yes, that confused me a bit.
I'm gonna ask the court to reserve on that, and we wait to see which photos exactly the
Okay.
state intends to introduce, we can address it at that time.
Okay. So are you now with me on what motion this is?
No, Judge, I don't think I have that one actually, but I can, if we go one by one, I'll be able to respond.
So the first one is the defendant's prior certification of being a gang member of the 1200 gang. And are you talking about a gang expert testifying as to Mr. Davion Murphy being previously certified before he went to prison? Is that what you're referring to?
That certification expired because of the 5-year lapse, so now he's been designated in some manner, allegedly as an associate with the 1200 gang.
Okay, so state, do you agree as far as the prior certification?
Judge.
Sure. No, Your Honor. I think that Mr. Sonardi's argument is regarding the earlier certification from Jacksonville
Right.
and Mr. Murphy's affiliation there. He still meets the statutory criteria. So it changes nothing about the state's argument because he went to prison and then in prison still met the criteria just under the cutthroat gang instead of a 1200 designation. So he still met the criteria. If the argument is that Jacksonville would be permitted or not to testify that he was in fact documented in Jacksonville before he went to prison, then the state has no objection. That's accurate.
That's what I'm hearing, is that you're talking about the previous certification
Correct.
before he went to prison.
Correct. And my understanding is under 874 that previous certification expires after
Right.
5 years. And that he would have to be recertified, which he was not. He was designated as an associate.
Right, which is what the state's seeking to prove, that he's an associate, not a member, correct?
That Mr. Davion Murphy
Yeah.
is a gang member.
I thought you told me associate.
Judge, I believe he is.
He meets all of the criteria for gang member before and after.
I thought I read somewhere that Isaiah Chance, member of ATK, Rashad Murphy, member of 1200, Davion Murphy, associate of 1200.
Member of 1200. The only associate label that has been lodged against any defendant is for Sean Gathright because of the criteria of association. Davion Murphy, both before and after his release from prison, met more than one criteria.
Yeah, the yes.
In the indictment?
Well, I'm not clear exactly as to what it is, the criteria that the state is relying on to certify Mr. Davion Murphy as a gang member of 1200.
Yeah, I don't know. I can't recall now where I read that because I had made a note a while ago that the state was seeking to prove that Rashad Murphy and Isaiah Chance were members and Davion Murphy was an associate.
Correct.
So since there appears to be some confusion, I would suggest a.
Judge, I can speak to that.
Okay.
Early on, when we went to the grand jury, he was qualifying as an associate based on the prior certification and the fact that after he went to prison, Mr. Sonardi is correct that they were purging their records. However, based on the fact that he still had that tattoos, he still met the criteria of associate. Mr. Harmon has uncovered some Department of Corrections that we are working to get the STAR report, which shows that he still, even when he went in prison, was connected to a gang. It was a prison gang. And so factually, we believe that we would be able to present enough evidence to the jury to show that the defendant was a gang member and met the criteria when the offense occurred.
Well, correct. We don't have that evidence. That I
Right.
understand the state's, what the state's intentions are at this juncture, but
Right.
we do not have that.
We do in fact have multiple.
Okay, it's
offenders from the
supposed to
gang.
be one attorney per motion, just so you all know. So for the state, I need one person to argue this motion.
Judge, we apologize.
Okay, it's fine. So, this needs to be sussed out a little bit more, it sounds like, because I was under the impression the state was going to attempt to establish he was an associate, but it sounds like Mr. Sonardi, now they're going to attempt to establish he was in fact a member. So regardless, it would be at the time of the offense, and his prior certification would have lapsed, expired, right?
Judge, the prior certification was based, or should be based, if there is nothing within the 5 years, Judge. That is not accurate.
Okay, so tell you what, okay, I'm going to reserve ruling, Mr. Sonardi. We just
Okay.
need to see how this,
How we can sort it out. Judge.
yeah, how we can sort this out. And state, if you've got additional evidence, you need to get it turned over ASAP.
And Judge, the majority of the evidence has already been provided. There is just an additional STAR report that we're waiting on.
Okay. And then with regard, are you going to argue consciousness of guilt for the lapse, the 6-month lapse between when the offense occurred until
Yes, Your Honor.
Okay, based upon what?
Judge, there was a high-profile media press release that was done both by the Tampa Police Department as well as the Jacksonville Sheriff's Office when the first when the arrest warrants went out for all of the defendants. There was a press conference that was done, and 3 of the defendants immediately were arrested. And there was a various attempts by Jacksonville Sheriff's Office to locate Davian Murphy in Jacksonville, and he was able to evade law enforcement for several months.
So you've got witnesses who are going to testify what they did in an attempt to locate Mr. Murphy and take him
Yes,
into
Your Honor.
custody?
As well as the video footage of the defendant the day that he was taken into custody. There are several statements that he himself makes when he's waiting for law enforcement to come into the room, where he is talking about how the best place for a person to hide is in plain sight. So there are statements that are made by himself on that video that shows a nexus that he was purposely hiding from law enforcement in this case.
Okay. All right. As to item 2, I'm going to deny the motion. That sounds like a weight versus admissibility. So reserve ruling on paragraphs 1 and 3, and then deny as to paragraph 2.
Thank you.
That's it for that motion, right?
Yes.
Okay, very good. Thank you. All right, Isaiah Chance, motion in limine. I think we may have covered a fair amount of this
We have,
already.
Justin Petridis, on behalf of Mr. Chance. For number 1, judge prior crimes, I'm really talking about 3 things. The October 7th attempted murder of Charles Jones, but I don't think the state's going to, I think they've stated they're not intending to.
They're not going to, no witness is going to take the stand. If it's an unsolved homicide, no witness, including law enforcement, is going to take the stand and say, well, I think it was.
Sure.
No one's going to opine.
And that goes to my other issue was during some detective.
As far as who the perpetrator was.
Correct.
Right, okay. Right, so
Some
that's,
detectives mentioned that they believe Mr. Chance is involved in other unsolved homicides, but
Right.
it's the same issue.
yeah, so that's granted.
And then he was arrested for resisting without violence during this case. I'm asking for that not to come up in this case.
Okay, he
He's
was
in
charged.
Jacksonville.
He was not charged with that, right?
Not in this indictment.
Okay. Okay, granted.
And I think number 2, you've previously ruled on, that's the,
Yes. So, same ruling. Paragraph 3. Well, I've already, I guess, in the context of Mr. Murphy's motion, I've already ruled, so that would be denied. Okay. And paragraph 4. Again, I'm at this point in time, I'm reserving ruling on the introduction of the rap videos until I know what the universe of proffered evidence is. So I'll reserve ruling as to paragraph 4.
I think you ruled on.
So then we've got the issue of Davion Murphy's alleged statement after the death of Charles Jones. That kind of goes into our severance issue, so I'm going to reserve ruling on that one, whether that would in fact be admissible against any of the other co-defendants if they were tried separately. Item number 6 has to do with the items found in Sean Gathwright's car. That will be denied. 7 would be the search of Sean Gathwright's home. That will be denied. Paragraph 8 would be the items found in Mr. Chance's residence. I think the state agreed to some
Yes, Your Honor.
correct? So it would be as previously ruled.
And then I think you wanted to see the picture of the Glock switch. And
Yeah, the notes.
Yes.
Yeah, I need to see that. So I can't even remember now. I think I granted some, reserve ruling on some. The clerk has my notes, so I can't remember. So as I previously ruled in the motion for that Mr. Gonzalez argued on behalf of Rashad Murphy. Okay, and then we've got the Glock 9mm and the firearm. I think the state agreed to that one, right? With regards to Mr. Chance?
Yes.
Okay, so that one's paragraph 9 is granted. Paragraph 10, the bully down poster, that's denied. 11, the notes, that's the one I've reserved ruling on.
That's an error, Judge. I put that twice.
That's fine.
Okay.
12,
So this goes to the history. This is
okay, that one is denied. 13 has to do with the social media post on November 19, 2023.
goes to allowing an expert to interpret the social media posts.
Okay, and I'm assuming, State, you're going to seek to introduce this?
Yes, Your Honor.
Okay, so that one's denied. 14, Cash App transaction.
This is both the transaction and describing what an expert believes the basis behind the transaction is. It's simply a transaction of Corey Rivers paying.
Right, this is for the Airbnb though, right?
Yes.
Okay, right. So,
Corey Rivers is not going to testify.
right. But I mean, the fact that the transaction occurred is admissible, you're just saying no one can opine what the reason was,
Correct, Your Honor.
right? State, you agree?
Judge, I agree, but it's certainly up to closing arguments.
Sure,
as
that's
to the
different.
amount. Yes.
We're just talking about the evidence. So the evidence, so 14 is granted as far as the evidence itself is admissible. I'm sorry, it's denied as to the evidence. It's granted as to any, the admissibility of the evidence is denied, but it's granted as to any opinion for why the transaction occurred. So denied in part, granted in part. Okay, 15.
You may have already ruled on this in general.
Yeah.
Just opining on phrases.
Unless it's being offered, unless the opinion is part of expert opinion, right?
Yes, Your Honor.
Okay. So I guess it's technically denied, but it only comes in through potentially expert opinion.
Yes, Your Honor.
Okay. Let me just make a note. All right, 16.
I don't think the state's intending to introduce these, but I don't want to speak for them.
Communications between Andrews and Chance.
Judge, we'd agreed at 16.
Okay, granted. And I think 17, same, no one's going to opine as to Mr. Chance's purported involvement in the October 7, 2023 shooting of Charles Jones. 18.
It's about from a space, conversation in spaces.
Okay. State what's your response to this one. Are you saying these are, what are these?
Judge, those are relevant, Judge, and we would object. That is the conversation that happens a couple of weeks right before a homicide where he is, and actually not only are the public watching this, but law enforcement is actually watching it and recording it, and that is when Charles Jones is having a conversation with our victim asking about his foot. The October 7th of 2023 attempted murder that is also tied ballistically to this case. The victim was indeed shot in his foot. So that is relevant, as well as, again, the co-defendants in this case. When that is happening, Sean Gathright is receiving a message from Rashad Murphy where there is dialogue concerned about this happening on X because they have bigger plans. So certainly that is relevant and probative to this homicide.
Okay, 18 is denied. 19.
Did I understand Mr. Howard's going to testify, and obviously he could testify,
Judge, I
but
think that was 18.
Yeah, 18 denied. We're moving on to 19.
we're just asking that he not be allowed to opine on what Mr. Chance meant by something Mr. Chance said to him, allegedly.
Okay, state what's your response.
Judge, we know that he could not comment on the defendant's state of mind, but certainly he can give his opinion as to their conversation that they were having.
Sure. So it's granted as to and Mr. Howard opining as to Mr. Chance's state of mind. Okay, 20. Again, this would seek to exclude Mr. Howard giving opinion testimony regarding social media posts allegedly made by Mr. Chance after the murder. State what's your response.
Hold on 1 second, Judge. Judge, we again are not going to ask him what Mr. Chance or the defendant, what he may have meant, but certainly he can testify as to seeing the post and the relevance and the effect on the listener, how it was pertinent to him.
Okay. So it's granted as to opinion testimony. Okay. You can again opine as to Mr. Chance's what it meant when Mr. Chance posted what he did. He can testify to the facts. Okay, and then 21, any allegation, mention, inference, or indication, whether through witness testimony, picture, or attorney statements to the jury regarding Mr. Chance being the mastermind. Is the state going to argue he's the mastermind?
Judge, I do think based on the evidence as well as, Judge, I do believe that is appropriate for closing argument as long as it's based on the evidence that we produced during the trial.
I would tell you
As far
something,
as
Alicia, don't
eliciting
push
that
it.
from a detective or anything of that nature,
No.
we certainly would not be doing
Okay,
that.
because the reason I ask is it did, in the motion, it specifically said attorney statements. So to me, that seems that you would want to prevent the state from even arguing that.
Yes, Judge, but I would agree that I'm more interested in not having the detectives or
Okay.
witnesses.
All right, it's granted as to any witnesses, and it's denied as to the state's closing, assuming they've got evidence to back up their argument.
Sure.
Okay, that's it for Mr. Chance's motion and limine. Okay, are there any other motions? I don't have a pile of anything left.
I think that is it.
Okay, all right, very good. I think we had 59 motions, so we made pretty good progress. Okay, so I think the last thing we need to do is wrap up, and I asked you all, I've taken the motion to sever under advisement, and so my kind of last thing I want to hear from you is now that we least have an idea as to the universe of evidence. What specific evidence you're going to argue on behalf of your client would be inadmissible if they were tried individually, sufficient to warrant a severance? Does anybody want to kick off?
I will, Judge.
Okay.
Judge, also, and I don't know the court's position on this. As you know, I filed a supplemental memorandum of law as it relates to severance issues. As I told the court that I would like to do last week when we finished with the severance argument, the state in turn responded to that. Is the court going to allow us to argue that as well?
You can.
Okay.
So, but
We can do this now, Judge, what the court asked.
Yeah, it's 2:37 in the afternoon. So if you wish to have further legal argument regarding the severance issue, that's fine. I would like you to first answer my question.
Certainly.
And then I'll give each of you 20 minutes to, in total. So it's 2:37. Mr. Gonzalez, you have the floor.
Judge, I did a filing, and essentially the items that I believe would be admissible, not admissible against Mr. Murphy and potentially is admissible about to other defendants. Number one, messages sent by Isaiah Chance to co-defendant Andrews, telling her that he needed to stay low and asked her to remain loyal. That was October 7th, 2023, the same day as the attempted murder of Charles Jones. And I expect Detective Nieder to testify that Mr. Chance and Mr. Gathright were suspects in that murder. I believe
Well,
that.
no, they're not going to testify to that. We've discussed that a couple of times now. No one's going to opine who the suspects are.
And whether or not it's admissible to Mr. Chance, I would suggest that if it is, it's not admissible to Mr. Murphy. Next would be Judge on.
Because why?
Because number one, it's outside the scope of the conspiratorial time frame. Number two, it's not relevant as it relates to Mr. Murphy. What Mr. Chance indicated to Miss Andrews about that particular incident. Well, even if it relates to that particular incident, we don't even know if that statement relates to that incident. That would be the state's theory of prosecution. But in any event, it certainly would be impactful. Would be a minimizing word as it relates to what the jury could, the road they could go down considering what effect it may have on Mr. Murphy.
Okay.
So,
all right, very good.
As it relates to two, that would be the recorded social media video where Mr. Chance is addressing Mr. Jones on X, saying, "Hey, Fulio, your foot okay, cuh? I got bigger fish to fry." Again, this, referring presumably, theory of prosecution, to the attempted murder on October 7th. It would be the same theory, the same reason for inadmissibility, may be admissible to Mr. Chance, and I believe not admissible to Mr. Murphy for the same reasons.
And that was that date also October 7th?
That date was June 6th of 2024.
Okay.
Next, Judge, would be all items, but specifically, and the court's already ruled them to be admissible in general, and that is shell casings that are, and all items for that matter, that are found in Mr. Gathright's vehicle at the time of the search on June 26, 2024. And again, all of these incidents, Judge, are post-conspiratorial, and ballistic comparison suggests that those casings match the October 7th attempted murder of Charles Jones. May impact Mr. Gathright, may impact Mr. Chance. Again, the same theory as it relates to the spillover, as to the thoughts that a jury may have as to Mr. Murphy's involvement, and I believe that would require severance. Same as it relates to all of the items on June 27th, post-conspiracy.
The physical evidence found.
Yes, items of physical evidence in both circumstances. 26th and 27th as it relates to Gathright's residence and Gathright's vehicle. Next, Judge. Chance's Instagram posts that he had to switch it up, coming different, all 2024, love you, brother. Tagged music by Charles Jones.
What is the date of that?
That is November 23rd, 2023. Pre-conspiratorial time frame. And tagging Antonio Tilley and Ghost 187 _. Detective Nieder, I believe, will testify that in his opinion, Chance was upset with ATK because they didn't get a get back for Tilley's murder in October of 2023, and that he had a falling out with ATK and was now associating with 1200. And then Detective Nieder opining that Ghost 187 is Rashad Murphy. Certainly potentially relevant and admissible as it relates to Chance, and under the same theories, in my estimation, and I believe based on the law, inadmissible as to Mr. Murphy. Next, Judge, and the court made some statements. It was not a ruling, but the court made some statements, as I understood it last week, with regard to celebratory statements made by Davion Murphy. Post-conspiratory, I'm coming home, my thirst is quenched, pop a bottle of Don Julio today. And although I don't believe the court made a formal ruling, my argument would be under the same theories and under the same time frame that those statements are post-conspiratorial in terms of the time frame. And although they may be admissible against Mr. Murphy, Davion, they should not be admissible against Mr. Rashad Murphy. Next, Judge, is categorized gang affiliation evidence. These next 1, 2, 3, 4, 5 incidents are, and I don't have any police reports on these things. I don't have any social media posts on any of these things. I don't have any pictures of any of these things. I don't have any videos of any of these things because they appear in Isaiah Chance's gang documentation FIR. So it is an evidence, and to the extent that the state would seek to introduce all of these varying pieces of evidence that I believe may be relevant to Isaiah Chance. Number one, to maybe segue into a gang certification or documentation, or as some type of inextricably intertwined evidence. I don't know under what theory, but the only thing I have, and it's very detailed as to its generalities, there are no actual documents that we have been provided because I don't know that they exist. This is the FIR regarding Mr. Chance. For all of those same theories, and the dates are March of 24, July of 23, February of 24, December of 23, March of 24, all in that same time frame, which certainly is all extensively pre-conspiracy. My arguments being the same, they may be relevant and admissible as it relates to Mr. Chance, not admissible in my view as to Mr. Murphy.
And did your supplemental or your amended identify these with specificity, this gang affiliation?
No, Judge,
evidence?
these would be in my filing, a notice of filing. I did an itemized list of evidence admissible against co-defendants, but not the defendant. You asked Judge Firth to orally give it to you.
Yeah.
I just put it in written form.
Okay.
So it'd be a little bit more particularized.
Okay.
Finally, Judge, two more issues. Again, the bully down poster that the court has admitted or determined not to exclude in limine. My position again and that would be inclusive of all the other items. The court's, declining to make it, a limited item and allowing it to be introduced. Certainly, it doesn't change the court's ruling, but it does change in my mind the ramifications as it relates to Mr. Murphy. And therefore, that bully down poster and the other items in Mr. Chance's residence, again, post-conspiracy, June 27th of 24. Although they are seized post-conspiracy, I assume the state's going to say they pertain to pre-conspiracy, not during conspiracy, but pre-conspiracy. And I would suggest again, potentially admissible as it relates to Mr. Chance, and I would tell the court not admissible as it relates to Mr. Murphy. Finally, Judge, there are Cash App records, and also Detective Ramos testified in his deposition about Mr. Chance. You heard about it a little bit earlier, that it's Mr. Chance's Cash App is rich on war. He's, he makes money killing people for the gang, and there are several entries to his Cash App. I don't recall whether they specifically reference transactions that the state is going to insinuate may be relevant to this or any other murder or shooting, but the records even in general, with his handle being Mr. Rich on War, again, these are pre-conspiratorial, and additionally, Detective Ramos suggesting he's the mastermind, he handles the gang war, and he is involved in ongoing violent gang activity. Again, I would suggest to the court under all of the same theories as it relates to relevance, as it relates to character, as it relates to pre and post conspiratorial timeframes, might be admissible against Mr. Chance. And I would suggest to the court they, for a number of reasons, not admissible as to Mr. Murphy, and certainly would be extremely, extremely prejudicial.
Okay. All right. Thank you. Okay.
Mr.
Snarty, on behalf of Davion Murphy, do you have any additional specific items of evidence that you contend would be inadmissible against Mr. Murphy if he were on trial alone?
In addition to those items that were already
Anything
identified.
other than Mr. Gonzalez just identified?
No, Your Honor, other than any of the social media posts do not involve Mr. Davion Murphy, and none of the rap videos involve Mr. Davion Murphy. We just incorporate all the other items identified as to Rashad Murphy that would not be admissible if Mr. Davion Murphy were tried individually.
Okay, very good. All right, Mr. Wise, on behalf of Mr. Gathright, any additional items, specific items of evidence that we've not already discussed?
Sort of, Your Honor. Again, I think Mr. Gathright is a little different in that he's not alleged to have been one of the gang members. So I think 5 of the 6 collateral incidents, I think, would not be admissible against him. Again, for two of those, he was a child when they transpired. But I think the only one that would have any relevance to him would be the alleged prior shooting of Charles Jones, and that's only because of the shell casings being found in the car. Otherwise, there's no connection whatsoever to him and the gangs. So I don't think really, the bulk of the evidence that we've been hearing about, including the communications with Mr. Chance about switching gangs, things like that, I don't see any of that being admissible against Mr. Gathright if he were to be tried separately, because he's not alleged to have been really even an associate of these gangs. The same thing with the rap videos. Other than that, I think it's really the same individual pieces of evidence that Mr. Gonzalez pointed out. Again, I recognize a lot of what he pointed out are things that do relate to Mr. Gathright, being the things that are found in the car. But
Well, you can get Gathright on a gang, but through Chance.
I don't believe do. The one thing that I don't know if was brought up, but it was subject of one of the motions limited just a moment ago, is the alleged consciousness of guilt of the other Mr. Murphy, which is something I don't think would be admissible against any of the other defendants if they were tried separately. And that being the allegation that he went to another jurisdiction or whatnot.
Okay.
Divide and conquer.
Very good. And
at each other, gonna have them.
okay, finally, as to Mr. Chance, Mr. Petratus,
I believe
any additional
a few of them are. That woman too, right?
I think Mr. Gonzalez spoke about Davion Murphy's post conspiracy statements. We would also add, we believe.
Anybody else would like to tell them she could give the jury an instruction?
Murphy, alleged threats he may have made in the history of Robert Howard being convicted of a crime involving a quote-unquote brother of Rashad Murphy. We haven't gotten into this yet, but the drill rap videos, none of which include Mr. Chance, we would argue, and then any historical gang.
They calling Isaiah the mastermind over 2 30-year-olds like that.
Chance is documented ATK, or that's the allegation. We would argue anything involving 1200 to be prejudicial.
okay. All right, State, Mrs. Murray, you gonna argue this?
I will try, Your Honor. If I can clarify, does the court wish for me to address the arguments now that were made by each of the defense counsels as it relates to the drill rap videos, or reserve that for when the court has the videos before it?
Yeah, just reserve for the time being on the drill rap videos, just until we know what actually is going to come in. So
yes, Your Honor.
So I guess I just need to know from you with regard to the identified items of evidence. What's the state's position as far as whether or not those would be admissible against all of these defendants if they were tried individually?
As stated by each of the defense counsels at this point, in its totality, the state's position is that as evidence of principle and as evidence in support of the conspiracy, all of the evidence would be admissible in trial against each of the defendants. Most specifically, because in establishing that one defendant committed this crime, the state would in fact be proving up that each of the co-defendants were in some way related to the offense. If they were gang members, we would still present evidence of that as the co-defendant being a gang member. We would still present each of the articles of evidence that have been listed. I'll go specifically for the court, but the overall position is that the evidence would still be admissible in each of these defendants' cases. So
let's start with the messages sent by Isaiah Chance to the co-defendant Alicia Andrews on or about October 7th of 2023. Would those be admissible against Mr. Davion Murphy, Rashad Murphy, or Sean Gathright if they went to trial individually?
Yes, Your Honor. So we would ask to submit those articles of evidence as evidence of motive in this case, because we have the ballistics evidence that links that earlier shooting to the subsequent homicide of Mr. Jones. We would ask for a limiting instruction in presenting that evidence, but we would certainly ask to admit that evidence in each of their trials.
Okay. I'm not sure. All right. And what about the recorded video where Isaiah Chance responded? I think it was dated June 6th of 2024, where he's responding to, is it Julio, who's he responding to?
Yes,
Georgia?
Your Honor. They're on Spaces. That's the one where verbally back and forth they are communicating with each other. Mr. Chance is posting on his social media accounts and is going back and forth with Mr. Jones. That, in addition to Sean Gathright and Rashad Murphy then discussing Sean Gathwright's boy going crazy on the internet on his social media accounts and telling him to calm down because they have bigger things to deal with. Absolutely, the state would be seeking to admit the evidence against each and every defendant, including Davion Murphy, given we've charged conspiracy in this case.
Okay. And then obviously the physical evidence that was found at Sean Gathwright's car at his residence.
Same argument that was previously made and seeking the same ruling from the court.
Okay. What about Isaiah Chance's Instagram post from November 23rd to 23? Why is that? Why would that come in against all the other co-defendants?
So that post is made a month after the earlier attempt on Mr. Jones's life. For the same reason that Mr. Chance and Mr. Gathright were linked to that offense. This is the same offense that we're discussing when Mr. Chance sends the messages to Miss Andrews in the same month about the earlier attempt on Mr. Jones's life. The law enforcement officers from Jacksonville will talk about how at the same time, it's not just Mr. Jones's life that was attempted at the October 7th date, but in the hours before Mr. Jones's life was taken, Mr. Tilley's life was taken. So the posts from Isaiah Chance then subsequent to that are about how he is transitioning from one gang over to the other because he is upset with how his current gang has represented or come forward in support of the death or homicide that occurred with Antonio Tilley. So when he posts this, he actually tags Ghost 187. At the time of Charles Jones and Antonio Tilley's homicide, Chance was associated with ATK. This is the detective's discussion or describing some of the detective's discussion about how he transitions from ATK to 1200 and how he tags Ghost 187, who we ultimately linked to Rashad Murphy, a 1200 member. So when law enforcement says we saw that he started posting with and he was in music videos with or whatever it was, that there was some relationship between ATK and 1200, this is just evidence of that. The defendant posts this to his social media account. It's actually a video with a
Isaiah Chance does.
Yes.
Okay, and then what's your argument regarding the post-conspiracy celebratory post by Davion Murphy? How is that admissible against the other co-defendants?
As it relates to Sean Gathright, it comes from Sean Gathwright's device. The timing of the post, or they're actually text messages that are immediately sent after the homicide itself. The argument from defense that it's definitely Davion Murphy is not one that the state also takes. Yes, investigators reached out to the recipients of those messages to try and ascertain whether it was Rashad Murphy, Davion Murphy, or Sean Gathright, because it comes from Mr. Gathwright's device. But the messages themselves or the contents of the messages are not being offered by the state for their truth. I have no idea if at the time Mr. Murphy or whomever sent the message was going home or had a thirst quenched. Instead, it goes to the identification of the suspects. It goes to the intent in this case, and it goes to knowledge. So we would have we would seek to introduce against each of the defendants in a trial these messages that come from Mr. Gathwright's device, but were signed Murph. There is no direct evidence for us to establish whether it was Davion Murphy or Rashad Murphy. The only thing that we have is investigators attempting to follow up with the persons who received the messages.
And that was on Mr. Gathwright's phone?
Correct, Your Honor.
Okay. Okay. Some of this I've already basically ruled on. The gang affiliation evidence as to Isaiah Chance, I'm assuming you would argue that you would seek to introduce that and if these gentlemen were tried individually, correct?
Yes, Your Honor.
The same with the bully down poster, correct?
Yes, Your Honor, same argument.
And the Cash App records for the rental of the Airbnb, right?
Same argument, yes, Your Honor.
And what about Robert Howard's testimony of threats made by Isaiah Chance?
You're looking for the Easter Bunny now.
I think Mr.
You don't know what's going on.
Howard's testimony were threats by
Rashad Murphy, if I'm not mistaken. I think that was Mr. Petridis' argument. Is that what you're referring to?
I think that's what he was referring to. Mr. Petridis was arguing.
I just want to make sure we're arguing the right thing. Okay, so yes, Mr. Howard did receive some phone calls or voicemails from Rashad Murphy leading up to the offense itself. Those are relevant to premeditation, motive, and intent in this case, and as it relates to all of the defendants. Mr. Chance is alleged by Robert Howard to have made similar calls, not threatening in any manner, but calls in advance of the offense itself in anticipation of the offense occurring or something occurring in Tampa. And that evidence, again, would be sought to be introduced given all of the defendants acted as a part of a conspiracy.
Okay, thank you. All right, so I'll start with you, Mr. Gonzalez. What is your response to the state's contention that Davion Murphy's celebratory post homicide of Mr. Jones would be admissible against your client, and that it's not hearsay because they're not trying to prove the truth of the matter, they're trying to prove identity?
Identity as to
who the perpetrators were.
Well, Judge, I can tell you that as I remember it, the two messages that went to two separate people. Although law enforcement was not able to talk to one of the two, they did speak to one of the two, and Detective Ramos says it was Davion Murphy. I spoke to that person, and that person indicated to me that it was Davion Murphy that sent her that post or sent her that message. I don't know details on that. I am referring to Detective Ramos's testimony, and in that light, and the fact that, as I believe it, Mr. Davion Murphy has been identified, and I think Detective Ramos will testify as such, at least to one of those two posts, that in and of itself, it would not be relevant and it would not be admissible as to Rashad Murphy. And simply to identify, okay, if it's going to identify anybody, it's going to identify Davion Murphy because that's what the person on the other end of it told Detective Ramos.
Davion, I'm like, why you keep saying my book?
My question as to its relevance as it relates to Mr. Rashad Murphy.
Okay, so I'm not so sure, as I indicated, I'm not sure about the celebratory post homicide, and I'm not sure about the message being sent by Isaiah Chance to Alicia Andrews after the October 7, 2023. I'm not sure. And I know I don't want to roll the dice in a death penalty case. So state, you just really need to think about this because I'm not sure about those two. They would be admissible against all of the defendants. I don't know.
Yes, Your Honor.
So,
Judge, I know that you said the Alicia Andrews and message to from Isaiah Chance. What was the second one? The post by Davion Murphy afterwards?
Mm-hmm.
Okay.
And Your Honor, I just want to confirm, I understand that in the motion from the defense, they're referred to as celebratory posts, but in confirming with the defense, Mr. Gonzalez is actually referencing the text messages from Mr. Gathrigh's device. Two sets of text messages, not posts, because there are posts.
Again, my literacy when it comes to.
Let me see them, please.
I've seen them, Judge. So. And Judge, I might take this one step further, is I believe that when Detective Ramos spoke to one of these ladies, she in fact knew Davion Murphy, but did not know Rashad Murphy, as I remember it. And I could be wrong. I don't think I am, but I think that inquiry was made of Detective Ramos in deposition.
Okay. as I indicated, I'm not sure. And I'm not really inclined to roll the dice in a death penalty case. Okay? So, state, it seems to me you're going to have to pick.
And you're referring to the text messages and the postings as well, or no?
No, it's just the post that was found on Sean Gathride's phone post homicide, and then the message from Isaiah Chance to Alicia Andrews on or about October 7th, telling her to stay low and be loyal. Okay.
Is the court making?
Why pick if one isn't admissible? If you don't know about either of them, why split?
Yes, I'm saying that I'm not sure that those would come in against. Well, I basically am. I'm telling the state they're going to have to kind of pick. So I don't, as I sit here right now, unless something changes my mind, I'm not sure that those two items of evidence would come in against all of the defendants. So the first one would come in potentially against Isaiah Chance regarding his conversation with Miss Andrews, and the item found on Sean Gathride's phone would conceivably come in against him. I'm not sure they would come in against the other co-defendants if they were tried individually. And even though it's not a brutal problem, does it become a other problem, meaning it somehow significantly impacts the defenses of the other co-defendants? And I don't know, but I'm being extremely cautious. Okay? So basically what I'm telling the state is if they really want this evidence to come in, then I would be inclined to sever. If not, then I wouldn't be. Okay? So.
Can I ask one follow-up in respect or in regards to that? If you are inclined to sever, would it be picking more than one jury at the same time or separate trials?
Well, that's a good question.
That's exactly what I was thinking. They about to do exactly what they did the case of.
Probably more than one jury.
Exactly. So y'all still gonna be at court at the same time. Still possibly going to court
So
on
it's
April
kind
13th.
of an open question mark at this point, but I'm not sure. Okay. So state, you want some time to think about it and let me know?
Yes.
Okay. All right. So how much time do you need to respond? You want to file something?
Yes.
Okay.
Judge, can we have we need to talk about it and
Sure.
Have till next week.
Okay. Sure. That's fine. To next Friday?
Yes, Judge.
All right. So you guys have until next Friday, the 13th, just to file something. If there's additional case law or additional argument you want me to consider, but you know my concerns.
Yes, yes, yes.
Okay. Okay. All right. I think that's it for today. We covered everything.
I want to put something on the record, Judge.
Sure.
Judge, I had previously asked the court whether or not I could argue the supplemental memorandum as it relates to severance. And that was mainly,
you go home
I
and be
argued
quiet.
extensively last week with regard to the grounds for severance, and the court has my motion that's whatever, 35 pages long. But, and that should be an amended. I hope the court has it amended.
Yes.
Okay.
Yes. An amended. Yes.
So Judge, essentially, I just want to say that at the conclusion of the severance hearing, the court didn't issue a ruling, still hasn't, obviously, taken it under advisement, but indicated a concern or a question to me as to whether or not pre and post conspiratorial evidence may be admissible against all defendants if the court determines that it's inextricably intertwined. And also asking, is there some case law or is there a position in the law as it relates to co-conspirator statements versus co-conspirator evidence?
Mm-hmm.
And I'm not going to argue the supplemental filing. I think it speaks for itself.
Okay.
It identifies case law. I will tell you, in my opinion, there's not much Florida state court law on it because I think it's a settled issue. There is some federal court law that I've cited to the court, and I know the state differs from me, and she has made that plainly clear in her response. But to the extent that that an act or a declaration should be separated and should be considered under different theories, I think is not the case.
Okay.
And so I would suggest to the court that for as long as I think we all should remember, the law clearly establishes that acts or statements of a co-conspirator are only admissible against another co-defendant if those acts or statements are made within furtherance of the underlying conspiracy. And I think that all evidence attributable to a co-defendant, but not attributable to Mr. Murphy, that especially falls outside that conspiratorial range. Because every one of the things we talked about that the court has considered, we are still in this post and pre, and we're also outside of that temporal range, and also discussing an act or a statement. And I think the memorandum sets out in my mind what is required, what the case law says, and how it establishes that the spillover prejudice that will exist, and despite any instruction from the court, by the way, despite any limiting instruction, the damage would be so significant that I don't believe a jury could compartmentalize in that particular circumstance. And as it relates to the state's response, Judge, I'm just going to say, generally, the crux of this issue is that the state, when it applies a co-conspirator rule to only hearsay, the rule has existed for decades before the hearsay rule was created, and it was never limited to statements. The hearsay rule merely codifies the existing law as it applies to hearsay. And other acts committed by the defendant may be admissible in conspiracy cases to show the evolution of the conspiracy. The key is that those should be acts by the defendant. It has never been applied that I'm aware of to a non-participating co-defendant. And that's just my response to the state's response, if you will. Thank you, Judge.
Okay, thank you. And the clerk just asked me, Rashad Murphy's fourth motion in limine, did we discuss that? I feel like we did, but maybe.
We did, Judge.
We did, Your Honor.
Hold on, I'm looking for it. The fifth, I have the third, where's the fourth?
It was a short motion concerning opinion evidence, and I cited the Bentley case.
Yeah. Yes. Yeah, there's the second the defendant, Rashad Murphy's second motion in limine.
No, Judge, you see number 13 on the sheet?
Yes.
That was a last minute, like one at the bottom, but we had already addressed the fourth one for the opinion. So
Okay.
I wasn't sure if we needed.
All I see is Rashad Murphy's fourth motion in limine. I thought have I not ruled on that
Yeah,
yet?
but that was a ruling on number, that was the same one. It was the opinion one, I thought, but then that was number 11. You see
Yeah.
number 11?
Yes.
Which is like the same motion, but.
Yeah. I think, yes, I think that's just a typo from the state and the state's master list.
Okay,
Yeah.
well, then I got it then.
Yeah,
I
yeah.
wasn't sure about that.
Okay, yeah, that's just a typo.
Okay.
So, and then I did, and if I didn't officially state it, Isaiah Chance's motion to adopt and conform applicable motions of all co-defendants, that's granted.
Okay, thank you.
Okay?
I got them all.
Okay. All right. Well, very good. I will take a look again at the updated case law that you've provided me, as well as the state's response. And then I will await clarification from the state regarding the items of evidence that I have a concern about. And then I will issue a ruling. Okay? Okay, I think we're done for today. All right, very good. Thank you.
Baby, she was trying to be done, wasn't she? She was trying to be done, okay? All right, guys. So that is it for today. So we are all caught up. Oh, no. Oh, it jumped over to Alicia when she's on stand. Damn. Okay. So for the most part, this whole idea of making Isaiah Chance the absolute mastermind, you mean to tell me that a teenager has the absolute wherewithal, Jedi mind trick mental capacity, if you will, to have two 30-year-old grown men go out there and do what they did to the extent that they did it while he's sitting in the car safe out the parking lot? Got them to get the Airbnb in their name and everything? I don't know about that. So what we'll do tomorrow they should be having another hearing, possibly the final motions hearing prior to court starting, if it will start on April 13th. Now, as we've heard, out of all 59 motions that have been going on, the biggest thing that the state is going to have to figure out is how bad do you want it? How bad do you want it? When it comes to those messages between Alicia and Isaiah, and when it comes to that celebratory post, is that the one with the football coach and somebody else afterwards I think that's might be what that one is, after a big game? But it's just like, do you really need those posts that bad to the point of severing? And it's no guarantee that severing is still going to keep all of them in the courtroom so they can be viewed together and just have two separate juries, which we saw that with the Queso and Scotty. Yeah. All right. So tomorrow we will try to catch we'll catch the final motions hearing, if it is the final motions hearing, because we need to figure out if this is going to be a severance based on the state's decision or what have you, because that hearing was about 2 weeks ago. So tomorrow will be the final motions hearing for Julio Fulio Part 2. And then Wednesday, I don't know that we have something, but I think there's another case starting either tomorrow or Wednesday. And then afterward, hold on. Then afterward on Thursday, we have the sentencing for Judy Church. What's that ice cream thing? Mm-hmm. Lord bless it. But we'll get to it. All right, y'all. So that'll be it for today. I will see y'all tomorrow. What y'all think the state gonna do? You think they gonna let go of that evidence? Let us